Can you let me know when she does that? Because I can't hear it. Should I just play the full Zimmerman thing?
Thank you, Your Honor. Lieutenant Zimmerman, I want to draw your attention back to the incident on May 25th of 2020.
Yes.
Earlier, you told the jurors about being at the scene, finishing your work there. The next day, did you have an opportunity to review some video of that incident?
Yes.
And do you recall what that video, where you saw it?
Yes.
And was it we've been calling the Darnella Frazier video?
Yes.
Did you watch that video in its entirety?
Yes, I did.
And since then, have you had an opportunity to watch other video of the incident?
Yes.
And specifically, have you watched body-worn camera video of the incident from the involved officers?
Yes.
And based on that and your years of training and experience with the Minneapolis Police Department, you saw then Officer Chauvin with his knee on Mr. Floyd's neck, correct?
Yes.
Would you call what you saw there a use of force?
Yes.
And did that use of force continue until the ambulance arrived?
Yes, it did.
Was there any change in the level of force being used until the ambulance arrived?
No.
And what do you think about that use of force during that time period?
I'm sorry?
What do you think about that use of force during that time period?
A little vague. Could you limit it to the time frame?
Right. Okay. So, based on your review of the body-worn camera videos of the incident,
Yes.
and directing your attention to that moment when Mr. Floyd is placed on the ground,
Yes.
what is your view of that use of force during that time period?
Totally unnecessary.
What do you mean?
Well, first of all, pulling him down to the ground, face down, and putting your knee on the neck for that amount of time is just uncalled for. I saw no reason why the officers felt they were in danger, if that's what they felt. And that's what they would have to feel to be able to use that kind of force.
So, in your opinion, should that restraint have stopped once he was handcuffed and prone on the ground?
Absolutely.
And I should add to that question then also that it appeared he had stopped resisting.
I'm sorry?
And it appeared that he had stopped putting up any resistance.
Absolutely, I would stop.
I have nothing further, Your Honor.
Mr. Nelson.
I may just have a moment, Your Honor. Good morning, Lieutenant Zimmerman.
Good morning.
Thank you for being here today.
You're welcome.
So you testified that you have been a Minneapolis police officer since June 5th, 1985, correct?
1985, yes.
And prior to that, you were with another agency?
Yes.
And when you initially came on to the Minneapolis Police Department, you were a patrol officer, correct?
Yes.
You were a patrol officer from 1985 to approximately 1993 when you took the sergeant's exam and were promoted.
Yes,
And so it's fair to say that since 1993, so 27, 28 years, you've not been on patrol in the city of Minneapolis.
correct.
Your assignments have been investigative in nature, correct?
Yes,
And generally speaking, an investigative role is more of a follow-up type role, right?
yes,
So an incident occurs on the street, it gets assigned to a detective, and then your job is to investigate the circumstances of that incident, right?
yes,
And so it's fair to say that since 1993, you've not, other than perhaps for ceremonial reasons, you've not worn a uniform on a daily basis.
Well, I don't know if I would call it ceremonial.
Well,
I
I
have
mean,
to wear a uniform.
you have to wear a uniform from time to time, but your daily role is as a clothed police officer, correct?
Yes,
And you're not out patrolling the streets, making arrests, things of that nature.
no,
All right. And it's fair to say then that your experience with the use of force of late has been primarily through training.
through what?
Your training.
Yes,
All right. Meaning you're not out actively, other than perhaps arresting a homicide suspect, you're not out actively patrolling and arresting people for less serious.
This morning, let's take this live right now.
Primarily of Officers Lane and King giving their side of the story, so to speak. It does not fall into any of the 804 exceptions for an unavailable witness to allow his hearsay. And I do not find that it was an adoptive admission by the defendant. He is there, but mere presence at a hearsay statement does not constitute an adoption of what is being said. Accordingly, the 2485 video will not be allowed.
Conversation, would those be allowed?
There were matters after the conversation, which specifically, Mr. Nelson. Why don't you go up here so we can go over that.
Again, specifically, Your Honor, after that commentary, there's additional conversation amongst the officers about who's going where, what's happening, who's going to the hospital, who's...
Any objection to that, Mr. Frank? Again, it's not really offered for the truth of the matter asserted. It doesn't seem just decisions on why some people went and why some people did not. All right, we'll allow that. Make sure it's tightly edited so that recollections that are being reported out about what happened with Mr. Floyd are not in there. All right, I think that takes care of that. We have, the jury is here, so I think we can bring them in. Just for the record, the next hearing is going to be on the record with spectators present, but we are going to go off audio and off video, so it will not be broadcast outside this courtroom. I think, and I'll make a record as to why we're doing that when we bring the jury in. I'll make a record as to why we're doing that when we bring the jury in.
Hey, and welcome back to day 6 of the Derek Chauvin trial. What you're seeing right now this morning, we have lawyers and the judges that have been in chambers all morning discussing some motions, doing some of that court housekeeping. They just came out right now to go on the record to talk about a piece of video that the judge is going to allow into evidence for the defense. And now they are going back, taking another short break. But you heard Judge Cahill there say that the jury is here and he's going to be bringing them in shortly. On this Monday, we are expecting Minneapolis Police Chief Arradondo to take the stand today. So we're really curious to see what he's going to talk about and what he's going to be allowed to talk about. We know that during jury selection, there were some motions filed by the state to limit some of the details that the chief will be able to talk about surrounding his decision to fire Derek Chauvin from the police force last summer. Specifically, the state wants kept out the fact that he consulted with black faith leaders before that firing. So we'll be really curious to see how much detail the chief is able to share about that decision. We're also curious to see, how far he will go in sharing his opinions of what happened. We saw on Friday, Lieutenant Zimmerman, he was at the time one of the highest ranking officers in the Minneapolis Police Department, get pretty candid of his opinions of what he thought was acceptable or not acceptable about Derek Chauvin's actions back on May 25th, 2020. So we're very curious to see if the chief will be sharing any of those kinds of opinions, where he'll be limited in his testimony of what he can talk about. And we'll also be curious to see, we're expecting the chief to talk a lot about the training that his officers receive and the expectations that they have out in the field. So again, we are expecting the chief to take the stand sometime this morning. Again, really just curious about what he'll be able to talk about. Of course, there's always rules we're learning here in court of what witnesses can talk about, how far they can go, what details they can touch on. The judge really does like to keep answers to yes or no when answering questions. But of course, we've seen, many jurors talking more details, giving more opinions, some of them even being stopped by the judge for sometimes going too far. So again, Tom, we're expecting the chief sometime this morning to take the stand. You heard Judge Cahill say that in the next few minutes, they're going to be bringing the jury inside for day 6 of the trial.
Last week there was a lot of emotional testimony as to what they were hoping to show the jury as to what happened on that day on May 25th. We know this week we'll turn to more of the experts, and one of the experts taking the stand, as we know, is Chief Arradondo. We have Ryan Pasiga on retainer for us during the trial, talking about what the case, how it's shaking out, what we expect today, and how much do we expect to hear from Chief Arradondo on the stand today. We know he fired Chauvin and the 3 other officers the day after the incident. So how much can he actually say on the witness stand?
Well, I think that's what we're waiting to hear, the judge talk about and give us some final rulings on that. Here's the deal. You don't want a jury confused on what the issues are in the case or what the standards of proof are. And the risk here is that the jury confuses the issue with what's taken to terminate somebody's employment versus what standard of proof or how that interacts with someone's guilt or innocence or not proven guilty in a trial. And so I suspect there's going to be quite a bit of a battle between the lawyers. The prosecution is going to want to push as far as it can to get the chief to say, this is not what we allow our officers to do. This is not how we train them. This is not what the Minneapolis Police Force stands for, and have the police force separate itself as much as it can from Mr. Chauvin's actions that day. On the other hand, of course, I think the defense is going to probably paint this as a degree of jumping to conclusions and not.
Ryan, we need to stop short there because it sounds like the court proceedings are starting once again. Thanks for your insight. We'll take you now.
But first of all, I need everybody to raise your right hand. Do you swear or affirm?
minute or so, and maybe less than that. But you can see that right now, at least the live feed from the courtroom shows us the seal, and they are not, at least right now, starting that process. So, Ryan, let's go back to you. And I'm sorry, finish your thought there. I apologize, we had to cut you off.
You know, on the other hand, I think that the defense may, to a degree, want to say, listen, you jumped right out in front of this, and what were you doing consulting with members of the community about whether you should terminate somebody's employment? You either terminate it because it's a terminable offense, or it's not, and why are you letting members of the community weigh into whether someone's employment ought to be terminated or not? So to begin to perhaps paint a picture of this being unfair to Chauvin, to people perhaps jumping to conclusions without knowing all of the facts. And maybe that's the defense theme kind of going forward as well. As, look, I think this case is all about what are the experts going to say, all right? And perhaps Chauvin's lawyer is going to say, listen, everybody saw the video and everybody thought they knew what happened. But the reason that medical experts are so important is because they have access to testing within the body and other data that none of the rest of us can see. And we all know from time to time, our eyes can deceive us. And so perhaps the idea is everybody's thinking that this went one way, but when we hear from the medical experts, we're going to learn a lot more, and there's reasonable doubt. And maybe that's where the defense is going with this.
We know the chief in the days after this incident at 38th in Chicago called this murder. How damaging is that for the defense, and will this be something the prosecution plays up today?
Well, I do suspect the prosecution will indeed play that up. I mean, it's very powerful if you've got the chief of your own. The law enforcement is known to a degree to circle the wagons, of course. I mean, they're there for each other. They've got their lives on the line. It's a tough job. And so they understand each other. They protect one another most of the time. And so if you've got a chief of your own department saying this is murder and condemning the actions of Chauvin that day, that's very powerful testimony, of course. With respect to the defense, though, again, you might even say, listen, this hasn't been fair to Chauvin. And again, everybody's condemning him and looking at the video, but we haven't heard from Chauvin explaining what happened here. We didn't get a chance yet to look at the medical testimony and the medical opinions here, to which, of course, I think there's going to be some differing opinions here. And that's what the defense needs, is reasonable doubt. So while it's powerful, there are ways to cross-examine the chief and still hold alive the idea of reasonable doubt, depending on how Nelson handles that.
It does sound like the defense will trump up, and they already have kind of led to this, that the medical side, the medical issues that George Floyd had was the reason they believe that he perished on that day. They also talked about large crowds. What do you think about that in their defense, and how that works in their favor, or maybe not in their favor?
Yeah, you know, again, so what we always got to preface this, right? No matter what I think or anybody else thinks, the 12 jurors that are here to decide the facts of this case and whether there's reasonable doubt or not, it really matters what they think. For me, when that argument was made in opening statements, as a lawyer, you have or not credibility with a jury, and what you say in opening statements goes a long way at the end of the trial to whether you were credible with them or not. And I think there's some strain there because when I saw that crowd in the context of the opening argument about them as an angry mob or the like, right, or growing more hostile, I saw them as a compassionate crowd that was very concerned for another human being. And yeah, there were some words like bum and things like that, but they didn't keep rushing these officers. They stepped off the curb once and would step back. And the idea that they're distracting the officer, for me, didn't go well, and here's why. They're saying, you're on his neck, he can't breathe, get off of him. If you're distracted, they're calling your attention to the very thing that they want you to focus on. And I don't think they were distracting him. I think they were trying to get him to focus on what they saw to be the big problem.
But I'm sorry, Ryan, we're going to have to cut you short. We're going to take proceedings now with Judge Peter Cahill in day 6 of testimony.
Yes, Your Honor, just for the record, last Thursday we had a hearing with Sergeant Pluger outside of the presence of the jury for an offer of proof to note an objection as to Sergeant Pluger's assessment of the use of force in this particular case. I made those Friday morning in chambers during a chambers discussion. I made those same objections with reference to the motion in limine that had been filed prior to trial to prevent every single officer from coming in and giving their 2 cents as to the reasonableness of the use of force. I made those same objections to Lieutenant Zimmerman's testimony, and I just wanted the record to be clear that that objection continued for that testimony as well.
Given their involvement with the case, Sergeant Pluger and Lieutenant Zimmerman, I did allow the state to elicit, and based on their training and experience, I did allow them for the limited opinion that the amount of restraint was, I think Lieutenant Zimmerman said uncalled for, but that it was not appropriate, and so I denied the defense motion to suppress those opinions.
And I would just only note today, Your Honor, because we have at least 3 officers that are coming in to testify. I understand that Chief Arradondo will be testifying today, and I understand that the court is permitting that per policy and his policy decision makings for employment purposes. However, there are 2 other officers that are in the train. One is the commander, Katie Blackwell, who's in charge or oversees the training. I would note that, again, she has opinions, as well as Sergeant Kerr Yang, who is in charge of the crisis intervention program. Again, now I'm concerned that what's going to happen is we're going to, and then we have use of force experts that are coming in. So I'm concerned that the state is pigeonholing expert testimony in through these officers, where I think that these officers should be just allowed to testify. These are our training materials. These are our training policies. These are what we do. So.
And I am allowing the chief's testimony that the use of force was contrary to policy. It's Lieutenant Blackwell. That opinion, Inspector Blackwell. I'm allowing that opinion, but why Kerr Yang are we crisis intervention? Are we trying to get in Mr. Floyd's state of mind through the back door here?
No, Your Honor. The proffered testimony of Sergeant Kerr Yang will just be regarding Minneapolis Police Department's crisis intervention training that they provide to officers. It's a 40-hour scenario-based training course in which paid actors come in and they go through various scenarios such that officers would be able to recognize people who are emotionally and behaviorally disturbed, and to be able to understand that some people are unable to comply with commands rather than being unwilling to comply with commands, and all goes to the reasonableness of the police officer and the actions that they take.
So Sergeant Yang is not offering any opinions per se?
He is not. He's only going to be describing the training.
And you have evidence that Mr. Chauvin took that training?
Yes, Your Honor.
Mr. Nelson?
Your Honor, that was my understanding of Sergeant Yang's testimony. It was limited to the crisis intervention program and training that officers go through. It is within the policy, that part of the de-escalation policy and things of that. And so what it would also include would be what officers are specifically trained to do to identify the difference between someone who is willfully resisting or intentionally resisting arrest versus someone who's having an emotional problem.
So just so I'm clear, there's not going to be any video shown and Sergeant Yang opining on whether this person was emotionally distressed?
That's correct, Your Honor.
All right, if it's simply a summary of the training that's provided and that Mr. Chauvin, his personnel record shows that he took that training, that's fine. Anything beyond that, including videos or opinions, I'm not going to allow.
And so, Judge, I just want to, I think this touches on something that was technically reserved during motions in limine, was the issue of which training materials would be admitted, because Ms. Blackwell, Inspector Blackwell, both parties intend to introduce training records that the Minneapolis Police Department has prepared. Both sides have intended to introduce those. There has not been a kind of a determination, I think, as to does the state or the defense need to specifically prove that Officer Chauvin experienced that direct training, or is this just the general policies and training materials of the Minneapolis Police Department? And that's what we had tried to work out, and it's not that we haven't. I just think the conversation got on the back burner.
Well, I'll just give you my thoughts and see if this answers any questions you have about it. My analysis of this is, we have said Mr. Floyd's state of mind is not relevant. It's the defendant's state of mind, his knowledge and his intent. And part of his knowledge is based on training he's received. So a summary of the crisis intervention training he has received is appropriate. We're not getting into, I suppressed the psychiatrist's testimony about what was Mr. Floyd's, was that truly anxiety or whatever. I'm not going to let a trainer say, look at the video and give those kind of answers. But evidence regarding what Mr. Chauvin knew, what he had been trained on, which goes to intent and knowledge on the May 25th, 2020, are all relevant and would be allowed. So I guess what am I missing here, Mr. Nelson, that still needs to be clarified?
Well, I think we get into some problems is in terms of how a connection between had Mr. Chauvin actually gone through this specific PowerPoint presentation, right? So the way that and this goes to how the disclosures were initially given to me, and then how they were subsequently.
Why don't you switch places here?
Thank you, Your Honor. So it gets into certain issues. So Officer Chauvin, a 19-year veteran with the Minneapolis Police Department, has completed 844 some odd hours of training. As the court is aware from our continuing education, I go on the CLE and I report I attended this all-day-long seminar, but within that all-day-long seminar, there's 5 to 6, 7 different presentations. I think that that's ultimately what we see here is we look at Mr. Chauvin's what are called workforce director training records, and it says he attended the 2020 use of force phase 1 defensive tactics presentation. Now, what does that consist of has been virtually impossible to reconstruct, and it goes to primarily how it was originally disclosed to the defense, how it was disclosed from the police department to the BCA, from the BCA to the defense, and then that formed the basis of my earlier motion and earlier proceedings to get a copy of that BCA drive. So when I originally received these training materials, for example, these training materials are 20 to 30,000 pages in PDF format, and you can look at some PDF of a PowerPoint presentation, and it says use of force academy, whatever the topic is. No frame of reference as to when this was given, who, there's no title, there's no dates, there's no information, who taught this course, who attended this course. And some of that information contains very important statements on the part of the Minneapolis Police Department. When I receive the BCA drive much later, and I look at them in their native formats, the reason I wasn't seeing the titles of these presentations or the dates of these presentations is because that's how they were saved on the drive. So it would say 2018 Phase 1 Defensive Tactics, right? So you know that this is now the training material from 2018. From the defensive tactics course, or it will say 2018 crisis intervention training, whatever, 2018 human factors of force training. So the dates and titles of these courses were given on that drive. Now again, you can look and you can see in his workforce director training or his workforce director program that he got credits for this 8-hour day. But again, which presentations were given on that particular day, you can't, there's literally no way to put this together, and I don't think that the state would disagree with that.
Well, let's see if they do. Mr. Slisher, Can you tie a specific training module to the date that Mr. Chauvin actually attended?
Your Honor, what we can do is first show the workforce director training, which memorializes what particular trainings, in-service trainings, the defendant has attended, and the titles of those different trainings.
Okay.
Then what we can do is have the trainer specifically talk about the materials and curriculum that they've developed for those blocks of training. And
For those dates.
on those dates for that. So, for example, if it's going to be the fall in service, there was a PowerPoint presentation that was developed from the curriculum from that fall in service, and they can say that that PowerPoint training was in fact presented. And these materials, they get recycled from year to year. There's nothing markedly different, in my view, from one to the other. They cover the same generalized concepts. And so, from a foundational standpoint, I think it's pretty clear that the training, the content, was imparted on, in this particular class, and that the defendant attended that class.
Well, it seems that a necessary foundation, I think you'd agree, would be this is the training provided on this date that the defendant's records show he attended. Even if it's embedded with 8 hours of other training, I think that would make it relevant. If you have training, but you cannot connect it to a training that Mr. Chauvin was at, it's hard to say then that you've laid the foundation for it. But it sounds like you've got the foundation. Am I correct?
Yeah, I think it's pretty clear, Your Honor.
As far as the other issues Mr. Nelson's identified, that seems to be more weight. It goes to weight, and you can cross-examine on it and say, this was a 3-slide PowerPoint in the midst of 8 hours of training on other topics. And that's pure, absolutely fine because it goes to the weight, the evidence, as opposed to its admissibility. All right, Mr. Nelson, one last comment?
Yeah, I guess, Your Honor, I'm not objecting to the admissibility of this training. The question becomes, I think, and I don't think that it's as easy as as it's presented. It's because even some of the things that they've said that they intended to introduce, which are that are clearly from the academy, from the police academy, they're not from in-service records, but it contains the information that may have been a part of some other training. That's where we. So, case in point, there's a PowerPoint presentation from the Minneapolis Police Academy about nerve manipulation and basically joint manipulation, nerve endings, and how to gain compliance through pressing or depressing someone's nerves. It's clearly a training material from the police academy from 2017 or 2018. Officer Chauvin was not in the police academy in 2018, but ultimately it's part of their training. Now, where did that come from? When was it presented to him? I don't know, and I don't think it could ever. There is no other record of that type of training. So there are training materials. I think there's 2 levels. If the Minneapolis Police Department comes in and says, we never train our officers to do X, right, and insert X, but there are training materials that contradict that testimony, that undermine that testimony. I'm not questioning the foundation for these records. These records exist. They all came from the Minneapolis Police Department. But whether or not I need to show that Mr. Chauvin had that specific training, I think is one question.
Well, let me stop you there. It seems like there are 2 levels here, and I think the foundation for any of this training material is, at one level, if it's certain training, defendant has been exposed to, he's been part of that training, so he has certain knowledge based on that training, that certainly seems admissible. If it's training that was provided by MPD, but there's no indication Mr. Chauvin took it, or this is not the version that he was trained on, that does not seem relevant at all. The only way I could see training that he had not attended, which might be relevant, is to impeach, for example, and I don't know if this is true or not. I just note that Lieutenant Zimmerman said in his 40 years roughly on the Minneapolis Police Department. He had use of force training every year. He was never trained to do X. And if you have use of force training that impeaches that statement, I think that's appropriate impeachment. But aside from that, I don't see why testimony that the defendant has not been a part of should be admissible at all.
And that was kind of the concern that I had and had raised in terms of why I thought it was important that each side identify those training materials that needed to be or were intended to be introduced. Because again, I agree with the court's analysis. It's an impeachment question on one hand. If as Lieutenant Zimmerman says, we were never trained to put our knees on the neck, but there's a Minneapolis Police Department policy that says otherwise, and there's ample training materials that would contradict that statement. That's impeachment of testimony, and certainly should be admissible for those purposes. Now,
yeah, had he not said that, for example, I don't think it would be admissible, because again, this is training that the defendant didn't have, and unless you can show he had that training, it's not admissible from either side.
And I think that goes to sort of some of the problems why I raised you can't have every single officer come in and say this was or wasn't a reasonable use of force, because the training he had may be different than the training that Zimmerman had.
Right. And so we've got so far opinions from Sergeant Pluger and from Lieutenant Zimmerman on use of force. We're going to hear from the commander or the then commander of the training unit about it. Beyond that, I think we have an expert witness from the state and an expert witness from the defense. Is that correct?
Two expert witnesses from the state on use of force.
All right. We are getting to the point of being cumulative. We're not asking every officer because that's cumulative, but also even having two seems like it might be cumulative, but I'll deal with that later. It just seems like we said early on in the motions in limine, you're not going to be able to ask every officer what would you have done differently, and we're not going to go through that. I've given you pretty good leeway that the sergeant who was involved in the case and the lieutenant who was involved in the case, a lieutenant who's been a peace officer for roughly 40 years, gave his opinion. Now you're going to have the training unit and the two experts. That's it. We're done with it, with asking other officers about the use of force. And Sergeant Yang, you can ask about what the training is on crisis intervention if the defendant had that training.
And so this is where, again, I don't know if the state is intending to call so Inspector Blackwell, she's the kind of the top dog in the training unit, but then there are the actual use of force instructors, right? It's the people who teach these trainings, and at least two of whom have been repeatedly interviewed by the state. I don't know if they're intending to call the actual trainers as well, which just puts, like, if Commander Blackwell, she's not teaching, as far as I can tell, these classes. She's not the one administering them, but she's maintaining the record, she's maintaining the training. She's a foundational witness to get these records in. I would have expected the state to introduce the actual training people, but maybe that's not what they intend to do.
Is the state intending on asking Inspector Blackwell for an opinion regarding the use of force in this case?
No, Your Honor. The state is going to be calling Inspector Blackwell to describe the training facility, the curriculum, how it's developed, how it's set up, how it's administered. She will offer the opinion, I guess it's not an opinion, it's a fact, that MPD does not train its officers to place a knee on a subject's neck and restrain them in that position for as long as happened. And she'll do that, but mainly go through the records and describe the curriculum in the facility and the trainers, how it's staffed, and then the individual trainers will impart the knowledge from the various disciplines. We have Carrie Yang, who we mentioned, on crisis intervention and procedural justice training. We have the use of force trainer, probably Johnny Mersel. I don't know that I need to have both Mersel and Schoonover testify on the defensive tactics side of it. And then the medical training that the officers receive from Officer McKenzie. And those are our trainers. And then we'll go into more of a practitioner level expert, Jody Steger, and then at some later time, the academic expert will testify, but not immediately.
Yeah, my main concern, obviously, the medical training they received. So again, what did Mr. Chauvin know? What it was his training? What was his experience up to that date? All relevant. When we start getting into the opinions, how many use of force opinions do we have? It's cumulative, I think, possibly already. But I think as you go through each of those, it's got to be talking about training that the defendant received. Not just, here's trainings we had. Because if he didn't take the training, it doesn't go to his intent or knowledge.
Understood, Your Honor. The workforce records specify what
Right.
in-service training the defendant has attended, and then we have the curriculum, the materials that were presented, during those training blocks.
And crisis intervention training seems to be relevant to this case. Use of force training is relevant to this case. Medical training is relevant to this case. So all those summaries of the training that the defendant received, according to his records and what the curriculum is, that's, I think, all admissible. I think when we start getting into opinions about use of force, I think we should visit about that before we start blurting out opinions. We've already had several, and I think we need to go tread carefully because of whether their opinion is something that is the appropriate topic even for expert testimony, because some of this stuff is within the jury's knowledge and they should be able to do without an expert. So, but I think let's just kind of go with that for
Your
now.
Honor, if I may, just as to the cumulative discussion, just to add to that, foreseeing Mr. Nelson being an able defense attorney, I would anticipate if I were to just simply try to prove my case with experts, he would say, the state hired some experts to say this was unreasonable, but what do the people who actually do the work say?
Well,
right?
and I think we've gotten 2 of those already.
And that's the reason. I'm just, I need to cover the appropriateness of the use of force really from every angle to give the full picture of the reasonable officer. I understand at some point enough is enough.
Well, let me be a little more clear. I think you have the right to somebody who's actually done the defensive tactics, use of force training, whatever, to give their opinion about this case. But not everybody, not every trainer. You can take one who's done the training, knows the curriculum that Mr. Chauvin actually participated in, and give an opinion there. But I think then we're done with the MPD people who can give an opinion regarding defensive tactics and use of force. So, does that make a little more sense?
It does, Your Honor. I think that was my plan.
Okay, good. Always good to have a plan that's consistent with the court's rulings.
And I guess the court will let me know if you feel I'm
Yeah, let's just go sidebar if we have to in the
Yes.
midst of all this, because as we know, everything's fluid. So, all right, we'll get the jury.
It looks like they're taking another recess there in court before the testimony starts up again. The jury is brought in. Motions hearing is what was going on this morning, allowing video to be part of testimony, and also this use of force and whether training would be allowed as far as Chauvin's training as a police officer, what he received as far as his training, what he did not receive is at issue. But you could hear what the judge was ruling on there, Judge Peter Cahill. Let's bring in our legal expert, Ryan Pasiga. What's your takeaway from that as far as, is it a win for, in this case, the state, or is this somehow going to help the defense?
I think it's going to help the defense some. So we have the judge reining the prosecution in to a degree to make sure that we don't have a runaway testimony situation where all these opinions are layered upon one another, both in terms of being cumulative, which means we're hearing the same thing over and over, and at some point it just gets too prejudicial. and as well as the degree that people saying how much Chauvin knew in his training or not. So the judge is trying to rein the prosecution in and make sure it doesn't become unfair for the defense.
Right. We've already heard testimony from a couple of the police officers, senior police officers last week, alluding to some of this. And it sounds like the judge, if I'm hearing this correctly, Ryan, will allow one more officer to talk about the training he had and how he applied that training.
That's correct. I think this is going to get very clunky. You know, we have this in trials all the time outside of the presence of the jury. But you have a situation where even the prosecutor is saying, Judge, I guess you'll let me know if I'm going a little too far. And of course, the prosecution's opinion about what's going too far versus what a defense lawyer's opinion about what's going too far are often two different things. So I expect we're going to see a lot of breaks even during this testimony and what the judge is calling sidebars, where the lawyers are going to stop the questioning, put on their headsets, and be speaking privately with the judge, because this is going to get to be a little bit of a tug of war. Where's that line drawn in the sand? And each side wants to move that line to their advantage here.
And did it almost sound to you from defense attorney Eric Nelson that they're contending that, yes, Chauvin had training, but they can't pinpoint exactly what type of training he had and on what day and who the specific trainer was, and that will be part of his defense?
That's right. I mean, basically, he got a big data dump from the state in terms of the training records, both at the academy and then within the police department for ongoing training that they have. And I think what he's saying is there's a problem here, because some of these records aren't saying this was only academy training, this is on the job training and continuing education training, and we are not necessarily able to match up. You did this training on July 1st of 2019. Was Chauvin there at that training or not? Did you make these PowerPoints after that? You got 3 sets of PowerPoints on this thing. Which one was presented at the specific training that Chauvin was at? And he's worried, of course, that some officer might come in and say, we're trained on this. And maybe Chauvin's telling him, that's not the training that I got. What Eric Nelson is really worried about is the last thing he wants to have to do is put his client on the stand to at least prove up this. If he doesn't want to put his client on the stand in the trial, and then they're trying to shove these records, they're kind of forcing the defendant to some degree to maybe take the stand to say, that's not the training that I got on that day. And he's really worried about that. So he wants to make sure these records don't come in to the degree that they're different than what his client is telling.
We're going to have to cut it off there. Thank you for your thoughts on that, and we'll take you to the proceedings right now live to the courtroom.
Behind the chair. Raise your right hand. You swear or affirm on the penalty of perjury. And before you begin, a couple things. If you feel comfortable taking the mask off, we'd prefer you do that, but sure. As a doctor, I can tell you I've had both my shots. That helps. But we'd like you to state your full name, spelling each of your name.
Sure. So Dr. Bradford Wankede Langenfeld, Bradford, Wankhedlangenfeld.
Mr. Blackwell.
And we can just call you Dr. Langenfeld.
That's fine.
Dr. Langenfeld, did you provide emergency care to the body, to George Floyd, after he was taken to Hennepin County on the evening of May 25th?
I did.
Just by way of introduction, are you the physician who officially pronounced him dead that night?
That is correct, yes.
Were you one of the physicians who tried to save his life?
Sustained.
Did you administer care to George Floyd on May 25th, 2020?
Yes.
What were you trying to do?
We were trying to resuscitate Mr. Floyd.
To save his life?
Correct.
So why don't we learn a little bit about your background, Dr. Langenfeld. Where are you currently employed?
Currently I'm working at Grand Itasca Clinic and Hospital. It's up in Grand Rapids, Minnesota. It's my primary practice. And I also work in Waconia, Minnesota at Ridgeview Medical Center.
And Waconia is in Carver County here?
That's correct.
Grand Rapids is several hours driving away from here.
That's correct.
Why Grand Rapids?
I was born there. It's my hometown.
It's also the hometown of Judy Garland, isn't it?
It is, yes.
Are you licensed in emergency medicine?
I have a Minnesota State medical license and I practice emergency medicine.
Would you tell the ladies and gentlemen of the jury what is emergency medicine as a practice for a doctor?
It's a very broad practice, but primarily involves taking care of patients suffering from critical ailments. Oh, sure. Critical ailments such as strokes, heart attacks, car accidents, other emergencies such as that, but also less emergent conditions, sore throats, urinary tract infections, things like that.
When were you first licensed?
May of 2020.
Would you tell the ladies and gentlemen of the jury a little bit about your educational background?
So I attended medical school at the University of Minnesota Twin Cities and then residency training at Hennepin County Medical Center.
And when did you finish your residency then?
Last summer.
Have you ever had any occasion to testify in a court before?
No, I have not.
This is the first time.
That's correct.
Let's go to Monday, May 25th, 2020, last year, Memorial Day. Do you recall whether you were working that evening?
I was, yes.
Where were you?
I was in the emergency department.
At the Hennepin County Medical Center?
That's correct.
And what was your position or title there?
I was one of the senior residents. We're involved with direct patient care, including both critical care and overseeing some of the junior residents.
Do you recall what time your shift began and ended?
It began at about 1 p.m. that day and ended at approximately 11 p.m.
And as a senior resident, what was your role?
My role was primarily direct patient care. I work underneath attending physicians as a resident.
Did you also oversee any other residents?
Yes.
Which residents would you have overseen?
More junior residents earlier in their residency training.
Now, in terms of was care administered to George Floyd on May 25th by yourself?
Yes.
Yeah. Who was the person primarily responsible then for George Floyd's care in the Hennepin County Medical Center Emergency Department?
I provided the majority of direct patient care under supervision of Dr. Ashley Strobel, who was my attending physician at the time.
Were you the primary decision maker?
I was.
Were you the person responsible for much of the direct patient care?
Yes.
When Mr. Floyd's when Mr. Floyd was brought in, would you describe it as an emergency situation?
Yes, absolutely.
What was his condition in terms of his cardiac condition?
He was in cardiac arrest.
And does cardiac arrest mean that he had had a heart attack, or what does that mean?
Not necessarily.
What does cardiac arrest technically mean?
Cardiac arrest is defined as sudden cessation of blood flow to all the tissues of the body when the heart stops pumping, typically as evidenced by absence of a carotid pulse.
So in lay people's terms, if we were to say cardiac arrest means the heart stopped, would that be accurate?
Yes.
What was your immediate objective when Mr. Floyd comes in and he's in cardiac arrest? What were you immediately trying to do?
Find a way to get the heart to pump on its own again. The primary goal in cases such as this is to achieve ROSC, which means return of spontaneous circulation. And part of that process involves trying to identify the cause of the arrest to see if there's any reversible causes, and continuing CPR and other life-saving measures.
And time is of the essence?
Yes.
How did you first learn that Mr. Floyd was being transported to the emergency department at Hennepin County Medical Center?
I received we call it a zip-it page. It's basically a EMS notification.
Now, first tell us what EMS is.
Emergency medical services.
And a zip-it, is it essentially a text-type message, or how would you describe a zip-it?
It's sort of like a encrypted text.
What time did the zip-it come in?
I don't recall exactly. Maybe around 8:50 p.m.
What information was provided to you for his care and treatment by zip-it?
The information was that it was a 30-year-old unidentified male who was in cardiac arrest, and that's as much as I can recall at this time, yeah.
Do you recall whether any information was given to you as to what may have happened to him ahead of time, before he got there, to explain the cardiac arrest?
Not at the time, not before he got there.
Did you know at the time he arrived that the patient was in fact George Floyd?
I did not.
So you learned that at some point later, that it was George Floyd?
Yes.
Did you also know at the time that there was a video or any videos that depicted what had happened to Mr. Floyd before he was transported to the Hennepin County Medical Center on May 25th?
No.
Grounds? Overruled.
You can answer. Were you aware of the existence of any videos as to what may have happened before he arrived at Hennepin County Medical Center on May 25th?
No.
Did you subsequently learn about videos?
Yes.
Were you able to evaluate your assessments about George Floyd in light of the videos?
Yes.
We'll talk about those a little bit later. So when you received this zip-it, what did you do in response to it?
We prepared a bay in our stabilization room, which is essentially a large room with a lot of critical care resources. We sort of prepped a team and got ready to take care of the patient when he arrived. Care resources. We sort of prepped a team.
Do you recall roughly what time Mr. Floyd would have arrived in the emergency room?
Approximately 8:55 p.m.
And when he arrived, then had CPR been started?
Yes.
Any mechanical devices or other things being used to help to stabilize him?
Yes, there was a Lucas CPR device, which is basically a mechanical device that sits across the body with something that almost looks like a plunger and pushes against the chest to provide CPR or chest compressions.
So this Lucas device then was on Mr. Floyd when he arrived in at the hospital.
Correct.
Did you ever observe at any point in time that his heart was beating on its own?
Not to a degree sufficient to sustain life.
Do you recall who brought Mr. Floyd into the emergency department?
I do recall 2 paramedics and possibly 1 or 2 other people, but I don't remember exactly.
Do you recall whether there were any police officers there also?
I don't personally recall that, no.
Did the paramedics who arrived at the emergency department give you a report?
They did.
Do you recall what they said for purposes of treating Mr. Floyd?
I do. The report they gave us is that they were called to a scene of someone who was suffering from medical emergency. As I recall, and this is what I was told at the time, they were initially called for a lower type of acuity event of facial trauma, and then that was upgraded to an individual in distress. They reported that on their arrival, the individual did not have a pulse and CPR was started. They placed an eye gel, which is a supraglottic airway device. It's basically a
super what? device?
supraglottic airway device. It's just a sort of a tube that goes down into the throat and can ventilate the lungs. And then they gave medications, including epinephrine and sodium bicarbonate, to try to resuscitate Mr. Floyd as CPR was ongoing.
Did they tell you that Mr. Floyd was in police custody?
They did mention that he was being detained at the time.
Now, did you recognize either one of the paramedics who came in?
I did. I did recognize both of them, and I worked with one of them several times before.
Derek Smith, did you know a Derek Smith?
I believe so, yes.
And do you recall having worked with a Derek Smith before?
I do.
How often?
Several times throughout the course of my training.
When the paramedics bring a patient in to the emergency department, is it standard protocol for them to tell you why they are bringing the patient in? What's the emergency?
Yes.
In what the paramedics told you when they brought in Mr. Floyd, did they also then give you information when they brought Mr. Floyd in?
They did. They essentially gave the report that I just told you, yes.
Did they say to you, for purposes of caring or giving treatment to Mr. Floyd, that they felt he had suffered a drug overdose?
Not in the information they gave, no.
Did they tell you in the information they gave that they felt that Mr. Floyd had had a heart attack?
No.
Did you receive any information or indication from the paramedics when they brought Mr. Floyd in that anyone had attempted CPR on Mr. Floyd at the scene on May 25th, 2020?
Overruled.
I did not receive a report that Mr. Floyd had received bystander CPR, no.
Did you receive a report that he had received CPR from any of the officers who may have been on the scene on May 25th, 2020?
No.
Is the administration of CPR right away important for you to know when you're dealing with a patient who has suffered cardiac arrest? Is it important for you to know about that?
It is, in the sense that it informs the likelihood of survival.
And what do you mean by that, Dr. Langenfeld?
It's well known that any amount of time that a patient spends in cardiac arrest without immediate CPR markedly decreases the chance of a good outcome. Approximately 10 to 15% decrease in survival for every minute that CPR is not administered.
Did the paramedics then tell you anything about the care that they had administered to Mr. Floyd?
Yes.
Can you tell us what they told you?
That they had started CPR and placed that airway device and started bagging the patient, as in providing breaths, and then administering those drugs. Yes. And
so when you talk about bagging the patient, could you describe what that is?
Yeah, it's called a BVM, or a bag valve mask. It's essentially a device that's hooked up to oxygen on flow to simulate giving a breath, or mouth to mouth, as it might be more better understood. But yeah.
Did the paramedics start something that's referred to as the ACLS algorithm?
Yes.
Would you tell the ladies and gentlemen of the jury, what is the ACLS algorithm?
So ACLS stands for Advanced Cardiac Life Support. It's basically a standardized way of taking care of patients in cardiac arrest.
And so these are protocols or sort of a checklist process you go through when somebody shows up in cardiac arrest.
Correct. It's a little broader than that, but a big part of it is for folks in cardiac arrest, yes.
Is it to help you to determine why the person might be in cardiac arrest so you know how to treat them?
Yes.
Had the paramedics tried to resuscitate Mr. Floyd?
Yes.
Do you recall how long?
The report we received was for approximately 30 minutes.
Now, you had mentioned to us just a moment ago that they had administered epinephrine and sodium bicarbonate. Would you tell the ladies and gentlemen of the jury, what are those administered for?
Epinephrine is colloquially known as adrenaline. It's a drug that has been studied extensively and is part of the standard protocol for ACLS. The evidence on it is somewhat controversial, but it is part of the standard protocol. Sodium bicarbonate is a medication that may provide some buffering of the acidic environment in the blood that occurs during cardiac arrest, and that is perhaps a more controversial medication than epinephrine.
Did the paramedics tell you whether they had checked Mr. Floyd's heart function?
Yes.
Well, let me ask that a different way. I want to talk to you about two different kind of heart functions and see if you can describe what they are to the jury and how or if they relate to Mr. Floyd. The first one we refer to as PEA. Do you know what PEA refers to?
Yes. So PEA refers to pulseless electrical activity. It's basically a situation where someone is in cardiac arrest. They do not have a pulse, as we previously discussed, and they do have some electrical activity on the monitor. And that suggests certain underlying causes that are known to be more common. The most common cause of someone being in PEA arrest, the most common causes are hypovolemia, either from typically bleeding or from hypoxia or low oxygen.
So we'll talk about those in more detail, but was Mr. Floyd in PEA status, pulseless electrical activity, when you saw him on May 25th?
He was, yes.
And there is another term I'd like to talk about and have you explain to the jury, asystole, I think it's called. Am I pronouncing that right, by the way?
Asystole, yeah.
Yes. Would you spell that for ladies and gentlemen of the jury?
ASYSTOLE.
And what is that, Dr. Langenfeld?
It's probably best known as flatlining, where there's no cardiac activity on the cardiac monitor and the patient is in cardiac arrest.
And so was Mr. Floyd in asystole status also when his body was brought into Hennepin County Emergency Department on May 25th?
At some point, yes. There was report that at some point he was felt to be in asystole prior to arrival.
And was he, and asystole meaning flatline, was there any point in time during your treatment of care on May 25th that Mr. Floyd was anything other than flatlined during your care and treatment of him?
There were times, for the majority of his time in our emergency department, he was in PEA arrest. Ultimately, that did devolve into asystole.
Is pulseless electrical activity, PEA arrest, asystole, are those conditions of the heart where you can simply apply a shock and potentially bring the patient back?
No.
What are what we refer to as shockable rhythms? Is there such a thing as a shockable rhythm?
So typically these are thought of as either ventricular tachycardia or ventricular fibrillation, which are basically abnormal rhythms of the heart that are more commonly associated with cardiac arrest, specifically from a heart attack. And they are rhythms that you can administer electricity to and shock a patient back into a normal rhythm.
But Mr. Floyd didn't have ventricular fibrillation or ventricular tachycardia.
Correct.
Because his heart wasn't pumping.
Yes, because he did, yes. In both situations, it's a little more complicated than that, but yes, he was not in VFib or VT as we commonly call them.
Do you recall, were there still handcuffs on Mr. Floyd when he was brought into the emergency department?
I don't specifically recall if they were on when he immediately arrived, but it would be unlikely because he had the Lucas CPR device on, and I recall his hands being at his sides.
Do you recall with his hands at his sides whether there were indentations or marks on his wrist?
At the end of the case, yes, after he was declared dead.
What did you observe in that regard?
I'm sorry, can you?
In terms of any indentations on his wrist or markings on his wrist?
I inferred that it was from handcuffs.
So let's talk about then the care you then provided once the paramedics have brought Mr. Floyd to the emergency department. What did you do?
So immediately on arrival, we took report from the paramedics. Mr. Floyd, as we knew him at the time only as an unidentified individual, was transferred over to the bed in the emergency department. As I recall, multiple things typically will happen simultaneously in these cases, but we achieved additional access. I placed intraosseous line in his bone in his leg.
Would you tell the ladies and gentlemen of the jury what interosseous
It's
means?
basically a type of IV that goes in through the bone and injects fluid or medications directly into the bone marrow, essentially. It's a type of access that's easier to achieve in someone who's in cardiac arrest.
And did you also go through the advanced cardiac life support protocols?
Yes, so simultaneous to that and obtaining blood draw and continuing chest compressions, etc. It went through various different things that could be causing this. Commonly in the ACLS protocol, these are thought of as the H's and T's, specifically with regard to the PEAA systole algorithm.
Well, let's, if we could, take a look at the H's and the T's.
Sure.
So, Brett, if you could pull up, I think, 900. I'm showing you what's marked as Exhibit 900 for illustrative purposes.
Sidebar.
And right now, prosecution and defense going in to a sidebar with the judge here as we are listening to testimony from the ER doctor who pronounced George Floyd dead and was trying to resuscitate him. And a little bit later today, we are expecting to have the police chief of Minneapolis on the witness stand as well. So it's going to be a busy Monday here to start this Day 6 coverage on NewsNOW from Fox. Remember, we will be providing you really gavel-to-gavel coverage here, as well as providing insights and expert analysis throughout this trial here. So we always invite you to watch along here with us, live, raw, and always unfiltered here on NewsNOW from Fox. Looks like that sidebar wrapping up here in just a moment. There was a delay to get the trial going today as there was several motions that the defense and prosecution were talking about. Just moments ago, the doctor testified that George Floyd was in cardiac arrest upon his arrival at the hospital. This in lay terms, Floyd's heart was stopped. The doctor explained that you try to get a heart to pump on its own when a patient arrives in such a condition. Doctor also recalls being told by arriving paramedics that George Floyd was being detained by police at the time of the medical emergency. Testified that there was no discussion upon patient handoff, either a drug overdose or heart attack. Earlier today, before the trial got going, the state just informed the court that it has 2 use of force experts above and beyond several officials with the Minneapolis Police Department. Judge Cahill expressed some frustration with that idea, explaining at this point it feels like it's just piling on. State then called this doctor, Dr. Langenfeld of Hennepin County Medical Center, to the stand. The doctor officially pronounced George Floyd dead at the hospital and continues to testify on how he tried to resuscitate Floyd the night of May 25th, 2020 there. Fox 9's Paul Bloom out of Minneapolis reporting earlier today that there was some details going on with a hearing that Judge Peter Cahill apparently conducted this morning with audio and video turned off. Paul Bloom says we'll get more information when we hear from our pool reporters in the courtroom today. They were allowed to observe the process, so that's an interesting little tidbit there that we should be getting a little bit more information maybe this afternoon or in the evening. Some reporting out there that there was a claim of juror misconduct or exposure to something that they should not hear, and we'll get to have those details a little bit later, hopefully. And as always, we try to talk to Paul Bloom daily on his reporting from everything inside of the courtroom and really outside as well. Just joining us here on NewsNOW from Fox, there is current sidebar situation happening right now with the prosecution, the defense, and the judge. Prosecution was just about to put up a slate that was going to be talking in more medical terms about cardiac arrest and what happens to the body during that time, and how do you try to bring a person back after what the doctor was saying, that he was seeing flatline from George Floyd, meaning that there was no cardiac activity inside of that hospital ER.
Dr. Langenfeld, going back to Exhibit 900, on the H's and the T's, which were part of the protocols for advanced cardiac life support, could you briefly explain to the jurors what the H's and T's are?
So these are common reversible causes of cardiac arrest in individuals, typically in PEA or asystole cardiac arrest. A lot of these etiologies are perhaps best evaluated through an ultrasound-based approach, but I can go through all of these. So hypovolemia, typically hemorrhage or bleeding. So we would think of that more in a traumatic cardiac arrest. Hypoxia, low oxygen. Again, those being the 2 most common causes of PEA asystole arrest. Hydrogen ions. acidosis can be from any number of causes, but essentially where the pH in the blood gets so low that the heart cannot function. Hyperkalemia is low or high potassium, it being a very important electrolyte for proper cardiac function, and disturbances on the extreme can lead to cardiac arrest. Hypothermia, very cold. Toxins, there's a lot of different toxins that can cause cardiac arrest.
And that's from poisons to potentially drugs.
Correct. Tamponade specifically refers to fluid around the heart that can prevent the heart from filling and then lead to the heart stopping. Tension pneumothorax is air around the lung, between the lung and the chest wall, that essentially expands to the point where it prevents blood flow from returning to the heart, and therefore leading to cardiac arrest. Cardiac thrombosis specifically can refer to a heart attack or a ruptured plaque in one of the coronary arteries of the heart. And then pulmonary thrombosis or pulmonary embolism is a blood clot in the pulmonary arteries that prevents blood from flowing from one side to the other of the heart, and therefore leading to the heart no longer functioning.
You mentioned ultrasound. What is the role of ultrasound in studying or trying to assess the cause of cardiac arrest?
Ultrasound can be used to evaluate many of these different causes. I think people would be most familiar with ultrasound from movies where they look at the baby using an ultrasound device or a small probe on the abdomen, but it's the same technology. So we can look at the heart directly and see if there's fluid around the heart, for example. We can evaluate for a large right ventricle that might be suggestive of a pulmonary thrombosis due to increased strain on that side of the heart. We can look for evidence of hemorrhage, hypovolemia, by looking in the abdomen to see if there's any bleeding or bleeding elsewhere. We can look for evidence of tension pneumothorax. For example, we can evaluate for what's called sliding signs on both sides of the chest that would suggest that the lungs are up and there's no air between the lung and the chest wall. So we can use it to...
That the lungs are properly inflated then.
Exactly, yep. So we can use it to evaluate for a large number of these etiologies.
So you went through the protocols of the H's and the T's. Did you have any kind of leading theories for treatment purposes as to what the most likely causes were for Mr. Floyd's cardiac arrest?
I felt that I was able to determine that some etiologies or causes were less likely based on the information that I had both from the paramedics and also the information I was able to obtain from my exam and ultrasound, etc. At the time, based on all the information I had, I thought it was less likely that the patient had suffered from, for example, cardiac tamponade. There was no fluid around the heart. Tension pneumothorax. We can discuss that briefly. At one point in the case, I was concerned that he may have developed a tension pneumothorax, but I felt it was unlikely. We did, in fact, perform bilateral finger thoracostomies where we entered the chest.
Let's ask another question.
I'll ask another question. You were explaining to the jury that you thought it was not likely a cardiac tamponade. Then you're explaining why you thought that tension pneumothorax was not likely.
Correct.
And could you, in plain English, help the jurors to understand how you might have eliminated that?
We essentially used a scalpel to cut into the chest and create a hole between the chest and the potential space around the lungs. We did not appreciate any large gush of air that might suggest that there was air in that potential space.
Was there anything that you looked at to determine whether or not the cardiac arrest was likely or unlikely to be related to Mr. Floyd having had a heart attack?
A lot of that is based on the history that we received from paramedics. There was no report that, for example, the patient complained of chest pain or was clutching his chest at any point, or having any other symptoms to suggest a heart attack. That information was absent. Also, the fact that he was in PEAA systole, as I was told on the initial rhythm check, further decreases the likelihood of that possibility. At the time, it was not completely possible to rule that out, but I felt that it was less likely based on the information that was available to us.
Did the ultrasound play any role in the question of whether or not he did or did not, or was likely not to have had a heart attack?
No, not especially in this case, no. Did not.
Did you consider the possibility of toxins, for example, being responsible for Mr. Floyd's cardiac arrest, including potentially drugs?
In the sense that it might have informed our care, yes. There was, again, no report that this patient had, for example, overdosed on a specific medication such as calcium channel blocker or any other medication for which there might be a very specific antidote. And so in that sense, I didn't feel that there was a specific toxin that we could give a medication for that would readily reverse his arrest.
And what about then hypoxia?
So hypoxia being, again, one of the most common causes of PEAA systole just in general. I did then, as I'd mentioned, use the ultrasound to look in the abdomen and did not see any evidence of hemorrhage. There was no obvious significant external trauma that would have suggested that he suffered anything that could produce bleeding sufficient to lead to a cardiac arrest. And so, based on the history that was available to me, I felt that hypoxia was one of the more likely possibilities.
And hypoxia as an explanation for his cardiac arrest, meaning oxygen insufficiency.
Correct.
Did you have any other leading theories as to why Mr. Floyd's heart may have stopped other than oxygen deficiency?
Yes. I also considered an acidosis. In particular, excited delirium, which is a controversial diagnosis, but it was in the differential in this case.
And were you able to make any assessments about so-called excited delirium based on your examination of Mr. Floyd?
Again, the patient had been in cardiac arrest for 30 minutes. It can be difficult based on the examination. Certainly there was no report that the patient was ever very sweaty, which is often the case when thinking about excited delirium. There was no report that the patient had ever been, that Mr. Floyd had ever been extremely agitated. In my experience, seeing a lot of cases of mental health crises or drug use leading to severe agitated states, that is almost always reported by paramedics. And so the absence of that information was telling, and that I didn't have any reason to believe that that was the case here.
So how long was Mr. Floyd in your care in the emergency department?
Approximately 30 minutes.
And at the end of the 30 minutes, did you pronounce him formally dead?
Yes.
At the time you pronounced him dead, was he still in some degree in PEA or asystole in terms of describing his heart?
I think it's probably best to think of these as sort of a spectrum where PEA is some degree of electrical activity still running through the heart, but the heart's not pumping. And then eventually that will devolve into asystole, where both the heart is not pumping and then the electrical activity stops as well. And so at the end of the case, Mr. Floyd was still in PEA, but there was virtually no cardiac activity. And at that point, in the absence of any apparent reversible cause, and because Mr. Floyd had been in arrest for, by this time, 60 minutes, I determined that the likelihood of any meaningful outcome was far below 1%, and that we would not be able to resuscitate Mr. Floyd. And so I then pronounced him dead.
And doctor, was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
Thank you, Dr. Langenfeld. No further questions.
Mr. Nelson. Yep. It's 9 o'clock, so we're going to take our 20-minute mid-morning break. Thank you.
Okay, folks, they are taking their 20-minute mid-morning break right now. You just heard from the judge there. We'll see if the defense will do a cross-examination there of the doctor, the ER doctor there that pronounced George Floyd dead. Right now, we will go out to some of the coverage, Fox 9 Minneapolis, as they continue to bring the very latest expert analysis that we saw from this morning. The highlights.
We've been listening to testimony this morning of the trial of Derek Chauvin. We're listening to the prosecution questioning the senior resident on call at HCMC when George Floyd was brought there, Dr. Bradford Langenfeld. And you could tell by what they were doing with their questioning to determine the cause of death. Let's get to our legal expert, Ryan Pasiga. And Ryan, were they effective, do you think, in what they wanted to achieve, and that is the cause of death? And you heard the last thing said, there were asphyxia. Was that something key that they wanted the jury to hear?
Yeah, I believe so. Even though they got out of this doctor what they could get out of him, I am hearing some potential for cross-examination on reasonable doubt here, though.
Right. And does it hurt? You might say that since he was the senior resident, he's not the attending physician on call, that the defense could say, you're very new at what you're doing, and use that as part of their questioning to put some of that reasonable doubt in the minds of the jury.
Exactly. That's one of the things I wrote on my notes was relative inexperience here. I think that's something the defense can seize on. I also heard at times words like not likely or, unlikely, not ruling things out for certain, of course. And when we hear things like less of a chance or not likely to a defense lawyer, that's reasonable doubt.
Right. And we heard a lot of medical jargon, and the prosecution was trying to put it in more lay terms. There seemed to be a little disconnect there. Were you picking up on that as well? And was the jury picking up on that, do you believe?
100%. And I think so. I mean, it kind of goes both ways, and here's why. So the doctor, because he's relatively inexperienced, if you will, on the one hand, I think it's good for the doctor to be using bigger words because it's going to show he knows what he's talking about. Of course, to the rest of us, myself included, I'm going, what's that mean? What's that mean? And I do believe that the prosecutor, Mr. Blackwell, did a really good job at times stopping him and telling him, hey, we need you to break this into plain everyday English for us because we don't get this. So I expected you're going to have some of that. An expert needs to use big words at times to tell the jury, I know what I'm talking about, but it was a very good move for that prosecutor to stop him at times and say, just in plain English, tell us what that means.
And the prosecution obviously wants to blow part of the defense's argument that George Floyd died of medical health issues from cardiac arrest and not because of what happened on the scene with the knee to the neck. Do you think that the prosecution in this case, they obviously were trying to blow holes in what the defense wants to do when they question him soon, but that they were trying to get to the fact that this his death did not have anything to do with his previous medical conditions?
I think for this particular witness, they did a good job trying to head that off at the pass as much as they can. The reality is that this witness is limited to what he knew at the time because he's relying on information that was provided to him by the paramedics. He wasn't there at the scene observing, making the initial observations, nor was he in the ambulance during the transport. So, and of course, he's not able to run many tests on Mr. Floyd, right? So he's limited to what he can speak about. And of course, we know when someone has limited information, they can make some inferences there, but also there's another way of looking at things. And I expect the defense to really make that a theme of their cross-examination on this expert now.
Right, and the fact that that limited knowledge as to what happened at the scene, not even knowing that drugs could be a possibility, obviously that's something that the defense would, I would think, capitalize on, the fact that this senior resident didn't have a lot of information to go on, even from the paramedics when they arrived into the emergency room.
Administer that aid. They loaded him into the ambulance, and then I don't know how long it was before they began rendering that aid, but you know, there is something to be made of that happening as well. Of course, we're all Monday morning quarterbacking this thing, but nonetheless, how can you say it was the decrease on the officer not giving this aid versus even the paramedics not doing it and so forth? So again, these things get to some reasonable doubt issues, and it'll be interesting to see whether the defense knows to seize on these things and how effectively it does so.
Ryan, we all know about Minnesota Nice, and you have to keep that in mind when we're talking about with this physician, this senior resident, when they go to the questioning now when the defense comes back. So with that in mind, they have to be careful, do you think, with the jury as to how you don't want to attack this young physician, but you also want to make your point that puts reasonable doubt in the jury's mind that maybe he is a little wet behind the ears, so to speak.
Yeah, you can do it a couple ways. You're exactly right. You can come at them like a freight train. You can do what's called a compassionate cross-examination, where you're more compassionate with them and saying, but you do have limitations on your experience and you haven't been around forever, and doing your job is tough and you don't always know things, and sometimes you need more information to render a different opinion later, and those sorts of things. And that's more of a compassionate type of cross. And sometimes you then won't alienate a jury if they want to protect a certain witness, because this guy's a northern Minnesota guy. He had a rather somewhat flat effect. He seemed to be not particularly invested in one side or the other in the case. So I think the jury overall is going to like him, and going bulldog at the guy may go over poorly with the jury. So in this particular situation, I think more of a making your points, but also having a compassionate cross and getting that witness to just agree with you on some things might be the way to handle this guy.
We saw the one slide, and there was a sidebar as to, I imagine the defense wasn't sure what was going to be on the slide with the H's and the T's, more of the medical jargon as to the criteria that the ER uses when a patient arrives there in cardiac arrest. Why do you think we had that sidebar? What was being decided upon there? What were some of the sticking points, do you think, for the defense on that slide?
Well, it's going to be how far do they want to question this witness on this particular slide. That's exactly it. So do they want to just talk about what's on the slide and give explanations in English for what these terms mean? Or was he going to be rendering an opinion about whether some of these things were present or not? And was that going to run further than what Judge Cahill said he was going to let some prosecution witnesses do? This is that battle about how many opinions can be rendered and how far can those opinions go. And the problem is you can't unring the bell. So Eric Nelson knows, hey, if he's not having these rules set really quick on this slide, the prosecutor asks a question, the witness asked it, then Eric objects, but the jury's already hearing. Mm-hmm. So you've got to curtail this stuff as you're going because you can't unring the bell.
Do you feel that the prosecution actually got the doctor to give the cause of death? It seemed it just seemed like it was not as clear as it could have been. He did say that he believed that the lack of oxygen was a part of this, and then asphyxia. So was that what they wanted to hear, or do you think that they missed short of the goal line on this one?
I think the prosecution did what it had to do there, or whether it could. This doctor isn't in a position to rule on the cause of death. That's why we have medical examiners. Mm-hmm. So, and again, he's got limited information. A medical examiner is the one that opens up the whole body on an autopsy and takes lab results from the blood and urine and tests the different organs and makes physical observations that we can't see when the body is closed. So that's as far, I think, as this doctor in that position could have went, honestly, and knowing that, and the prosecutor knows that, and the defense lawyer knows that. So I think they took him as far as they knew they could take him.
Right. Let's get over to Paul Bloom, who, of course, was there during the proceedings this morning. We knew that we had the motions hearing this morning, allowing some new video from the scene, and also some questions about the training that Derek Chauvin had received and whether some would be permissible and what would be permissible as far as future testimony when it comes to officers who've had similar training. Paul, what's your takeaway so far from this morning, not only from the motions, but what you heard from the Dr. Langenfeld there?
Well, I think it's best where I start with, I'm going to have to read off my cell phone here, but we do have some details in from our courtroom pool reporter who was inside the courtroom when there was this quote-unquote Schwartz hearing. I don't know, I missed the top of Ryan Pasiga's discussion with you. If you discussed this issue with the jury, they had gone off camera, off audio, Judge Cahill, wanting to address something that had apparently, I don't want to say maybe upset him or concerned him in the courtroom with the jury. Well, now we do have some details on exactly what happened there. Our courtroom pool reporters were allowed to stay in the room, but they cut the audio and the video feed. So you didn't see that on the live broadcast stream. But basically, Cahill didn't explain what was in front of the jurors. Apparently, they had several pages of paper on their desks when they arrived in the courtroom. He said he was being intentionally vague. He noted that on the sheet there was a comment about halfway through. So the jurors were reading through this page, or these pages. And then my question is, this is the judge speaking, my question is, has anybody said that phrase or something similar to it? And I think you know what I'm talking about. Has anybody said anything like that to anyone? So that is in reference, my understanding of a Schwartz hearing on quick research, is it's if a juror has committed some kind of misconduct, maybe been approached, maybe said something, maybe had told something to another juror as if they had gone to investigate or went to figure out more. So apparently he had the jurors read through this sheet, asked if anybody had said these comments, and I'm going to pick it up. He asked them to raise a hand. If the answer was yes, no one raised their hand. He asked them to raise a hand if the answer was no, and then 13 jurors raised a hand, but the juror in seat 1 did not. So there was some further questioning there. In the end, Judge Cahill finding that there was no violation, nothing to be concerned about. But that was sort of a surprising situation in that courtroom. Judge Cahill concerned about something apparently laying it out in this paperwork, having the jurors respond whether, they said something like that, whether they recognize. This next portion is about whether they recognize the person. So there might have been a photograph provided to these jurors. So some interesting stuff. It's hard to condense it all so quickly. But again, our courtroom pool reporter is saying something was very much addressed with this jury out of a concern of possible misconduct amongst this jury, of course, coming back from a slightly longer Easter holiday weekend. But the judge taking care of that, you saw he got right back into it with the attorneys. He sent the jury back out of the room and then continued on with witness testimony of this doctor. And, Ryan hit the nail on the head, and you guys were talking about it before coming to me, this idea that oxygen deficiency, of course, when we talk about asphyxia and the potential involvement in the cause of death of George Floyd, that is so huge. And Ryan's right. The doctor can only go so far in his assessment, but in the moment, his best guess based on the H's and the T's and his training, that it was some kind of oxygen deficiency that caused his heart to stop. And when asked to translate what that means in layman's terms, he said asphyxia. So as far as the state, it was a little muddled getting there, but they did get the doctor to say that. I know that was important to them. Obviously, we've got cross-examination to come yet. And then we have Chief Maderi Arradondo waiting in the wings to testify probably before lunch yet.
All right, Paul, we'll pick your brain a little bit more on the topics from what happened this morning. Let's get to Hannah Flood right now in our newsroom to find out a little bit more about what happened earlier. We heard what Paul was saying with there was no violation according to the judge in some of the comments he thought that could pertain to this jury. But tell us about some of the motions that were brought this morning and what came of those.
Yeah, hey, Tom, it's interesting. We know that this week, it's already starting off with this first witness. It's kind of going to be, less about those personal witnesses being on the ground and seeing things. And it's going to be more now based on expert testimony, whether it's doctors like we're seeing this morning or other police officers involved with police training. So basically some of the motions that happened this morning were, what are police officers going to be able to say when they get up on the stand? Will they be able to give their opinion? We had Lieutenant Zimmerman on Friday give his opinion that Derek Chauvin's use of force was unnecessary, was uncalled for. So today, this morning, they were kind of shaping what officers after this are going to be able to say on the stand, kind of limiting their testimony to, hey, this is my role in the police department. Maybe they're the lead trainer on a certain kind of topic. They'll be able to say, this is the training we provide, this is what we tell our officers, these are our policies, and this is the training that Derek Chauvin went through. So I want to play a little clip of the judge kind of laying out, Judge Cahill laying out what the limits are going to be for these officers when they do take this stand.
My analysis of this is, we have said Mr. Floyd's state of mind is not relevant. It's the defendant's state of mind, his knowledge and his intent. And part of his knowledge is based on training he's received. So a summary of the crisis intervention training he has received is appropriate. We're not getting into, I suppressed the psychiatrist's testimony about what was Mr. Floyd's, was that truly anxiety or whatever. I'm not going to let a trainer say, look at the video and give those kind of answers. But evidence regarding what Mr. Chauvin knew, what he had been trained on, which goes to intent and knowledge on the May 25th, 2020, are all relevant and would be allowed.
So that right there, Judge Cahill, again, kind of mapping out what officers will be allowed to talk about, what they won't be allowed to talk about. Again, we're expecting the Minneapolis police chief to take the stand sometime today. So kind of laying out those rules before those witnesses start coming up. The doctor who's up, Dr. Langenfeld, who's up on the stand right now, also has, some rules and restrictions of how far he can go when he's describing some of the experience that he had with George Floyd when he got to the hospital. But Paul and Ryan were talking about kind of this last question that Jerry Blackwell asked him about oxygen levels related to cardiac arrest. So we want to play that little clip of what the doctor had to say just before we went on this break.
Was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
Thank you, Dr. Langenfeld. No further questions.
So that right there was kind of an important point for the state to get the doctor saying that, because of course the state has to prove causation here. They have to prove that Derek Chauvin played that role in George Floyd's death, and getting that doctor to kind of get to that point. Ryan was talking about how it took some questioning and some explanation to get to that point. That's kind of what the state ended on there with that powerful testimony from the doctor saying asphyxiation, something that it looks like the state is going to work with and try to prove here. I was talking to a defense attorney yesterday, and she said this part of the trial can get a little challenging because we get into really complicated medical testimony, you know, those big words, asking these doctors to break things down in simple terms. And she told me that it really comes to how the lawyers ask questions to get the kind of answers that the jury can understand, right? So the jury doesn't doze off, they don't stop paying attention, or they don't understand what the doctor is talking about. So we're going to play a clip for you now of Dr. Langenfeld up on the stand today, of the state kind of asking some of those questions. And you can hear Jerry Blackwell asking questions in a way that he's looking for answers that the jury will be able to understand, but also kind of giving him that credibility as a doctor to speak in medical terms and then break them down so it's easier for the jury to digest and understand. So let's listen to a little bit of Dr. Langenfeld's testimony so far this morning.
The report they gave us is that they were called to a scene of someone who was suffering from medical emergency. As I recall, and this is what I was told at the time, they were initially called for a lower type of acuity event of facial trauma, and then that was upgraded to an individual in distress. They reported that on their arrival, the individual did not have a pulse and CPR was started. They placed an eye gel, which is a supraglottic airway device. It's basically a
super what?
Supraglottic airway device. It's just a sort of a tube that goes down into the throat and can ventilate the lungs. And then they gave medications, including epinephrine and sodium bicarbonate, to try to resuscitate Mr. Floyd as CPR was ongoing.
Did they tell you that Mr. Floyd was in police custody?
They did mention that he was being detained at the time.
Now, did you recognize either one of the paramedics who came in?
I did. I did recognize both of them, and I'd worked with one of them several times before.
Derek Smith, did you know a Derek Smith?
I believe so, yes.
And do you recall having worked with a Derek Smith before?
I do.
How often?
Several times throughout the course of my training.
When the paramedics bring a patient in to the emergency department, is it standard protocol for them to tell you why they are bringing the patient in? What's the emergency?
Yes.
In what the paramedics told you when they brought in Mr. Floyd, did they also then give you information when they brought Mr. Floyd in?
They did. They essentially gave the report that I just told you, yes.
Did they say to you, for purposes of caring or giving treatment to Mr. Floyd, that they felt he had suffered a drug overdose?
Not in the information they gave, no.
Did they tell you in the information they gave that they felt that Mr. Floyd had had a heart attack?
No.
And we'll go back to
Monday.
court proceedings right now.
And just a reminder, Doctor, you are still under oath. Mr. Nelson.
Morning, doctor.
Morning.
Thank you for being here today. I have a few follow-up questions for you, kind of picking up right where we left off. You were discussing hypoxia kind of being consistent with asphyxiation, right?
Correct.
Hypoxia is the lack of oxygen to the brain, correct?
Correct.
Right. And there are many things that cause hypoxia that would still be considered asphyxiation, agreed?
Correct.
Drug use, certain drugs can cause hypoxia, agreed?
Yes.
Specifically fentanyl?
That's correct.
How about methamphetamine?
It can.
Combination of the two?
Yes.
All right. Now, you testified about certain things that happened during your care of Mr. Floyd. You were running all sorts of different tests. You used the
ultrasound.
Ultrasound. Yep. Thank you. Used the ultrasound. You took some blood samples as well.
Correct.
And you took some blood gas samples as well. Correct.
Correct. From the blood samples. Yes.
Right. So, can you explain what the blood gas samples are?
So the blood gas samples are analyzing different parts of the blood, specifically looking at the pH or how acidic or basic the blood is, looking at the amount of oxygen in the blood, the amount of carbon dioxide, the amount of bicarbonate.
Okay. And carbon dioxide levels in this case were pretty high, weren't they?
Correct.
Do you recall what the carbon dioxide level was in the blood gas sample you initially took?
I believe the initial blood gas sample I took was a venous blood gas sample, which is less preferable as opposed to an arterial blood gas sample. At the time, I believed it was a venous sample, and I believe the CO2 level in that sample was around 100.
Okay. A little over 100, perhaps?
Yeah.
And that indicates an exceptionally high carbon dioxide level, agreed?
That, yes.
What would the average, for a healthy person, and you did a blood gas sample, what would you expect the CO2 or carbon dioxide level to be?
For a healthy individual without any sort of lung disease, you would expect somewhere between 35 and 45.
Okay. And so Mr. Floyd's carbon dioxide level was more than 2 times what you would normally expect.
Correct.
Now, the reason that you're doing these blood gas samples is in part to help you analyze and figure out courses of care. Agreed?
Yes.
And that's the carbon dioxide number that we're talking about is essentially, that would be indicative of a person who is not eliminating the carbon dioxide, right? For it to go that way?
Correct. For it to be high in the blood, that means that they are therefore not eliminating it through ventilation or breathing.
And that points to a possible respiratory problem, right?
It can, yes.
And that increase in a carbon dioxide from a 35 to 45 to over 100, that takes some period of time in order to climb that high.
Yes, it can happen relatively quickly depending on how severe the ventilation problem is, but
it generally could take 30, 40, even an hour to climb that high.
It could take that long. It could take much less time, yes.
The use of fentanyl, do you know that to attribute to high carbon dioxide levels?
It can cause high carbon dioxide levels because it depresses the ventilation or the breathing.
So when someone ingests fentanyl, it can cause them to feel very sleepy because of an increased carbon dioxide level. Agreed?
Correct.
And that's one of the reasons ultimately that fentanyl is so dangerous, because it suppresses the respiratory system. Agreed?
The primary reason it is so dangerous, yeah.
Now, you testified that when the paramedics gave their report to you, They did not give you any reference as to potential drug use, correct?
Correct.
They did not tell you that they had administered Narcan or naloxone during their care, correct?
Correct.
And during the course of your care of Mr. Floyd, you did not administer Narcan or naloxone, did you?
No.
And when you talk about those drugs that are immediately able to reverse the effects, that's what that does. Narcan reverses the effects of fentanyl toxicity. Agreed?
Correct.
When someone has a high carbon dioxide level, that causes that person to have a sensation of shortness of breath. Agreed?
Yes.
And that can happen to a person even without stress complicating their body, right? That respiratory, that feeling of an inability to breathe.
Yes.
Are you familiar with the impact of taking certain narcotics interrectally? Rectally?
Yes.
And that ultimately can provide a more powerful or rapid onset of an impact, right?
Yes.
Simply because a person has a history of chronic opiate abuse, does that mean that fentanyl can't kill them?
No.
When someone is hyperventilating, anxious and hyperventilating, they're actually decreasing their CO2 by doing that, correct?
Correct.
Some of the considerations that you have to take also would be the potential occlusion of a coronary artery, right?
Yes. In cases of cardiac arrest, yes.
And someone who has greater than a 75% occlusion of the right coronary artery, that poses a particular risk of fatal ventricular cardiac arrhythmia, does it not?
Objection, Your Honor. May we approach?
Favor?
You can see they went into another sidebar session there. The defense now, Eric Nelson is questioning the doctor who pronounced George Floyd dead, and we are getting a back and forth on that as well. A little bit later today, we are expecting the Minneapolis Police Chief to testify, and of course, we always provide you gavel-to-gavel coverage right here on News Now from Fox. Just joining us here on News Now from Fox, thank you so much. Again, as we are in now day 6 of the Derek Chauvin trial. Looks like the sidebar is going to be wrapping up. There we go, and audio back on.
All right, last question's withdrawn. Ask a new question.
Only a physician can declare a person dead, correct?
Depends where you're practicing.
In the state of Minnesota?
Yes.
A paramedic can't declare a person dead?
No, not without consultation with a physician.
So just to, based on your treatment, again, of Mr. Floyd, based on these tests that you did, had an elevated CO2 level, correct?
Yes.
And that CO2 level was considered to be exceptionally high, correct?
Correct.
And you did not, in the course of your consideration, provide naloxone or Narcan?
No.
Okay. And it would be, is it fair to say that the administration of Narcan, if you do not have opiates in your system, is a safe procedure?
Yes.
And if you do have opiates in your system, the administration of Narcan could be life-changing, life-saving? Yes,
not in this case.
Prior to the, but again, the paramedics also, based on your information, did not administer Narcan?
Correct. Can I make a clarification?
I'm good. No. There's no question.
If they wish.
I'm sorry?
I just said the state can clarify the
Direct if they wish.
And you would agree that Mr. Floyd arrived at HCMC at approximately 8:53, if we have seen evidence previously?
That sounds correct. Yeah.
I have no further questions, Your Honor.
Mr. Blackwell.
Thank you, Your Honor. For starters, Dr. Langenfeld, there was an answer you wanted to clarify. Please do so.
Only to state that Narcan, administering Narcan to someone who potentially suffered a fentanyl overdose, once that individual is in cardiac arrest, the administration of Narcan would provide no benefit.
And Mr. Floyd was obviously in cardiac arrest.
Correct.
You were asked questions just now about whether fentanyl works by causing someone to feel very sleepy. Remember that discussion?
Yes.
Did the paramedics tell you that Mr. Floyd was ever asleep or sleepy or anything that sounds like sleep?
The report that I received was that the patient, Mr. Floyd, was unresponsive on their arrival and did not have a pulse. And so there was no report that he had been sleepy or difficult to arouse per se.
You asked quite a number of questions about the carbon dioxide content in the blood gases. First off, if a person is suffering from hypoxia, that is oxygen deficiency, is that an explanation for a heightened carbon dioxide content in the blood?
It can be in severe cases.
In this case, do you find that the carbon dioxide reading for Mr. Floyd is really all that significant?
I felt that it was weak evidence in support of what I was thinking at the time. What's difficult in cases of cardiac arrest is once someone has been in cardiac arrest for an extended period of time, essentially the blood gas that I obtained could be consistent with cardiac arrest from any number of causes. You expect the pH to be low. During cardiac, I'll provide a little bit of explanation on that. During cardiac arrest, there's no blood flow to the tissues, therefore there's no oxygen getting to the tissues. Therefore, the cells will die. They'll release hydrogen ions, which lower the pH, creating an acidic environment. They'll release lactate, which complicates that further. Because the person's heart has stopped from whatever cause, they'll no longer be breathing either. And so you would expect that their CO2 to be high. Again, it can vary a little bit depending on the cause, but in my estimation, the blood gas in this case wasn't very strong evidence for one cause over another as far as the etiology of the arrest.
And it was simply consistent with the fact of cardiac arrest.
Correct.
The fact that the heart had stopped.
Correct. And I felt that the high CO2 may have suggested a respiratory cause.
Now, you were asked questions about somebody administering narcotics interrectally. Remember those questions?
Yes.
Did you get any indication that Mr. Floyd had administered narcotics interrectally?
I had no information to suggest that.
Dr. Langenfeld, thank you.
Any further? Thank you, Doctor. You may step down. Mr. Slisher.
Thank you, Your Honor. Your Honor, the state calls Chief Madeira Arradondo.
Swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do, sir.
Let's see. And before you begin, if you could give us your full name, spelling each of your names.
Yes, Your Honor. Madeira Arradondo. First name is spelled Medaria. Last name is Arradondo.
Mr. Slisher.
Thank you, Your Honor. Sir, what is your current role?
My current role is Chief of the Minneapolis Police Department.
How long have you held that position?
For approximately 3 years.
And as Chief of the Minneapolis Police Department, are you responsible for overseeing the operations of the entire Minneapolis Police Department?
Yes, I am.
And that's the highest ranking role at the Minneapolis Police Department, is that correct?
That is correct.
Now, sir, I'd like you to first share a little bit about yourself with us. How old are you?
54 years old.
In what city do you live?
Twin Cities.
Where are you from originally?
Minneapolis.
Where did you go to high school?
The Minneapolis Roosevelt High School.
All right. And have you ever lived outside of the Twin Cities, Minneapolis area?
I went away for college for a couple of years in Michigan, yes.
Where in Michigan did you go?
It was Hancock, Michigan.
Which school?
Which is now called Finlandia University. I'm sorry, Your Honor, Finlandia University.
And what is the highest level of education you've attained?
I received my master's degree.
What degree did you receive in Hancock, Michigan?
That degree was a criminal justice degree.
After you completed your college studies, you returned to the Twin Cities area?
That is correct.
And is that when you first joined the Minneapolis Police Department?
Prior to that, I had worked as a community service officer at the Minneapolis-St. Paul Airport Police Department.
What years did you do that?
I believe that was from 1987 to 1989.
And then in 1989, did you join the Minneapolis Police Department?
I did.
In what capacity?
I started my career as a Minneapolis police cadet and then was hired as a Minneapolis police officer that year.
And Chief, why did you decide to become a police officer?
I've been very fortunate to come from a city of very resilient, very welcoming, proud people here in the city of Minneapolis. And my dear parents taught all of my siblings and me about the service of love. And so I've been very fortunate to then eventually join the Minneapolis Police Department and give back to the very community, the very city that embraced me and has been so good to me.
Are you familiar with the motto of the Minneapolis Police Department?
Yes, I am.
What is it?
And that is to protect with courage and to serve with compassion.
And what does that motto mean?
We are oftentimes the first face of government that our communities will see. And we will oftentimes meet them at their worst moments. And so the badge that I wear and that members of the Minneapolis Police Department wear, it means a lot because the first time that we interact with our community members may be the only time that they have an interaction. And so that has to count for something. And so, so it's very important for us to make sure that we're meeting our community in that space, treating them with dignity, being their guardians, and representing and all of the men and women that came before us who served so proudly on this department.
Sometimes you have to protect with courage and you have to use force. Is that correct?
At times, yes. As a police officer, you will have to use force.
Sometimes serving with compassion means to understand when force is not required.
Rephrase.
What does it mean to then serve with compassion?
To serve with compassion, to me, means to understand and authentically accept that we see our neighbor as ourselves. We value one another. We see our community as necessary for our existence. And so that's what serving with compassion means to me.
Now, you've told us a little bit about your educational background. I'd like you to share with all of us a little bit more about your specific law enforcement training. You mentioned the academy. Is that where you received your law enforcement specific training?
Yes, it is.
Please describe how that training occurred.
I was a member of the first Minneapolis Police Cadet Program, and along with many other candidates, we received training, both academic training on the laws of the state of Minnesota. We received training as it relates to everything from driving and defensive tactics, community relations. And so we also, there's post requirements of Minnesota Post Officer Standards and Training to receive our license. There was a test that we had to take then. There was also scenario-based training as well to grade and assess how we performed during that training in the academy. And so that was part of that important training that I received along with my candidates at the academy.
And that was the very first Minneapolis Police Academy?
That is correct.
And a trainee at the academy is that trainee referred to as a cadet?
That is correct.
In your employment, you've been continuously employed as a in the Minneapolis Police Department since, was that 1989?
That is correct, sir.
Has the academy changed since you first were a cadet back in 1989?
It has. And while I certainly believe that at the time back in 1989 that training was important, like any police department, we should not be monolithic. Our communities are not monolithic. Our training should evolve. We should be focused on what our national best practices. And so the training that our recruits and cadets get today, and rightfully so, is far better than the training that I received those years ago.
Well, we'll circle back to that a little bit later. You also mentioned that you take post credits, is that right?
Yes, that is correct.
And POST stands for Peace Officer Standards and Training?
That is correct.
What is the requirement for post training? How many courses are you required to take in a given period?
Yeah, every sworn peace officer in the state of Minnesota receives their license through the POST, Peace Officer Standards and Training Board. And so POST will change up what some of those requirements are from time to time. But some of the ones that I think of right now would be crisis intervention training. There's certainly defensive tactics training. There's now a form of procedural justice training that is required. And so Minneapolis police officers receive that mandated training, but we're also very fortunate that we're able to receive additional training above and beyond what is required of the POST board.
And you personally participate in this training in order to maintain your POST license?
That is correct.
Chief, you began your career in 1989. You're now the chief of the police department. Fair to say you've had many roles within that department. Is that correct?
That is correct.
At this time, I'd like to publish Exhibit 209, if I may. And we'll leave that up, if we may, while you testify. What was the first position you held within the department after you completed your academy training?
I was sworn in as a Minneapolis police officer.
Now, we've heard that term sworn officer before. Can you please explain to the jury what that means?
Sworn officer, after you complete the required educational requirements, and certainly after you complete your performance measures at the academy, then you are eventually sworn in at a location, and traditionally our city clerk has been there, and you take an oath, and you're sworn in as an official member of the Minneapolis Police Department, but also as a City of Minneapolis employee, and you start your employment with the city then.
And what were your duties then as a sworn police officer, that rank for the City of Minneapolis?
Primary duties was to be a 911 responder, to work in a geographical area of the City of Minneapolis in a district, at a precinct, and respond to 911 calls on a given shift.
Are those also called calls for service?
That is correct.
And as a patrol officer at that time, well, how long did you remain a patrol officer?
Approximately 5 years or so.
And can you tell the jury what geographic district you served as a patrol officer?
Yes, I served for a short time in the 3rd Precinct, and then I think the bulk of that time in the Minneapolis 4th Precinct, which is located in North Minneapolis.
During that time period, that 5 years as a patrol officer, did you ever have occasion to arrest a suspect?
Yes, I did.
How about a non-compliant suspect?
Yes.
You've had to place handcuffs on someone who was not compliant?
That is correct, yes.
Approximately, would you care to guess how many times?
I'm sure several. I'm sure several.
This is something that's a fairly regular occurrence as a police officer, as a patrol officer, is that right?
That is correct.
You've had to be in situations where you've had to use force, is that right?
That is correct.
Have you also been in situations where you've had to de-escalate or talk someone into compliance?
Yes.
And is that a regular part of your job as a patrol officer?
Yes, it is.
Even from 1989 to approximately 1994?
Yes.
Then after serving this period of time as a patrol officer, what was your next position at MPD?
And I believe in 1997, I was then promoted to the rank of sergeant in the Minneapolis Police Department.
And what do you have to do to be promoted to the rank of sergeant? What are the requirements?
It is a civil service test that you take, and you have to successfully pass that and receive a grade from that. And I'm trying to recall if there was an assessment center that was also part of that testing process. But there is a number of years that you have to at least have served as a police officer before you can take the sergeant's test and promotion.
And what is the role of a sergeant in the Minneapolis Police Department?
Sergeant's role, and I've often said it is the most influential role in the police department.
How so?
It's most influential because you have the most proximity to the men and women who are out there serving in the community. You're there for them at the roll calls. You are a mentor. You give them guidance. They are going to see you far often than they would ever see the chief of police, for example. And you set the tone and the attitude. And so that's really a very significant role within the Minneapolis Police Department.
That's a first-line supervisory position, correct?
Yes, it is.
And sergeants or people with that rank within MPD would serve in a variety of jobs or functions. Is that correct?
That is correct.
And how did you serve as a sergeant when you were first promoted?
I served as a investigator with the property crimes unit at that time.
How many people approximately did you supervise?
At that time, I did not supervise any. I worked as a detective or investigator alongside other detectives.
Okay. How long did you hold that position?
Approximately 2 years.
And after that?
Then I served as a sergeant in our Minneapolis Police Department Internal Affairs Unit.
Describe what a sergeant in Internal Affairs does.
Sergeant Internal Affairs is responsible for investigating cases of misconduct involving Minneapolis Police Department employees, and fact-finding, preparing reports, and ultimately submitting those to their supervisor.
Can those investigations include inappropriate uses of force or excessive force?
Yes, they can.
And have you ever evaluated an excessive force case in internal affairs context?
I believe I have, yes.
How long did you serve as a sergeant in internal affairs?
I served in that position about 2 years as well.
And then what did you do?
Then I was promoted to the rank of lieutenant.
Now, what was required of you to promote to lieutenant?
That also required taking a civil service exam, and I believe certainly at that time an assessment, going through an assessment center, which comprised of scenarios and different type of performance measures for that position.
Is it true that a lieutenant is it's a higher level of management above the first line sergeants?
Yes, our lieutenants are considered managers within the organization.
And what were your duties then as a lieutenant?
I served for a time as overseeing at that time, the federal mediation agreement that the Minneapolis Police Department had entered into with the Unity Community Mediation Team. And I also served time as a 4th Precinct lieutenant on the night shift.
Okay. And what is lieutenant in the 4th Precinct night shift? What do you do?
You have a team of sergeants and a team of officers on a shift. That particular shift worked the night hours in North Minneapolis, and really there as a lieutenant there to support the mission of the precinct inspector, who is kind of like the chief of that precinct, but also then to support your officers on the shift as well. Yes.
And how long did you hold that position?
That was probably about 2 years as well.
Seeing a pattern here. What happened after that?
After that, I was appointed to the rank of commander.
And what does a commander do?
Commander now, unlike the previous civil service positions, a commander now is appointed specifically by the chief of police, and it is a higher position, and the commander is usually in charge of a division. And so at that time, I was appointed to commander of the Internal Affairs Division.
And so you're now back to internal affairs, but more or less overseeing the entire operation?
That is correct.
And how long did you hold that position?
About 2 years.
Okay. And after that?
Then I was appointed as the first precinct inspector. And so that was a position in charge of the downtown precinct or first precinct. And that was a patrol function, so that was mainly patrol-related functions, even though we do have great civilian teams who work on things such as crime prevention and others, but I was appointed to first precinct inspector.
And what does the inspector do at that level?
The inspector at that level is really driving the work of the precinct, monitoring and working on trying to reduce crime in that precinct, working with its stakeholders, its neighborhood associations, its business community, making sure that whether it's investigative or patrol in the precinct, that they have the resources and things that they need, interfacing with the city council members of that particular ward. And so that is really a lot of the work that a precinct inspector does.
And does the precinct inspector then supervise, maybe not at the ground level, but is responsible for the supervision of all of the different positions underneath the inspector?
That is correct.
All right. And how long were you in that position?
About 2 years. Yes.
Okay. And after that?
Then I was appointed to be deputy chief of staff.
And what does a deputy chief do?
Deputy chief at that time was a unique role in that I was really chief of staff for the chief of police, a lot of work helping to support our department initiatives, reaching out to elected officials, community stakeholders, boosting up programs, grants that the department had received, and really carrying out the mission of the chief of police.
And from there?
After about 2 years, I was appointed to assistant chief of the Minneapolis Police Department.
And by whom were you appointed?
Then it was former Chief Janae Harteau.
And what did you do as the assistant chief?
That was really overseeing the day-to-day operations of the Minneapolis Police Department, and again, also supporting the chief.
And for approximately how long?
That may have been a little shorter, about a year or so, I think.
You've broken the pattern.
Yes. Yes.
And now, of course, you're the chief of police. How were you selected, or who selected you to be the chief of police?
Well, I served in an acting or an interim capacity, then under Mayor Betsy Hodges, and then after that term ended, then Mayor Fry of the city of Minneapolis appointed me as chief of police.
You may take that exhibit down. So you've had certainly, it seems, every rank available within the Minneapolis Police Department and a variety of roles. Is that right?
That is correct.
And as such, are you familiar generally with the day-to-day operations, I guess from the patrol level all the way up to the level you are now?
That is correct.
What I'd like you to do at this time is provide us with a little bit more information, sort of an overview of the Minneapolis Police Department and how it serves the city of Minneapolis. MPD's jurisdiction is within the geographic limits of Minneapolis, is that right?
Yes.
And what's the approximate geographic area that you have jurisdiction over?
Well, to the north, we border Brooklyn Park, Brooklyn Center. to the south of Richfield, to our east, just right up against the River St. Paul, and to the west, Golden Valley. And so it's a pretty large area.
Would you agree that's about 58 square miles, give or take?
Yes.
And are you aware of the current population of Minneapolis?
Roughly about 30,000.
How many sworn officers work for the Minneapolis Police Department?
Currently, around 700.
And as the chief, are you generally familiar with the officers who work for you? It's a lot of people.
It's a lot of people, and so it can be taxing to try to. We've got a lot of people that work in different areas, but I have a pretty good understanding of where folks are throughout the organization. Yes.
As we go on, I'll be asking you if you recognize some of the names of different people we may have met to this point, but at this time, up until May 26, 2020, an individual named Derek Chauvin was a Minneapolis police officer. Is that right?
That is correct.
And are you aware of who this person is?
I am.
Do you recognize this person in the courtroom today?
I do.
Would you please point to him and describe what he's wearing?
Yes. Mr. Chauvin's right there. He appears to be wearing a navy blue suit.
So I'd like you to please describe for the jury how MPD is structured to deploy law enforcement services to about 420,000 people over a 58 square mile area, 24 hours a day, every day. Administratively, how is the department organized?
Administratively, we are broken down into bureaus. And so, as I may have mentioned, you have the chief of police that really leads the organization and its mission and vision and goals. And then we have an assistant chief that oversees the day-to-day operations. After that, there are 3 deputy chiefs. And we have a deputy chief of patrol. The deputy chief of patrol is responsible for the 5 geographical precincts throughout the city of Minneapolis. We also have a deputy chief of professional standards, and that deputy chief oversees really 2 main functions, and that is our training for our entire department, as well as the internal affairs portion of our department. And then we have a deputy chief, the 3rd one, of investigations. So all of the employees who work, whether it's homicide unit, robbery, assault, that deputy chief oversees the investigations bureau. And we also have commanders who oversee these divisions. As I mentioned, they're above the civil service rank, they're appointed, and they serve in different divisions. And the precincts, as I mentioned, there's 5 geographical areas. We have 5 precinct inspectors, and they are like the chiefs of police for those precincts. Yes.
And so by my count, there were 3 bureaus. You have investigations, patrol, and professional standards. Is that right?
That is correct.
And the investigations bureau has a number of individual units within the bureau, correct?
That is correct.
For example, what type of units are within investigations?
Yeah, investigations bureau has homicide, assault, robbery, crimes against children. There are several different investigative units.
So within the investigative bureau, you mentioned homicide. That's where Lieutenant Zimmerman would work. Is that right?
That is correct.
Okay. And the patrol bureau, that provides services such as 911 response, like you did when you were a patrol officer. Is that right?
That's correct.
Crime prevention, traffic control, emergency services, all within the patrol bureau?
Yes.
And in individuals, sorry. And within the patrol bureau, in order to provide those patrol services over the geographic area, we've heard about precincts. Is that right?
Yes.
And if we could publish Exhibit 269. Okay, looking at exhibits 269, is this the geographic area of your jurisdiction?
Yes, it is.
And then can you just use 269 to describe the precincts and what they are and what purpose they serve?
Yes, this exhibit outlines the 5 geographical precincts, and this also lets our community know which precinct, based on where they happen to live, which precinct their residence or business is a part of. And so you're able to see from this map here, Sector 1 or Precinct 1 kind of is in the center there, covers downtown Cedar Riverside area. The sector, the number 4 at the top left-hand corner would be our North Minneapolis precinct. And then second precinct, number 2, covers southeast, northeast Minneapolis. And then 5th precinct covers southwest Minneapolis near the lakes area. And then the 3rd precinct covers our southeast Minneapolis area.
And focusing specifically on the 3rd precinct, I see it's divided further into these sectors. Is that right?
That is correct.
And that's for the purposes of being able to deploy patrol services, correct?
Yes.
Within the various precincts, this is primarily a tool for dispersing patrol officers, correct?
Yes.
But there are also investigative functions within the precincts as well, correct?
Yes.
That would be specifically assigned to that precinct?
Yes.
Okay. But professional standards, that would cover all of the precincts. Is that right?
Yes.
Okay. If we could publish 268, I'd like to focus specifically on the 3rd precinct. Oh, it's a little hard to see, but you can see the, that's much better. Thank you. You can see the different colors. It appears the sectors that we looked at in the previous exhibit are listed here. And if you take a look at Sector 1, that would be represented as 310 on the exhibit 268. Is that right?
Yes.
And then Sector 2 would be exhibit 320?
Yes.
All right. And we won't go through each of the sectors, but the purpose of these sectors, again, is to further distinguish different geographic areas within the 3rd precinct or any precinct, so we'd be able to have, say, dispatchers deploy law enforcement resources there. Is that right?
That is correct.
Dispatchers like Jenna Scurry, for example, could send a car to a particular location based on the different sectors that are within this precinct map. Is that right?
That is correct, yes.
And a Professional Standards Bureau, you can take that down, please. The Professional Standards Bureau, what does a Professional Standards Bureau do?
One of the functions is training. We have a commander, again, that is one of the appointed ranks, who oversees the training division, and they're responsible for making sure that not only are our officers in compliance with our mandated post-board educational requirements every year, but also really looking to make sure that we continue to evolve and that we're staying on top of necessary training that's important for us, that has a benefit to our communities that we serve. And so that's a core piece to what our professional standards training division does.
And so within professional standards, you have the training services, and that's staffed at the, I guess it's at the commander level, led at the commander level.
That is correct.
And who is the current commander of the training division?
The current commander for the Minneapolis Training Division is Commander Darcy Horn.
Last year, who was your commander?
Last year, she's now Inspector Katie Blackwell, but she was Commander Katie Blackwell last year when she led our training.
And she would have been the training commander on May 25, 2020. Is that right?
That is correct.
Okay. There's other divisions within professional standards. I think you mentioned internal affairs, but there's also an administrative services division. Is that right?
Yes.
And what does the administrative services division do?
Administrative Services Division can deal with everything from grants different types of programs that the city of Minneapolis is embarking upon, employee personnel matters as well.
Also, business software and equipment.
Technology, business software, yes.
Body cameras, milestone cameras.
Yes.
And we met Jeff Rugel, and that's where he works. Is that right?
Yes, Lieutenant Rugel is part of that. Yes.
I'd like to talk to you a little bit about the Minneapolis Police Department and reacting to calls for service. The role of the Minneapolis Police Department is generally to serve the community's law enforcement needs. Is that right?
That's correct.
And most requests for service come in through the 911 system. Is that right?
Yes.
And you respond, or officers respond to different calls for service. Could you please describe the types of calls for service Minneapolis Police Department commonly responds to?
Calls for service can absolutely range from everything from tenant trouble to a loud party dispute to domestic assault to shooting and to even homicide. So it can really range from a wide variety of types of calls.
People will call to report a crime and request assistance. Is that
Yes.
right? People also call to report, just general emergencies.
Yes, they can.
What type of emergencies?
Medical emergencies. They can request calls for service for that. Oftentimes we have community who are calling because it may be 3 o'clock in the morning and they don't know of any other service or who will respond, but they will call us for those types of situations as well.
And I suppose what constitutes an emergency is in the eye of the caller somewhat?
That's correct, yes.
But nonetheless, MPD responds.
Yes.
Do you know approximately how many calls for service the Minneapolis Police Department receives annually?
It's usually a couple of 100,000, and then we also have officers that we categorize as self-initiated activity. So that could mean an officer happens to be driving through a neighborhood and sees something and reports out on their radio that they're going to look into it. So it's a combination, but it's a lot of calls.
And generally people don't call the police department to say, hey, everything's going great. Just wanted you to know they have something that they want you to do.
Exactly, yes.
It sounds then like it's fair to say there's more to policing than just going out and arresting people. You provide a broad spectrum of policing services to the community.
Yeah, I would actually say that the actual law enforcement part is probably pretty small compared to most of the types of calls our officers are being called to address and deal with. Yeah.
So we've touched on police training, your own personal police training, and how police training is dispensed, I guess, through the Professional Standards Bureau. I'd like you to describe that a little bit further. Are you generally familiar with the types of training that the Minneapolis Police Department provides its officers?
Yes, I am.
Where does this training take place?
We have a large facility located in North Minneapolis, which we call our Special Operations Center. And that is where the vast majority of our required training takes place.
Is the Special Operations Center then a dedicated building only for training purposes?
It's primarily dedicated for training purposes, yes.
And I think you testified it's supervised by a commander. I'd like you to tell the jury a little bit about when now currently training begins for a Minneapolis police officer who's hired on to the department.
For a new officer who's hired onto the department, that first initial orientation to our training begins at the academy. And that again is overseen by the commander of the training unit. And we actually have a class currently in place now at the academy, at the SOC. And so that first initial indoctrination to our academy occurs during that first part of the training at the academy.
Fair to say that the training that's provided to Minneapolis police officers can be generally divided into two categories: pre-service training and post-service training. Is that right?
Yes.
And the pre-service training would include the academy that you just talked about. Is that right?
That is correct.
And then post-service training is the continuing education that you testified about previously. Is that right?
Yes.
So let's again focus on the academy training. How many cadets do you generally have at a given time per class?
Well, it's usually been a mixture of recruit classes and a cadet class. I would say that we average in terms of recruit class numbers around 30. Cadets might be 20 to 25.
So now I'm going to ask you to just define some terms a little and explain to the jury the difference between a recruit and a cadet.
Recruits are typically individuals who've already been laser focused on a career. Being a Minneapolis police officer is what I wanted to do. They typically have already at least their 2-year criminal justice or law enforcement degree. Most have completed their required skills training. Cadet was really created to capture diversity of candidates. And so the cadet might have individuals who may have had a psychology degree, but it's really streamlining them in. It's a little lengthier process, but it's really getting them on board so that they meet the state requirements, the post requirements to get to be hired. And so the cadet program is a wonderful way for us to capture diversity within our police department. And so, but they both, once their programs are finished, they're both classes, whether you're a recruit or cadet, you are ready to successfully become a Minneapolis police officer.
Do you also take lateral candidates?
Yes, lateral candidates. We certainly have had hirings of laterals in the years past, yes.
And do those individuals also go through a similar training as a recruit?
Yes, the laterals can. It's usually much smaller in length of time just because laterals are individuals who've already served as police officers, perhaps in another jurisdiction or another part of the state, or out of state, actually.
We'll get a more detailed description from another witness, but just at a very high level, can you describe what the trainees do at the academy during this pre-service training?
Trainees at the academy during pre-service, it's their first indoctrination into this world of being a police officer. So they're being taught about city and statutory laws. They're being trained on procedural justice and critical thinking, defensive tactics. They're having community members come in and speak to them about different aspects, whether it relates to things in our cultures within our city. Technology is a huge piece to that. Learning how to write reports on our computers. They're really getting that basic indoctrination into the Minneapolis Police Department.
As far as the methodology, is it typically classroom delivery? Do you also have practical application? How does that work?
Yeah, it's a layered approach. It's both the practical academic studying, examinations that occur, but it's also scenario based. And so there's scenarios that they will go through, and whether that's crisis intervention training or other aspects. So it's a layered approach to the training.
And in this pre-service training, then, once the officer or candidate has completed the pre-service training, what's the next phase before becoming a fully functioning police officer?
Once they complete that training, they're making sure, obviously, that they've met the requirement for the licensure for the Minnesota Post Board, and then ultimately they're going to get sworn in and hired on as Minneapolis police officers.
Are you familiar with a program called the Field Training Program, or FTO?
Yes, I am.
Is that part of the pre-service training?
That would be, yes.
Can you just give us a general description of what the FTO, or Field Training Program, is?
The Minneapolis Field Training Officer Program is really, once the recruit has gone through that series of pre-service training, it's now teaming them up with a mentor, basically. And they're being gauged and judged on certain performance measures. And it takes course over a period of several months, usually about 5 months. And they're given instruction. They're seeing how well they are able to handle certain types of situations, calls. And they're also having feedback, not only from their FTO, but they're also having conversations with the supervisors in the training bureau and seeing how they're doing. They're assessing their progression. In the event a candidate is not progressing, they're making sure that there's support mechanisms for that, where they need extra help. And yes, at times, we have candidates that don't successfully complete it. And so, but that's really getting them to the point where they can ultimately be really on their own and be able to function on their own as a sworn Minneapolis police officer.
Okay. And so once they've completed the field training program, and I think is, per your testimony thus far, the training doesn't stop there. You have post requirements that you have to fulfill every year in your post-service training. Is that right?
That is correct.
And is that delivered through a series of in-service things that are at the same training facility you mentioned?
Yes.
Is that training optional? Can an officer go somewhere else to get their post credits and skip the in-service, or is that training required?
That training is required annually.
Do you have to take it?
Yes, I do.
What type of training is provided in the post-service training?
Some of the training that is provided in the annual training can be critical incident training, CIT training.
CIT is crisis intervention training?
Crisis intervention training, thank you. Yes, crisis intervention training, defensive tactics, basic CPR or first aid. Those are some of the types of training that is required annually. Yeah.
Even though they've already ostensibly been trained on all of these things before, you're still doing the same training annually?
That is correct.
Why is that?
A lot of that is just to reemphasize the importance of the training itself, muscle memory, because all of our department members are being taught the same thing. We may have officers that are working in patrol capacity one year, and the next year they may be in investigations, but they may be called to assist upon. And so it's making sure that all of us have that basic necessary core fundamental training to better help serve our communities.
So if you could give the jury kind of an idea of the amount of time that is spent training your officers.
It's a lot. We put a lot of time, energy, and resources into our training. I believe last year, the Minneapolis Police Department, in terms of our mandatory in-service training and leadership training, we probably spent about $8.5 million. In our pre-service and in-service training, that was probably about $4.5 million. So training is absolutely vitally essential to us as a department.
And officers are paid while they're being trained, is that correct?
Yes, they are.
And would it be fair to say that part of the objective of training is to impart Minneapolis Police Departmental policies onto the officers so that they know what those policies are and are able to apply them?
Yes, it's important through training that we're reemphasizing not only our policies but really our values as a police department and what our community expects of us. It's to help our officers, and it's also to help our communities at the same time.
As a former patrol officer who's used force, put handcuffs on people, I mean, you understand the reality of what policing is like when you're actually on duty. Is that right?
That is correct.
You also testified that you've participated and continue to participate in the training that's been provided by MPD and has continued to be provided. Is that right?
Yes, that is correct.
Is this training practical and useful?
Yes, it is.
Why do you say that?
Our officers are being called, particularly patrol officers, are being called to, again, respond in a way to our community's needs. And it's hundreds of thousands of calls that they respond to. And, we are a very interesting profession in that to some professions, your body of work matters. And to an extent, within the Minneapolis Police Department, our body of work matters, but it's more internally. But to our communities, for the most part, your body of work doesn't hold as much value. We don't have the luxury of being able to go up to a community member for the first time and say, you know, those 99 calls I was on before went really well. Trust me on this one. We don't have the luxury of doing that. Our communities are going, no, what have you done for me lately? This interaction, I'm going to grade you on how you treat me during this call, during this interaction. And so we have to make each engagement with our community count. And so the training is very important because for many in our communities, the first time that they encounter a Minneapolis police officer may be the only time in their life they do. And so that singular incident matters.
Aside from the usefulness of it to the community, what about the usefulness of it from a practical standpoint to the patrol officer out on the street? Is this training practical, or is it more aspirational?
No, it's very practical. And as I had mentioned earlier, it's so important that we evolve as a police department and meet our communities where they are. And I'll give a couple examples if you don't mind. We've talked a lot about within the department that we know that our communities suffer at times and go through trauma. So it's very important for our men and women to have training as it relates to how we respond in those moments. What resources can we provide for community? But one of the things that we have not talked about in this profession, and sadly, is the impacts of trauma on our own officers. And so wellness, we do a great deal of training and work on officer wellness because we need to make sure that our officers are well when they're interacting with our communities in that regard. I will also tell you, a few years ago, we were hearing from members of our transgender community and how they had felt police have played a role in their lives, and not always good, quite frankly. And so we were able to, through conversation, through discussion, through meetings, being very authentic, we were able to sit and craft a policy based upon members of our transgender, gender nonconforming community really guiding that. And we had the first policy ever in that. And so, again, it's so important that we as a police agency continue to evolve, continue to place value on all of our community members. And so that's very important.
Now, speaking of Minneapolis police policies, you're aware that the police department has a fairly extensive policy and procedure manual. It's pretty thick, correct?
Yes.
And is it important then for policies and procedures to be in a written form so that officers can understand what the expectations are?
Yes, it is.
And those are public documents so that the public, they're also able to see what the expectations of the police officers are, correct?
That is correct.
As the chief of police and being employed by MPD as long as you have, I take it you're familiar with the Minneapolis Police Department policy and procedure manuals and all the content contained inside?
Yes.
You in fact created some of these policies?
That is correct.
Are Minneapolis police officers required to be familiar with the various written policies?
Yes, we are.
And there's a policy requiring them to be familiar with the policies, correct?
Yes, that is correct.
All right. So if you would please publish Exhibit 207. If you would highlight Section 1-103. Okay. This is the policy about the policy, and it requires that the MPD employees shall be provided instructions on how to access the policy and procedure manual. Is that right?
That is correct.
And they're accountable for knowing how and where to access, and for knowing the contents of the manual. Is that right?
That is correct.
And they're also required to sign a receipt acknowledging their responsibility for knowing the contents of the manual, correct?
Yes.
Because, the first policy manual that you would receive as a patrol officer might not be 30 years later, what you're going to be looking at, correct?
Yes.
The policies are changing, but they're published, they're public, and the officers are required to know what they are and to sign something saying that they will continue to review them. Is that right?
It's preliminary, overruled.
Yes.
All right. Well, if you could take that one down, please. At this time, asked to just display to the witness Exhibit 274 for identification. Sir, do you recognize this is a general form here of being an electronic version of the MPD Policy and Procedure Manual acknowledgement?
Yes, I do.
This is an example of an acknowledgement form that a Minneapolis Police Department employee patrol officer would sign upon being hired. Is that right?
Yes.
Just indicating that they're aware that there are written policies and committing to reviewing them and accessing them. Is that right?
Yes.
At this time, I'm going to offer Exhibit 274.
Welcome everyone here to News Now from Fox. Current sidebar happening right here with the defense team, as it looks like prosecution is going to put some more evidence there into the trial. And it looks like they're now talking with each other right here. And if you're just joining us here, we do have the Minneapolis Police Chief currently on the stand right now. Prosecution continuing to ask questions to the police chief. We were hearing all about the credentials of the police chief. Now we are going into some of the training aspects for a police officer, as well as other big details. Looks like we could have another potential sidebar.
$274 is received.
All right, if we could then publish Exhibit 274 to the jury. And you see this is, again, one of the forms that was signed by a particular officer upon hire. And if you could please highlight the name. And that's signed by Derek Chauvin, Derek Chauvin, badge 1087, December 28, 2001. Is that correct?
Yes.
If you could take that down, please. Minneapolis Police Department has a code of ethics. Is that right?
Yes.
And the code of ethics is contained within the policy manual. Forgive me, we're going to be talking a lot about the policy manual and kind of march through some of these, but the code of ethics, if you could please display Exhibit 215, page 2, and if you could highlight 5-10201. And as the Code of Ethics provides in the policy manual, law enforcement officers' fundamental duty to serve mankind and safeguard lives and property, and to protect the innocent against deception and the weak against oppression and intimidation. Is that right?
That is correct.
And if you could take that down, Minneapolis Police Department also has a professional policing policy. Is that right?
Yes.
At a high level, can you describe what professional policing means in this context?
Yes, our Minneapolis Police Department professional policing, it's really about treating people with dignity and respect, above all else, at the highest level. It's that we see each other as necessary, we value one another, and it's really treating people with the dignity and respect they deserve.
If we could display then Exhibit 215. And drawing your attention to page 4, section 5-104.01. Sir, is this the professional policing policy?
Yes, it is.
And could you read the first bullet, please?
The first bullet reads, "Be courteous, respectful, polite, and professional."
And if you would then also read the third bullet.
Ensure that the length of any detention is no longer than necessary to take appropriate action for the known or suspected offense.
And you can take that down, please. Sir, fair to say that law enforcement generally has changed a lot since you started back in 1989, is that right?
That is correct.
1989, you didn't have body-worn cameras, correct?
That is correct.
And nor did you have sort of the ability for civilians, bystanders, to video or record conduct of police officers, right?
We did not.
Because we didn't have smartphones.
That's true.
And now we do.
Yes.
And as you indicated, the policies and culture of the police department has to change with the times, is that right?
Yes.
And so in terms of understanding that sometimes bystanders do use their smartphones to take video images of police officers, has the Minneapolis Police Department imparted any training or constructed any policies to prepare officers for people recording them?
Yes, we have. We've imparted policy that really is informing officers that individuals under their First Amendment rights, they have the absolute First Amendment right to record through cell phone video or other types of video officers interacting or engaging with a community member, with the exception that they cannot obstruct the activity of the officers, but they absolutely have the right, barring that, to record us performing our duties.
And what does obstruct mean in this context?
Obstruct would mean interfering, doing something where you are physically placing yourself in a position where you're prohibiting the officers for carrying out their lawful duties. But barring that, individuals have the right to record our engagement with our community.
Well, Chief, you'd have to acknowledge that a patrol officer may find it irritating to have a civilian recording their activities. True?
Very true.
Is that obstruction?
It is not.
At this time, I'd like to display to the witness only Exhibit 273. And if I may step away for a moment. And at this time, I will offer Exhibit 273.
Any objection?
No objection.
273 is received.
If you would publish 273, and I'd like to draw your attention to Section 9-202. And again, this is the public recording of police activities, providing employees guidance with dealing with members of the public, recording them. Is that right?
Yes, it is.
Okay. And generally, this informs officers that unless you're being obstructed, people get to record you.
Yes.
Even if you don't like it.
That is correct.
And how long has this been policy of MPD?
Since May of 2016.
All right. Thank you. You can take that down. Sir, are you familiar with the concept of de-escalation?
Yes.
What is de-escalation?
De-escalation is providing a knowledge base or skills, in this case for officers, to really focus on time, options, and resources. It's really primarily trying to provide an opportunity to stabilize a situation, to de-escalate it, and with the goal is having a safe and peaceful outcome. And so there's tools associated with that, but that's really the goal of de-escalation: time, options, and resources, so that we can stabilize the situation peacefully and safely.
When you think of de-escalation, are you thinking of it as the sort of the opposite of using force, or is it a part of using force?
We teach it as both.
And when you started with the department back in 1989, was there an emphasis on de-escalation?
It was not mentioned. It's not heard of back then.
Okay. When did de-escalation start becoming more of a topic of conversation in law enforcement communities?
I think that right around late 90s, 2000, I think that when we were when there was attention, not only in Minneapolis, but in departments across the country, and incidents particularly involving police encounters with those who were suffering from mental illness, we really started to see a lot of work on that. Here locally, the Barbara Schneider Foundation, there was a very tragic incident in Minneapolis many years ago that involved the death of a community member. But when we started, that was really what kind of culminated for our department, de-escalation. And even when you heard departments starting to talk about other tools like tasers, all of these types of things, it was around that time frame that I think our department really started getting a lot more education, awareness, and training as it relates to de-escalation.
What about just, even if you weren't taught de-escalation formally when you started back in 1989, as a practical matter in practice, is that something that's been employed by experienced police officers for a long time now?
Yes, it has.
What about in your own experience when you were on patrol? Did you use de-escalation techniques?
Yes, quite a bit. Yes.
And did you find them to be effective, a way to maybe talk somebody down from a situation rather than needing to use force?
Yes, and with the primary goal is that you want to keep yourself safe as an officer, and you also want to keep the community safe. And so a lot of it hinged on communication and listening and verbal skills. And so if you could talk your way out of a situation to de-escalate where it didn't have to result in physical force, those were things you certainly utilized, and you were always in a better position to look upon someone that you worked with who had that skill set to do that.
But if you can't talk somebody out of the situation, if you can't de-escalate, you can't, right? And you have to then use a different method.
That is true.
And so it really comes to what's reasonable at the time. Is that right?
Yes.
Does Minneapolis Police Department currently have a de-escalation policy?
We do.
And at this time, if I can display Exhibit 219. You have this one, okay. I think it is admitted, I just want to make sure you have it. Okay. Yes, if we could publish Exhibit 219. And then Minneapolis Police Department Policy 5-304, threatening the use of force and de-escalation. This is the policy, and it's a policy as it existed on May 25, 2020. Is that right?
That is correct.
If we could highlight the first paragraph A, threatening the use of force. And I'd like you, sir, to please just read into the record the paragraph that you see here. All the way up until the first sentence. I won't make you read the whole thing.
As an alternative and/or the precursor to the actual use of force, MPD officers shall consider verbally announcing their intent to use force, including displaying an authorized weapon as a threat of force, when reasonable under the circumstances.
And I guess, is it an either-or alternative? Is it like you either de-escalate or use force, and once you start using force, you just give up on de-escalation?
The goal is to resolve the situation as safely as possible. So you want to always have de-escalation layered into those actions of using force.
And if you could take that down and highlight paragraph B, de-escalation. In accordance with the policy, officers, the language here is mandatory when reasonable, whenever reasonable, shall use de-escalation tactics to gain voluntary compliance. Is that right?
Yes.
And to seek to avoid or to minimize the use of physical force, correct?
Yes.
And seeking to minimize physical force, that can be happening while physical force is being employed, can't it?
Yes.
An officer can be using physical force and during the course of that still maintain attempts to de-escalate and defuse the situation.
Yes.
Okay. And if you could clear that, please. And as part of a de-escalation, the policy indicates the officers are supposed to do what?
Attempt to slow down or stabilize the situation so that more time, options, and resources are available.
When you talk about more time, options, and resources, could options and resources include, for example, using other officers who may be at the scene?
Yes.
Or calling for backup?
Yes. Actually, it can also include seeking community's help in a situation as well.
And in employing de-escalation techniques, in accordance with the policy, the officer is required to consider a number of factors regarding the subject. Is that right?
Yes.
And we're assuming here that the subject is non-compliant. You run into people who, maybe don't want to comply with police officers, but you can also run into people who just, for some reason, are unable to do so at that moment. Is that right?
Yes.
And officers are required to consider, if you could highlight B and the bullets that come underneath. The officers under the Minneapolis de-escalation policy are required to consider whether the subject's lack of compliance is a deliberate attempt to resist or an inability. Is that right?
Yes.
And if you could read, first, the first bullet is medical conditions, correct?
Yes.
We have mental impairment, developmental disability, physical limitation. Some of you may just be physically unable to comply, correct?
Yes.
Language barrier. The city of Minneapolis has a variety of people who speak a variety of different languages. Someone just may not understand you, right?
That is correct.
And if you're not considering that, perhaps the situation could escalate into something greater than it would need to be.
Yes.
The last two bullets, first, could you read the second to the last bullet?
Yes. One of the other considerations officers should take into account is the influence of drug or alcohol use.
How so?
We know the research says that people can react differently when they're under the use of alcohol or drugs. And so you trying to give verbal commands, if someone's under the use of alcohol or drugs or you're doing force, it may have a different reaction to them. So that should be something that you should be considering.
And 12:30. Sir, drug or alcohol use, in this context is being required that the officer consider to determine if de-escalation is appropriate. It can be true that some people who are under the influence of drugs or alcohol can become dangerous, correct?
That is correct.
But isn't it also true that some people react completely different and they are not necessarily dangerous if they're under the influence of alcohol or drugs?
That is correct.
In fact, they may not be more dangerous, they may actually be more vulnerable.
True.
And it's important that the officer considers that
when determining whether to go the route of force or continued force or de-escalation. Fair?
Yes.
Behavioral crisis is the last bullet I'd like you to discuss. What do you mean by behavioral crisis?
Behavioral crisis, of all the bullets, sometimes that is probably the one that our men and women experience in our communities most. If someone loses a job, that can trigger a behavioral crisis. If someone loses a loved one, that can trigger a behavioral crisis. If someone has themselves got the worst diagnosis from their doctor that day, that can trigger a behavioral crisis. And so we want our folks to take all of those things into consideration. When I talk about meeting our community where they are, that's probably the one that we need to really focus on. Yeah.
And as you testified earlier, the police just don't get to meet people on their very best day, do they?
No, they don't.
And the behavioral crisis, as the kind you've described here, can in fact be a barrier to compliance. Would cause an inability to comply, even if not, an intentional inability to comply. That's fair.
Let's go to list, Lena, please.
Yeah.
Thank you.
And so the purpose of the listing a behavioral crisis as a point of consideration for a law enforcement officer is what?
Again, it's recognizing that when we get the call from our communities, it may not often be their best day, and they may be experiencing something that is very traumatic. But we're going to respond, but we have to take that into consideration because, as I mentioned again, we may be the first and last time they have an interaction with a Minneapolis police officer, and so we have to make it count. It matters.
Would this be a good time to stop before I go to the next line? I'm sorry, I was trying to push it to the time limit. So.
All right, members of the jury, we'll take our lunch break, come back at 1:30. Chief, you may step down.
All right, lunch break is currently underway right now as the prosecution will continue on the other side of that lunch break. You're watching News Now from Fox. Hi, everyone. Mike Pace here. Thank you so much for joining us here. Let's get some analysis of what we just saw from the police chief as well as the other witness of the day, the ER doctor. Let's bring in Ben Taylor, attorney, and always giving us some great legal setups and really advice here as we are seeing the remarks here on this day 6. We are in the week 2 version here of this trial. Thank you so much for joining us here today, Ben, as always. All right, Bennett, hold on. It looks like we're having some audio issues here with you. We see your shot rate, but the audio not bouncing. Are you muted on your end, by chance? All right, we'll try to work that. Give us a second there, Ben. We'll try to work it maybe on our end here. Let's take a quick 2-minute break, and then we'll try to reconnect there with that audio. You're watching News Now from Fox, currently looking at a White House briefing that will be coming up in just a little bit. Stay right here with us.
I felt that hypoxia was one of the more likely possibilities.
And hypoxia as an explanation for his cardiac arrest, meaning oxygen insufficiency.
Correct.
Now, under cross-examination from the defense, Dr. Langenfeld said fentanyl could cause a person to stop breathing and could have led to the high carbon dioxide level in Floyd's blood.
You were discussing hypoxia kind of being consistent with asphyxiation, right?
Correct.
Hypoxia is the lack of oxygen to the brain, correct?
Correct.
And there are many things that cause hypoxia that would still be considered asphyxiation. Agreed?
Correct.
Drug use. Certain drugs can cause hypoxia. Agreed?
Yes.
Specifically fentanyl.
That's correct.
How about methamphetamine?
It can.
Combination of the two?
Yes.
And that's important cross-examination because toxicology reports showed that George Floyd did have traces of fentanyl in his bloodstream. We're going to have
Welcome back, everyone, here to News Now from Fox. We appreciate everyone joining us, as always, worldwide here. And we are in a break there for the Derek Chauvin trial. So what we will do is show some other news here of the day that we want to get to. And I just want to show you that we will be having a White House news briefing in just a little bit. But really one of the big stories here today was Representative Matt Gaetz, his former assistant, spoke to the news media because he was interviewed by the FBI the other day and wanted to talk about the allegations against his former boss. Let's listen to this right here on News Now from Fox.
I'm going to be very brief. My name is Nathan Nelson. I was the former director of military affairs for Congressman Matt Gaetz. Last Wednesday afternoon, 2 members of the FBI came to my house unannounced to question me about allegations surrounding Congressman Gaetz. They told me that members of the media reached out to them asserting that I had previous knowledge of Congressman Gaetz' involvement in illegal activities. They asserted that because of that knowledge, I resigned my position as the director of military affairs. I'm here this morning to state that nothing could be further from the truth. Neither I nor any other member of Congressman Gaetz' staff had any knowledge of illegal activities. I've known the congressman for over 6 years when he was a state rep in the Florida House. I worked with him for 4 years as his director of military affairs. Everybody here in Northwest Florida and the defense community knows that I had a planned departure. I left to continue supporting the military mission in a private capacity, helping to align the Department of Defense, defense industry, and academia for workforce development here in the Panhandle. This baseless claim against me leaves me further convinced that the allegations against Congressman Gaetz are likewise fabricated and merely an attempt to discredit a very vocal conservative. I welcome any other questions.
Well, what evidence have you seen so far, sir?
I'm not here to provide any degree of evidence in support of Congressman Gaetz, only to discredit these baseless allegations.
Well, that's the reason I'm asking, sir. If you are trying to discredit any kind of investigation or anything, what of the investigation do you know that can lead you to would lead you to discredit the investigation?
I don't have any specific knowledge on the investigation or any of the facts that are involved with the investigation.
Now, you left in November?
End of October, that's correct.
Okay.
Yeah.
All right. And why'd you leave that?
So, like I said, I had a planned departure. My involvement now is to continue supporting the military mission, to help align our community to support the defense mission here in Northwest Florida.
Have you been in contact with the representative or with the FBI, since that initial encounter?
The FBI hasn't reached back out to me since Wednesday.
Next question. Will you tell me why you are the best person to be speaking today? Did the communications department or Mr. Gates' office ask you to come today, or how were you selected to do this press conference today?
I reached out to the congressman's office to let them know that the FBI came to the house. and to ask them if they had any other information regarding the media's claims and where any of that came from. Also to inform them that, hey, here's what I communicated regarding former staff members, my interactions with the staff that exist, just so that they have firsthand knowledge as to what I specifically said. It's clear that, there are people out there that are making baseless allegations. I wanted to make sure that my words were direct from my mouth. Yeah. So we have not received a grant from the Triumph Corporation. We did an initial pre-application and found out that it was not appropriate for Triumph, which is fine. We're trying to do some startup here to bring a reutilized DoD supercomputer to Northwest Florida to help bolster the weapons development enterprise here.
Have you talked at all to the Department of Justice? Have they reached out to you?
Just the FBI that came to the house.
Do you have in your official capacity with a basis office or personally, do you have any interaction with Joe Greenberg, the tax controller out of Seminole County?
That was Nathan Nelson, a former director of military affairs for Representative Matt Gaetz, pushed back against the FBI after he's had two agents questioning him as part of an ongoing investigation of the congressman. Let's take a quick 2-minute break here on News Now from Fox. When we come back, we'll take you out to the White House briefing.
On, including 31 Republicans. Senior White House officials have briefed bipartisan working groups in both chambers, including the group of 20 senators and the Problem Solvers Caucus. And as I noted, the President looks forward to welcoming members when they return next week. With that, Alex, go ahead.
Great, thanks. I have a couple of questions on the infrastructure and jobs plan, and one on immigration.
Okay.
To start, the jobs plan has been receiving opposition from both the left and the right. On the right this weekend, Senator Roy Blunt said that it would be an easy bipartisan win if the bill were more narrowly focused. So why not reduce the bill down to just infrastructure and take out planks like the care workers and the electric vehicle aspects? And then in addition to that, on the left, Senator Joe Manchin said today that he can't support a 28% tax increase on corporations. So is the White House open to lowering that? He said the highest he would support is 25%.
Well, first on the infrastructure question, let me say that some Republicans who have been vocal think investing in water systems and replacing pipes so Americans can have clean drinking water is not infrastructure, but the president does. Some don't think investing in high-speed rail is infrastructure. The president does. Some believe building charging stations to support America's electric vehicle future is not infrastructure. He believes it is. Some don't believe that America's broadband capacity, which is 1/3 of the American people, I should say, don't have access to broadband, and improving those lines and expanding that access is not infrastructure. The president does. Some believe that addressing the issue of America's supply chain so that we're never again at the mercy of China or any other nation is not investing in infrastructure. The president disagrees. Some don't believe that rebuilding schools so that they're safe and asbestos-free is investing in infrastructure. The president disagrees. And finally, some don't think that building a support system to take care of elderly parents or kids with disabilities at home so people can go back into the workforce. Some of those 2 million women who have left the workforce during the pandemic, some think that that is not investing in the infrastructure, our workforce of this country that are the backbone of this country. The president disagrees. But with all that being said, he welcomes their ideas, hopes they put them forward, and he looks forward to having conversations with members of both parties about how to address the long outdated effort to update our infrastructure.
And then on Manchin, is the White House open to reducing the corporate tax rate?
Well, first, the president felt it was responsible to propose a way to pay for his proposal. That's exactly what he did. He knows some members think it's too big, some think it's too small. Frankly, there have been folks who have come out on both sides, which we fully expected. He knows that some will come forward with different ways to pay for this package, and some may have views that it shouldn't be paid for at all. So we fully expect that from Senator Manchin and other members, and we expect the question of how to pay for the package, if we should pay for the package, to be part of the discussion moving forward.
The White House is open to that conversation.
We're open to hearing ideas and proposals from members, and we encourage them to put them forward.
And then on immigration.
Let's take a quick 2-minute break here on News Now from Fox.
At the border with respect to unaccompanied minors. So does this poll suggest that the president needs to reevaluate his approach to that issue?
Well, if I read the poll correctly, it also had 59% of Americans believing that unaccompanied children should be treated safely and be protected in that way, and 65% supported the reunification of families. There's no question this is a difficult challenge, and the president believes he was elected to address hard problems. And his focus right now is on expediting processing at the border, opening up additional facilities, addressing the root causes, and restarting programs to incentivize kids from applying from within their countries. So that's his focus right now.
Is the issue just a messaging issue then? I mean, how do you explain the fact that Americans are not in favor of what the president is doing at the border?
I'm not sure that's an accurate depiction of the poll, given that there was about 1/3 of the people who replied didn't have an opinion at all. So
40% said that they did not approve though.
Fair, but also 1/3 said they had no view. So I think that right now our focus is not on looking at the poll. It is on implementing solutions, which is no question to address what we view as no question a difficult challenge, and hoping that we can ensure we are protecting these kids. We are continuing to reassert to the region. The border is not open. The majority of adults who come to the border are turned away. Continuing to implement programs in the region, whether it's working with them to address root causes or working with them to restart programs that can help kids from apply within country, that we feel those are the ways we can help address what is no question a challenging issue. Go ahead.
Thanks. First, I want to ask about the budget. What's the holdup on releasing it?
We expect it to be soon. It's not the full budget, as you know, but just for clarity purposes, it's a kind of discretionary guidance. But we hope it to be soon. That it will be soon. We expect it to be very soon. I don't have a timeline on that quite yet.
Well, every previous White House has released at least a budget blueprint or an outline, abbreviated budget, by the end of February. So what's the holdup here? Why is the delay now stretching into April?
Well, there's no question, as we talked about during the transition, that we dealt with some impactful intransigence from the outgoing political appointees. We had some cooperation from the career staff, but we didn't have all of the information that we needed. As you all know, we also don't have a budget director. We have not had a budget director confirmed. We have now an acting budget director, which is an important step forward. But again, we expect it to be soon, and as soon as we have a timeline, we will make sure you all know.
I also wanted to ask you a question about Major League Baseball. The league decided to move its All-Star game out of Atlanta. That's something that the president said he supported before. Does he then agree with their decision to move that game out of Atlanta under the voting law?
Well, I wish I had this with me on Friday, because I got asked a question, and there's just some help, what I thought would be helpful context, and I know you probably don't have the transcript in front of you. So when the president was asked during an ESPN interview last week, he was asked the question, last week, Major League Baseball Players Association executive director said that he would look forward to discussing moving the All-Star game from Atlanta in the wake of Georgia's governor signing into law a bill passed by the Republican-led state legislature to overhaul how its state elections are run. How do you view this possibility of moving the All-Star game out of Georgia? And he said, quote, "I think today's professional athletes are acting incredibly responsible. I would strongly support them doing that." So he was not dictating for what Major League Baseball should do, that they should, dictating they should move the All-Star game. That was their decision. They made that decision, and as he stated earlier, he certainly supports that.
So he does support the decision to move the game then?
Well, he supports them being able to make the decision and respond to what their players' asks are, given many of them are impacted, of course, by these laws.
Okay, and then just one more on vaccines.
Mm-hmm.
So there's a report over the weekend that Governor DeSantis in Florida had been dealing with some sort of improper dealings with the supermarket chain Publix as far as distributing the vaccine. So did those reports give the White House any pause in working with Governor DeSantis in the vaccine program?
Well, first let me say that for those who weren't following this in Florida, one of the concerns we've had as we've watched the data is that 17% of Florida's population is African American, but less than 7% of vaccinations have gone to African Americans in the state. That's one of the reasons that we opened 4 FEMA sites in Miami, Tampa, Jacksonville, and Orlando. And these sites disproportionately serve communities of color. So we've been closely watching this data and these statistics as we would in any state across the country. And we took these specific actions for that purpose. We are not going to hurt the people of Florida just because of the steps or actions of leadership, and we will continue to take actions to ensure that the vaccine is equitably distributed. Go ahead.
Just to follow up on the baseball all-star game, I know that you made the point that he did not dictate the league move the all-star game out of Georgia, but he likes to say the words of a president matter. He said he would strongly support if players in the league wanted to do that, and they did it. So does he think that the PGA should move the Masters tournament that begins this week out of Georgia?
I'm not here to call for anyone on behalf of the president or the vice president or anyone to take steps in reaction to the law in Georgia. The president was asked a direct question, and the context of the question was also around the league meeting to discuss this exact issue, and he answered the question.
So then should we believe that if PGA Tour players who are arriving in Augusta this week or today to register for the tournament, if they got together and decided or talked about not participating, that is something he would strongly support? Or is there a difference between...
I'm sure you will ask me that question or him this question, but our focus is on doing what we can to advocate for making voting easier and more accessible around the country. And that's where our efforts are going to be from the White House.
Before the president said that he would strongly support moving the All-Star game out of Georgia, did he consider the economic impact? Because the Cobb County tourism CEO is saying they're going to lose $100 million in lost business activity, 8,000 hotel rooms. Did he think about that before he said he would strongly support the move?
Again, he was doing an interview. He was given the context, as I just read out to you in full detail of how the question was asked. He answered the question.
Okay, on immigration, 171,000 migrants were caught at the border in March. That's up from 100,000 in February. If the trend continues, do you have a sense of how many migrants the United States can handle this month?
Well, first let me say that there have been numbers that have been reported out there. CBP has not released their final numbers. We expect that to happen later this week. And for full context, there are numbers that when they release them will be out, like you cited, some version of what you cited. But those are reflecting of people coming, and we should also be reflecting, and I hope I'm encouraging people to do this, people who are turned away. Because again, single adults, based on your own reporting and everyone's reporting, the vast majority continue to be turned away at the border. I don't have any predictions about numbers that will come. We're obviously taking steps, as I addressed in response to Alex's question, to address the root causes, put in place programs that people can utilize to apply from in country, send a clear message the border is not open and that we're turning away the majority of adults when they come to the border.
There's a separate report that, speaking about the adults, there are 1,000 gotaways, mostly in Arizona, people who are seen, detected, but they're not chased because authorities are so busy processing the families. The Washington Post is reporting that some of these people are carrying drugs. Has the administration maybe reached out to Mexico to try to stop the flow of drugs or help stop the flow of drugs into American communities?
That's always a part of our diplomatic conversations, certainly through the State Department and other entities within the government. I'm happy to check on that specific reporting. I had not seen that report since before I came out here.
Okay,
great. Go ahead, Kelly.
In clarifying today, are you trying to roll back what the president said about the All-Star game?
No, I'm trying to articulate clearly to everyone what he said and what the context of his remarks were, the question that was asked, and the full scope of his answer. And I think it's been shorthanded to no one's fault because it's been repeated a bit without the full context.
And Mitch McConnell says that we are witnessing a coordinated campaign by powerful and wealthy people to mislead and to use the bully pulpit about this law. Will the White House say explicitly that it is not trying to influence corporations or organizations to take action on state level decisions like this?
We've conveyed it, and I'm happy to answer your question directly. We've not asked corporations to take specific actions. That's not our focus here. Our focus is on continuing to convey that it's important that voting is easier, not harder, that when there are laws in place that make it harder, we certainly express an opposition to those laws.
A couple of foreign policy questions. It's now April 5th. The Afghanistan decision is due soon. Obviously, troops and their families are interested to know what the president's decision will be. What more does he need before he can make or announce this decision?
Well, as the president has said before, it will be tough to meet the May 1st deadline for full withdrawal for logistical reasons. He's continuing to consult internally with his national security team and advisors, and of course also with our partners and allies. And, he's been working on these issues, foreign policy issues, national security issues for several decades now, and of course wants to take the time to make the right decision.
So our expectation should be that it'll go beyond May 1st with the tough to meet portion of your answer.
He set the expectation it will be tough for a full withdrawal for logistical reasons by that timeline. And that certainly has also something that we've conveyed clearly to our...
Hey, let's take another quick 2-minute break here on News Now from Fox. About 20 minutes away from the, Derek Chauvin trial to get going, or once again, we'll bring it to you right here on News Now from Fox. All right, everybody, and looks like in just a moment we will go out to the legal expert there, Ben Taylor. In just a moment, looks like we do have that audio resolved here. So in 90 seconds, we'll be bringing it to you here on News Now from Fox.
President Putin to predict at this point in time. Last week, it was read out that that our Secretary of State had a conversation with his counterpart. Also, the Secretary of Defense had a conversation with his counterpart. We remain concerned by the recent escalations of Russian aggression and provocative actions in eastern Ukraine. That's something we're watching closely. Of course, we're aware of the Ukrainian military reports concerning Russian troop movements on Ukraine's border. But at this point, we've been in touch at the Secretary of State and Secretary of Defense level, which is pretty high, as we all know. But I don't have any calls from the president to predict for you.
And just one more.
And he, of course, spoke with the president of Ukraine on Friday as well. So
that's right. Yeah.
About this specific issue.
Yeah. So on the tax front, I understand that you're not willing to sort of close in on a specific number that you might agree with Joe mentioned. But have you done a detailed analysis of what the delta would be, say if you agreed to 25%? How much less income revenue would that distribute? Are you doing that kind of a detailed analysis in preparation for these negotiations?
Welcome back, everyone, here to News Now from Fox. I'm your host, Mike Page. We were, before break, we had a little bit of the White House briefing. We are going to step away from that because we're about 20 to 30 minutes away from the Derek Chauvin trial to get going after lunch. So we will be bringing that to you, of course, gavel-to-gavel coverage right here. And in the meantime, let's get some updated context and analysis from attorney Ben Taylor, who always joins us here on News Now from Fox. We tried to get you a little bit earlier, but the audio just wasn't working. Sometimes here on News Now from Fox, sometimes it's really raw and that audio just not working. But Ben, thank you so much for joining us here. It looks like we got you now.
Yeah, great. No, I mean, as people saw earlier today,
they saw the police chief testify, and that's a key witness watching the trial. This is the chief. This is the highest person in all of Minneapolis Police Department. So this is a powerful testimony, and the jurors are definitely going to be listening to what the police chief said. And earlier, before the police chief, you saw the doctor, a doctor who saw George Floyd. That was the first doctor who administered aid to George Floyd at the hospital. That doctor made valuable testimony in regards to giving opinion that the doctor thought that George Floyd may have died due to loss of air to the brain. So very powerful testimony this morning, and we'll see what's going to happen this afternoon.
And Ben, how unusual is this for a police chief to testify against a police officer or a former police officer?
This is very, very unusual. To have the police chief come in and testify, very rare. And I think because this is a high-profile case, and this case has been watched all around the United States, all around the world, that's the reasoning why they have the police chief, the prosecutor called the police chief in. But in normal cases throughout our country, you don't see the chief of police coming in to testify. But this police chief did make statements about Derek Chauvin, who's on trial right now. So this is one of the reasons why they brought the police chief in. And this police chief fired Derek Chauvin pretty soon, right after the death of George Floyd. So having a police chief come in is very rare, and we'll be seeing what he says this afternoon too.
And we were talking about last week, Ben, about how, this is obviously a very real court case, not like the ones that you see on TV and the movies where everything's wrapped up in an hour. For this testimony, it took a while for the prosecution to really get going on the use of force there. In the beginning, we were just hearing pretty much a resume of this police chief. Now, Ben, tell us why they have to really bring up the resume there in front of the jury. I mean, you would think, though, if he is police chief, you would think he would have the credentials and maybe you could skip forward a little, but really that wasn't the case there for the prosecution.
Yes, in the law, it's called laying the foundation. So some of these jurors might have just moved to Minneapolis a year ago. So some people may not be familiar with the police chief. It sounds ridiculous that somebody wouldn't know their own police chief, but a lot of occasions, sometimes jurors are buried into their own lives and they don't really know what's going on around their city. So the prosecutor is trying to do is lay the foundation to explain to the jury, this is your police chief, everybody. This is their qualifications. This is how long the police chief's been on the force. This is how the police chief governs their office, governs their other police officers. And the prosecutor wants to show the jury and explain to the jury who this person is. So it does sound kind of funny why the prosecutor, talks probably about 5 minutes just about qualifications. But in trials, you'll see that a lot, especially for expert witnesses, for either the defense or the prosecutor to ask simple questions about where you're from, how long you've been working, just so that to explain to the jurors who might not even know who this person is, the qualifications of the expert witness who is the police chief of the Minneapolis Police Department.
And then the witness before that, we had the ER doctor, and the defense there really getting a little bit of the last question in maybe or so when they were talking about trying to bring up the fact that George Floyd was on drugs and really trying to hammer that home there, that could he have died because of the drug use rather than the chokehold situation that it was in. So we're going to hear this a lot, right, from the defense, really bringing up the drug use, what was in his body at the time, and really trying to hammer that home to try to give some doubt there to the jury.
Yes, the defense attorney's main argument throughout this whole trial is, one, there was drugs in George Floyd's body that caused the death to George Floyd. And number two, that George Floyd didn't die because of the knee to the neck or excessive force. He died because of drugs in his system. So you're going to see this repeated questioning of different expert witnesses saying, you're not an expert in knowing how he died. he died because of drugs. And when the defense gets their chance in a couple of days, they're going to probably put on their expert witness who's going to try to testify and explain to the jury that George Floyd died of drugs. So that is the main defense attorney's thing, to try to hammer into the prosecution's argument that it wasn't excessive force, it was drugs.
And Ben, I was thinking about this one over the weekend there. Coming in August, we are going to have the trial for the other 3 officers. Now, what kind of, well, you know, the prosecution and the defense for those police officers are definitely watching this case. What kind of advantage does that give the state as well as the defense teams for these officers that will be coming up at trial in August to watch this case?
Yes, the defense attorneys who are watching this trial and the officers who are watching this trial, they are able to watch the prosecution, able to see how they act, see the questioning. So a lot of the same witnesses are going to be testifying in the trial coming up for the other officers. So it's a huge advantage for the defense attorneys defending the other officers because they can see the style of the witnesses. It's going to be the same witnesses, same expert witnesses. So we're going to do a do-over, but these other defense attorneys are going to be able to go in there knowing in advance the cards on the table and already knowing what to expect. So it's a huge advantage to the defense going into the next trial.
And as we come back from this lunch break here in about 20 minutes, when the defense does the cross-examination, what are some things that we can be listening to the defense attorney, Eric Nelson, while he does cross-examine the Minneapolis police chief? What are some key moments you think we should be watching for and looking for?
One of the main key arguments that Eric Nelson, the defense attorney, will be doing is saying to the police chief, you don't know all the training that Derek Chauvin did. He was acting within the scope of his training. That's what you're going to see from the defense attorney. Or number 2, police chief, you weren't there at the scene. You weren't there. So how do you know how George Floyd died? You might can testify, you might can make statements, but you weren't there at the scene. So you might see cross-examination on this, on his training of George Floyd and whether or not the chief was even at the scene. And another thing is, because it's a big political and big media trial, what is your motivation of being here, Chief? That's what some of the things that you'll see the defense attorney try to poke holes into the trial or the chief's testimony, because they want to say the chief might be biased, you might have another horse in the race, and why are you here? Because you're the police chief. And like we talked about earlier, it's very rare for a police chief to walk into the courtroom and testify against another fellow officer.
Yeah, definitely unusual there, and it's something that we're all watching in real time. Ben, any last things that you want to touch upon before we get ready for the trial to come back for lunchtime?
No, I mean, basically, you're going to see is more expert testimony, more prosecution trying to beat in the jurors' heads that Derek Chauvin was the one who killed George Floyd with the knee to the neck. And you're going to see the defense attorney cross-examine the police chief, cross-examine other expert witnesses to make sure that he hammers in the head that George Floyd died because of drugs. These are the 2 main going back and forth there. So it'll be exciting to see what happens this afternoon on the cross-examination with Eric Nelson too. Yes, it will be, and we'll be watching it all unfold, and you will too. Ben, thank you so much for, once again, your updates and analysis. We truly appreciate it there, Ben. Yeah, thank you for having me. No problem, and we would continue to roll on right here on News Now from Fox. Let's take another quick 2-minute break here while we have it, while we do set you up there for the trial to come back after its lunch break. In just a little bit, we'll take you also out to Fox 9 Minneapolis as they continue their coverage and highlights from earlier today.
Situation as safely as possible. So you want to always have de-escalation layered into those actions of using force.
So they talked about that, for a while. de-escalation and use of force together, talking about the training and the policies surrounding that. So we can expect more of that questioning this afternoon. But there are limits to what the chief or any other officer can say on the stand. And actually, Judge Cahill clarified some of that this morning. The chief and officers won't be able to get up on the stand and say, this is what I would have done. But they will be able to talk about specific policies and specific trainings that tell them what they're supposed to do and what they're not supposed to do. So we're expecting the chief back up on the stand here as soon as this afternoon break is over. I want to talk about another witness that was up on the stand this morning. This is the doctor over at HCMC who took care of George Floyd when he first came into the hospital. And that doctor talked about the science behind Floyd's cause of death.
Was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
Thank you, Dr. Langenfeld. No further questions.
So that was a really important line of questioning for the state right there. Of course, the state has to prove that Chauvin's actions caused Floyd's death. So hearing that word asphyxia, lack of oxygen to the brain, was a big deal for the state to get on the record. Then, of course, on cross-examination, though, the defense attorney, Eric Nelson, really dug into that.
You were discussing hypoxia kind of being consistent with asphyxiation, right?
Correct.
Hypoxia is the lack of oxygen to the brain, correct?
Correct.
And there are many things that cause hypoxia that would still be considered asphyxiation. Agreed?
Correct.
Drug use. Certain drugs can cause hypoxia. Agreed? Yes. Specifically fentanyl?
That's correct.
How about methamphetamine?
It can.
Combination of the two?
Yes.
Now, we know this week we can expect to hear from more witnesses like this, more of your medical professionals, of your law enforcement witnesses throughout the course of this week, Tim. So court is set to be back in session here in about another 22 minutes.
All right. Hannah Flood keeping an eye on everything in court today. Thanks, Hannah. Again, we're going to bring you back to the trial once it resumes after the lunch break, and we're going to have gavel-to-gavel coverage every day of this trial, along with analysis from our legal experts, too. All right, on to other news of the day. The U.S. hits a new record this weekend for COVID vaccine.
All right, guys, just want to say thanks again for being here with us on News Now from Fox. Christy Larson here at the desk with you. As you can see, we still have that trial on their lunch break. They are expected to come back here in about 20-ish more minutes. So what we're going to do is continue to keep you updated on stories that have been happening here all across our country. I know that we were in some of our White House press briefing a little bit earlier here on our stream for you. Jen Psaki is still continuing to answer media questions, so let's jump into that before going into even more stories that we haven't gotten to right here on our stream earlier today.
So there were still steps taken to address this moving forward, but we were not betting on these to vaccinate the American public, the adult Americans, that we have assured people we will have enough doses by the end of May. We continue to believe we will.
But is he worried that something like this happening can affect vaccine hesitancy that we're already seeing in the United States?
Well, we haven't seen that to date, but this is why the FDA approval process is in place. In many ways, it was the process working because the FDA had not approved this site. There were steps taken to address what some of the issues were. And we also have a range of contingency plans. You know, when we all talk in here about why did we order so many doses? Why aren't we at the point where we are sharing doses with every country around the world? Part of it is because we need to plan for things coming up. Things like this come up. This is obviously, as you noted, a big number of doses, but we have to plan for a range of contingencies. That's exactly what we did. That's one of the many reasons that we are going to still be in a place where we have enough vaccines for adult Americans by the end of May. Go ahead in the back.
On infrastructure, does the president support the idea of a possible second reconciliation if the White House proposal does not receive any Republican support?
Well, we believe with 80% of the public supporting infrastructure investment, with even proposals coming forward supporting components of the package, that if we start on areas where we agree, we can move forward with bipartisan support.
And any more background you can provide on which lawmakers, specifically Republicans, the White House is reaching out to and inviting to the White House for meetings?
Not yet. I'm sure when we have a meeting set and we have the members all confirmed, we'll share the names with you, of course, once that's done.
More on COVID, with the rise of new variants, is the administration investing in booster shots or ramp up in production of booster shots or research and development for new vaccine to deal with the many variants?
Sure. Well, one of the issues that we've been focused on is, again, ensuring that we have flexibility as it relates to vaccine doses that we have ordered. That could include, now the FDA is still going through the process of approval for booster shots and determining, of course, what's needed and when. We would leave it to them and the CDC, of course, to make that determination and announcement. But we do have flexibility in the doses we've purchased moving forward, should that be a need.
Clarify that point. Is Operation Warp Speed still in effect, or would this be a continuation of that to address the investment in additional vaccine?
Well, companies are producing booster shots and options. They're being they're being reviewed by the FDA. So I'm not sure. That's just a process that's ongoing with companies and HHS. Go ahead. Oh, sorry. Let me just get around to everybody and they'll come back. Go ahead.
Yeah, Chief of Staff Ron Klain said last week that President Biden has asked the U.S. Department of Education to prepare a memo on the president's legal authority to cancel student debt. What exactly has the White House asked for here? And in the past, President Biden has said he would be prepared to write off $10,000 in debt, but not $50,000 like some liberals and Democrats have asked for. Is Biden rethinking his position, and is he reconsidering his position on the idea of canceling debt of students who attended more expensive private schools?
Well, first, he continues to look forward to, he'd welcome a bill signed by, or passed by Congress, I should say, to cancel $10,000 in student debt, and he'd be happily sign that. I think that would naturally be the first step before it's a larger amount beyond there. What Ron Klain was referring to is the fact that there's an ongoing review. It's both a policy review and a legal review. So Department of Education and Department of Justice to look at what the options are and what authority could be recommended to the president. So that was the process he was referring to.
If he's asking what options are available, does that mean whether he could do it to $50,000? And does that mean that it's therefore open as a possibility for the White House?
Yeah, his position hasn't changed. There's a review to take a look at what is possible with executive authority.
But he has indicated he doesn't think that's a good proposal. During the town hall back in February, he very much was outspoken against the $50,000 threshold. So where does he stand on that at this point?
And again, after that point in time, Ron Klain and others have spoken with a range of leaders in Congress, and we've said many times from this podium that there is an ongoing review of what the options are that are possible under executive authority. There's also a policy review, as would be expected at the same time. We haven't ruled out options, but that review is ongoing and there isn't a conclusion of it. Let me just go ahead.
Thanks. I have an infrastructure and a baseball question.
Oh, okay.
So last week, the White House put out a fact sheet about the infrastructure plan that cited the Texas power outage excuse me, as evidence of the urgent need to modernize the nation's electric grid, which kind of leaves the implication that Texas will get funding to upgrade its grid, but I haven't seen that specifically. So can you offer assurance that there actually would be money in this for Texas to modernize, upgrade, weatherize its grid?
Well, this is, believe it or not, or you will believe it, of course, a very common question from a lot of reporters and media outlets across the country. We will have some state fact sheets, I expect soon, that kind of break down some of the specifics. There are pieces like broadband access and other things, but there'll be a competitive bidding process once the bill is signed into law, and we'll probably won't have more to say that specifically until then.
So that's I think that's a really vague part of the plan. What do you mean by a competitive bidding process? Is this like, how do the top bridges or power grids get chosen? I mean, is it a formula? Do you envision a formula based on state population, or is a federal department deciding which is a more critical project than another?
We're not quite there yet. We just proposed this a couple of days ago. A competitive bidding process, which I think most Americans would support, would mean that States, entities have to apply for funding for rebuilding the infrastructure in their states and through local communities or whatever it may be. What the tenets and the specific logistics of that competitive bidding process would be, I'm sure there'll be discussions. Members will have different views. They'll all be advocating for different projects. We certainly expect that, but we're in the early stages of the process. And
So these congressional meetings, these are not about putting specific projects on a list?
No.
Okay. My baseball question is, today's home opener for the Texas Rangers is the first major league sports event since the pandemic started that allows a full house. The president called that a mistake last week. Has he spoken to other team owners to try to deter them and get them to hold off from having full house events?
I don't have any calls from the president to baseball team owners to read out. I would say that the president continues to reiterate the need to follow public health guidelines. There are restrictions, as you all know, recommended, including on masking, social distancing, which of course applies to having a full stadium, and the importance of being vigilant even while we're at war with this virus. We have seen spikes in certain parts of the country, certain regions in the country. That's something we're closely watching, and just a reminder of how important it is to be vigilant.
Very last question. Are any federal assets going to be used to track whether this event actually does lead to a spike?
I would send that question to the CDC. Go ahead.
Thank you very much, Jen. I have a question about immigration.
Mm-hmm.
President Biden has spoken publicly about how during the Obama administration, he worked with Central American countries and has talked about how he was helped negotiate getting $700 million in aid to help those countries prevent the flow of migrants coming north. What lessons did the president learn from that experience that he's applying to dealing with the crisis now?
Well, I think one of the reasons the president asked, and tell me if this is answering your question, but one of the reasons the president asked his vice president to play a similar role that he played is because he recognizes that unless we address the root causes in these countries, unless we disincentivize young people, families leaving these countries, we improve the economic conditions, we create spaces for them to be in these countries that avoids the corruption that is in place in many of the governments, we will continue to go through cycle after cycle. Some of these programs, and obviously the funding was not advanced during the last administration, and some of the programs were reversed. So, his experience impacts him and affects him because he knows we need to address the current challenges we're having at the border. Those are immediate. But in order to address it longer term, we need to address the root causes in the countries.
Is his expectation snapping back the funding that...
And just a heads up, some of you are going on a quick 2-minute break.
In the region? Well, he's proposed $4 billion in funding in his immigration proposal, so he certainly believes that we need more. It's not just reinstituting programs. We also need more, and we need to build from there. And he expects to, of course, be briefed by our envoy, who's going to be back and forth in the region, others who will be involved, and of course the vice president, who will be very closely involved in these conversations as well.
We expect on climate, when can we expect to see the U.S. commitments under the Paris Agreement that the U.S. announced it would re-enter on February 4th? When can the public see what those U.S. commitments are going to look like?
Well, I expect when we have our climate summit in a couple of weeks, there'll be an update, and we'll discuss more on a big national stage or the bully pulpit, where we are going from here, where we are, where we're going from here. And of course, Gina McCarthy and other members of our climate team, former Secretary John Kerry, are hard at work on putting together plans and working to implement. Go ahead in the back.
Yeah. Thank you, Jen. 2 questions. First, in response to Kelly's question earlier, you reiterated the U.S.'s strong support for Jordan and for King Abdullah as a strong ally. Now, the reports about the arrest of the deposed Crown Prince and 20 others are now 24 hours old. Has the president made any calls to the king and Amman reiterating that support?
I don't have any calls to read out. What I tried to convey to Kelly was that those calls or those engagements would likely happen out of the State Department at this point in time.
All right. The other thing on the infrastructure package, there is a private memo that's being circulated in the business community and to some Republican senators that said that the $2.25 trillion price tag is $1 trillion off. and that there's many things in there that were omitted in the initial discussion of the bill, notably the $300 billion energy tax credit, the $100 billion for the Green Bank, and that these things would add $1 trillion to it. This is being circulated on the Hill. Do you have any response to the charge that the president lowballed the price tag on the infrastructure bill?
Sounds mysterious, the memo, the secret memo. Are you saying, just so I understand your question, are you saying there are things the president didn't put in his proposal people think he's going to add to his proposal?
No, there's things there that somebody went through it or is claiming to have gone through it and added it up and came up with $1 trillion more than the president listed as the price tag. So it is actually $3.25 trillion as opposed to.
We laid out very specifically each component of the package and how much we're proposing. So I would encourage you all to get your calculators out and charge that up and see how it compares to the secret memo. Oh wait, go ahead in the back and then we can come back around to the front. Go ahead.
Thank you, Jen. The CDC updated the COVID-related travel guidance last Friday.
Yep.
Is the administration considering losing some international travel restrictions?
I don't have anything to predict on that front. Obviously, that would be done by our health and medical experts, and we would refer to them for any timeline on the guidelines.
Will you accept other vaccines that are approved by other countries that's not approved by FDA yet?
Will we accept them here in the United States?
Yeah, as like qualified vaccines.
I may not be totally understanding your question. We have ordered supply from the 3 vaccines that have been approved by the FDA. That's what we're focused on distributing to the American public. So I would anticipate we continue to focus on the vaccines that are FDA approved. Go ahead, you've been very patient.
Thanks. I just have a question that's a follow-up to Caitlin's question on Emergent.
Sure.
And that's about what does it mean now that J&J is sort of taking over that facility wholesale? What does that mean for the AstraZeneca vaccine? And will it affect their ability to manufacture here in the United States, or will that production domestically now shrink?
Well, first, we're working with AstraZeneca to immediately identify other facilities to continue their domestic manufacture of AstraZeneca drug substance, and several options are under consideration. As you know, it hasn't been approved, AstraZeneca, through the FDA yet. Johnson & Johnson has, hence the importance of Johnson & Johnson production continuing to be expedited.
Thanks.
Sure. Go ahead.
So a small question, just trying to make certain I understand where you are with taxation on the individual level. On Friday, in the president's remarks in the state dining room, he said it won't raise a penny tax on a family making less than $400,000 a year. Last week, there were some questions about this. You also included individuals. So is it families, joint filers, individuals? Is that threshold determined?
It is, he will not raise taxes on any individual or family making more than $400,000 a year. We expect there'll be more specifics on what he's proposing, some of the things that he's talked about on the campaign trail as it relates to individuals as we get closer to the rollout of the families plan. Go ahead.
Is that me?
That's you.
Got it. Thank you.
And then,
a quick one. So in California, as the school districts decide how to reopen, the United Teachers of Los Angeles Union, their members are asking for free childcare for their own kids, for the teachers' kids to go back. Does the White House think that that is something that they should get?
I would point you to the state of California and the local school districts to have those discussions.
And then just one more quick one on Georgia to put a bow on it. Is the president going to change the way that he talks about the new Georgia voting law? Because in that interview that you referenced, he said the law would end voting at 5 o'clock when working people are just getting off, and he said it would end voting hours early so working people can't cast their vote after their shift is over. But the Washington Post gave that claim 4 Pinocchios because that part of the law gives counties the option to extend voting hours. And so I'm just curious if the president is going to change the way that he's talking.
Well, fundamentally, the president doesn't believe it should be made harder to vote. He believes it should be easier. And this bill makes it harder to request and return an absentee ballot. It collapses the length of Georgia's runoff election, making it harder for large jurisdictions to offer early voting. It imposes rigid new restrictions on local officials' ability to set polling hours to suit the needs of voters in their county. Those are all pieces of the bill. So his view is that we need to make it easier and not harder to vote, and that will continue to be what he advocates for.
But the thing he said has been determined by election law experts to be not true. So I'm just curious if he's going to stop saying that.
Well, again, I think we can, the fact checkers will also tell you that this bill does not make it easier for people across the state of Georgia to vote, and that's where he has concerns. Go ahead. Yeah.
Semiconductors, you've got this April 12th meeting up with, coming up with senior officials, but also from industry. Can you give us a list of companies that will be participating in that? And then there was a report out on Japanese media saying that the president and the Japanese prime minister were working toward an agreement of supply chain, shoring up the supply chain for semiconductors. Can you say anything more about whether there is some kind of agreement in the works and what you're expecting to come out of both of those meetings?
Well, first, I expect when we get closer to the meeting, we will have, and we have a confirmed list of participants. We will share the list of companies and participants with you, but probably not until we get much closer to that actual meeting. As it relates to Japan, as we've made clear, the U.S.-Japan alliance is a cornerstone of peace, security, and prosperity in the region. And that is one of the reasons why we're working to deepen our close coordination across a variety of areas, including supply chains, as Secretary of State Blinken discussed with his counterpart last month. But in terms of specifics of those discussions and what's possible in the future, I just don't have anything to preview for you at this point in time.
Sorry, can I just do one quick follow-up, Peter?
Yeah.
But the president does acknowledge that the new law doesn't change election day voting hours, right?
Well, look, Caitlin, it also doesn't expand them for early voting. It makes early voting shorter. So there are a lot of components of the legislation he is concerned about, and that's what he was expressing.
Right, but he does acknowledge that because his comments have been confusing about closing it at 5 p.m.
That's correct.
So he does acknowledge that it doesn't change.
I think what's important is to report on all the components that make it more difficult to vote in the package in the legislation. All right. So we have a special guest. I will say that we know that this is one of the events where people get to take their children, family members, friends to, and it's not quite the same. We'll do a big one next year, but we still wanted to have a visitor and some special commemorative Easter eggs for all of you from the president and the First Lady.
Is the bunny taking questions?
Not today, but we'll invite the bunny back for a future briefing, as always. But the bunny's wearing a mask, where we use every opportunity.
Is this the same bunny suit that Sean Spicer wore?
It does not look similar, but we'll have to fact check that for you. Different eyelashes. Are we giving those out?
Yes, we're going to save them with Chris.
All right. Chris is going to be the bunny's helper. He will be delivering eggs, and make sure each of you get one and some chocolates to take home to your loved ones. Thank you, everyone.
All right, what a fun way to have a wrap up of their press conference there here on this Monday after Easter. And what we're going to do is send you guys into a quick 2-minute break. When you return, we'll show you those comments that President Biden had with the Easter Bunny. Again, that's just 2 minutes away.
And there once again is many of our locations that you can find News Now from Fox anytime. We do stream on newsnowfox.com 24/7. Just wanted to make a note of that for people who don't always know where to find us. You can always find us on there. I do see we have our Minneapolis trial. They have just come back from their lunch break, and so we'll have to get back to President Biden and the Easter Bunny a little bit later. He only made about a 2-minute speech just wishing everyone a happy Easter. So we'll play that out a little bit later for everyone on our stream, because I do want to get into this trial. We do have the Minneapolis police chief on the stand giving his testimony. Let's jump into that right here for you on News Now from Fox.
219, which is MPD policy 5-304. And if you take a look at the section here that's been enlarged, de-escalation tactics include but are not limited to. If you would please just summarize for the jury the different bullets that you see here.
Yes, some of the bullets here for de-escalation tactics.
Sir, one moment. Oh. All right. Thank you. All right. Please resume.
Yes, some of the de-escalation tactics that are noted here include but are not limited to placing barriers between an uncooperative subject and an officer, communication from a safe position intended to gain the subject's compliance using verbal persuasion, advisements, or warnings, using verbal techniques to calm an agitated subject and promote rational decision-making, calling for additional resources to assist, including more officers, CIT officers, and officers equipped with less lethal tools.
And CIT officers are those who've been through the crisis intervention training course, is that correct?
That is correct.
And our Minneapolis police officers then at the training center taught different techniques on how to implement this policy?
That is correct.
Have you personally attended the training?
Yes, I have.
Did you find it useful?
I have.
And then you can remove that. We've talked a little bit then about behavioral crises and identifying behavioral crises. How does the Minneapolis Police Department respond to persons in a behavioral crisis?
One of the first important things is obviously trying to get as much information prior to the call as possible. But as soon as officers at least have knowledge that this could be a potential situation with that caller, this de-escalation piece should kick in. And that they, while they may not know exactly what they're going to encounter when they arrive on the scene, this body of knowledge that they've been taught should at least be kind of forefront in terms of the different tools that they'll be using possibly to help de-escalate that situation.
What is an EDP? What is that acronym?
The acronym EDP is labeled through our Minneapolis Emergency Communications Center as a emotionally disturbed person. And so when our Minneapolis police officers receive a EDP call, that is prompting them that there's at least initial information that they're going to be responding to someone who may be in crisis.
And that's something that the officer would then be communicated by a dispatcher prior to going to the scene, correct?
That is correct.
However, when if that information is not imparted upon them, they make their own assessment at the scene as to whether the person could potentially be an EDP. Is that correct?
That is correct.
You indicated that the Minneapolis Police Department receives over 100,000 calls a year, calls for service. Is that right?
Yes.
Do you have an idea of how many calls for service involve people in crisis?
I believe in 2019, Minneapolis police officers responded to about 4,500 of those signified as EDP calls. Yes.
Now, in terms of teaching officers how to recognize a person who may potentially be in crisis and therefore unable to comply with commands, you place these different signs into MPD policy.
That is correct.
And I'd like to direct your attention now to Exhibit 231 and ask that to be published. And this is 7-809, the crisis intervention policy, you say it begins here, oops, sorry, but we'll go ahead and over to page 2. And I'd like to highlight, please, for the jury, the definition of a crisis. And again, in the definition of a crisis under MPD policy, generally speaking, we're talking about some of the same things that we saw before in the de-escalation policy. Is that right?
That is correct.
There can be mental illness. Is that right?
Yes.
Substance abuse can be a crisis or a barrier to communication, correct?
Yes.
And same with various stressors, is that right?
Yes.
And then further, if you can emphasize the crisis intervention definition. And officers, when they either respond to an EDP call or are aware that the person may be in crisis, can attempt a crisis intervention method. Is that correct?
Yes.
And generally speaking, what is the officer supposed to do to a person in crisis?
It's an attempt to de-escalate that situation.
And the policy then of the Minneapolis Police Department in handling persons in crisis, if we could look at section 3 of the policy, would be the next page. Highlight Roman 3. Okay, in accordance with the Minneapolis Police Departmental policy, what are officers supposed to do? How are they supposed to handle encounters with individuals who are experiencing a crisis?
We really want to, again, we want to meet people where they are. We want to bring our values, our principles to those situations. We recognize that oftentimes people who are experiencing crisis, it is not something that they brought on themselves, but they're dealing with. And so there's a sense of dignity and respect that we should be honoring when we come to those calls. And so, as it's mentioned here, the values of protection, safety, and sanctity of life. Oftentimes, again, we are that first face of government that they're going to see. That may be 3 o'clock in the morning. And so we have to wear many hats, but we want to be respectful in that care that we're trying to provide for that individual.
And sometimes persons might be experiencing some sort of a breakdown that, maybe they did partially bring upon themselves. Is that right?
That is correct.
And are those people still entitled to be treated in accordance with MPD policy?
Yes, they are.
And this policy, again, is imparted in training at the training center by that group. Is that right?
That is correct.
Now, I'd like to, if you could take that down, please, talk to you a little bit about officers' role as first responders in terms of providing basic medical care. All right? And so, with that, can you tell the jury, are Minneapolis police officers trained to provide basic medical care?
Yes, we are.
Can you please describe what level? I'm aware there are various different levels of medical care that someone could be trained in.
So most of department members will have at least basic training in terms of first responder, the ABCs, airway, breathing, circulation, the effects of applying direct pressure on wounds to stop bleeding. Many of the things that we will respond to, perhaps just because we're closer to a call than perhaps our EMS or our fire before they get there, and they're obviously have a higher degree level of training. But the training that we have and that we receive, it's very vital because those seconds are vital. Our officers carry tourniquets. We respond to situations where members in our community will have gunshot wounds. And matter of fact, a couple of my officers a couple of weeks ago saved a young man who was shot in the femur and was bleeding profusely, but because they got there quickly, knew how to apply that tourniquet. Those are some of the basics. Direct baby not breathing calls. our officers have saved the lives of children who've choked or what have you because they've applied or they've been able to help start emergency breathing for them. So those are some of the basic types of first aid that are chest compressions, those types of basic first aid.
And are officers then, specifically trained at the training center to provide this basic sort of first aid?
That is correct.
And does the Minneapolis Police Department have a policy regarding any duty that an officer would have to apply that training to a real life situation?
Yes. We recognize, again, I mentioned that we are oftentimes going to be the first ones to respond to someone who needs medical attention, and so we absolutely have a duty to render that aid.
And that, of course, is in the policy and procedure manual, is that right?
Yes.
If I can display Exhibit 230, which is MPD Policy 7-350, Emergency Medical Response. And under Roman 1, you see that the purpose of the policy is to lay out in writing the roles and responsibilities of Minneapolis Police Department employees in incidents involving a medical emergency. Is that right?
Yes.
If we could take a look at the policy itself under Roman 2, does that explain what a Minneapolis police officer is supposed to do when they come upon a medical emergency or a medical emergency develops on a call?
Yes.
What are they supposed to do?
While awaiting EMS, MPD employees assisting an individual having an acute medical crisis shall provide any necessary first aid consistent with our MPD training as soon as practical.
And so then that presumes, of course, they're waiting for EMS or waiting for some kind of emergency services. Is that right?
That is correct.
So would it be fair to say that this policy then is in two parts? The officer has to request EMS or an ambulance, correct?
Yes.
And while waiting for the ambulance, they're required to provide what medical training and skills they have to attempt to save the person.
That is correct.
Are Minneapolis police officers provided naloxone or Narcan kits?
Yes, we are.
What are those?
It is basically a inhaler for community members who we may respond to have overdosed. It is to, if they've overdosed and are out, it is to give them that inhaler injection so that they can hopefully come to. And so it was a few years ago where, for the most part, our Minneapolis Fire Department were the ones that responded to overdose and carried the Narcan. Unfortunately, in our cities across the country saw an uptick in heroin and opioid overdoses. We had to make sure that we were, again, because we were oftentimes the first ones to come across these situations, we wanted to make sure that we were in service to our communities and making sure that if we could save lives, that we were equipping our folks with Narcan.
And a policy developed as a result of this, is that right?
That is correct.
If I can show you Exhibit 229, it's published at. Is this the Narcan policy 7-348?
That is correct, yes.
And our officers provided training in the administration of Narcan?
Yes.
Under appropriate circumstances?
Yes.
Okay. And now I'd like to talk to you a little bit about the use of force. Does Minneapolis have a written policy governing proper and authorized use of force?
Yes, we do.
Okay. And is this generally covered in the 5-300 series of the Policy and Procedure Manual?
Yes, it is.
I'd like to discuss some of that manual with you and the policy with you at this time. If we could pull and display Exhibit 216. Under the purpose of the policy, which is 5-301, can you please read the first sentence under subparagraph A?
Yes. Sanctity of life and the protection of the public shall be the cornerstones of the MPD's use of force policy.
What does that mean?
Of all the things that we do as peace officers for the Minneapolis Police Department, And I mentioned the thousands of calls that our men and women respond to. It is my firm belief that the one singular incident we will be judged forever on will be our use of force. And so, while it is absolutely imperative that our officers go home at the end of their shift, we want to make sure and ensure that our community members go home too. And so sanctity of life is absolutely vital, that is the pillar for our use of force.
Has this generally always been the case with Minneapolis use of force policy?
It is not.
When did that change?
We implemented this particular in 2016.
Has the training and use of force and application of use of force policy been imparted, including this philosophy, onto police officers in training at the training center?
It certainly has, yes.
Does the policy itself define force? What is force?
Yes, it does.
If we could take a look at Exhibit 217, I'll publish that. If you highlight use of force. Okay, generally speaking, what is force?
It can be any physical contact. It can be with a weapon. It could be with a vehicle. But it's any sort of physical contact that is more likely to render harm or injury to someone.
Is the use of restraint considered force?
That would be considered force.
And what type of force is authorized under departmental policy?
We under 609, we operate under the use of force, the Graham v. Connor statute, objectively reasonable force.
And if I could display Exhibit 217. Let's see. First, go back to 5-303. 5-303 authorizes force, is that right? And you mentioned 60906, state statute authorizing force under certain circumstances, is that right?
Yes.
And the phrase that's used for the authorization of force is what type of force?
Reasonable.
And that force can be authorized under certain circumstances, is that right?
Yes.
All right. So now if you would go to the next page, and let's talk about the circumstances under which a police officer is authorized properly to use force. If you highlight that. What are the circumstances under which an officer is authorized to use force?
An officer is authorized to use force effecting a lawful arrest, executing a legal process, enforcing an order of the court, and any other duties imposed upon that officer.
And that term reasonable force is further delineated in the policy, is that right?
Yes.
If we take a look at Exhibit 217, I believe under the definition, objectively reasonable force. Could you please read that definition?
Yes. The amount and type of force that would be considered rational and logical to an objective officer on the scene, supported by facts and circumstances known to an officer at the time the force was used.
Oh, you discussed a case, the Connor, right? The Connor factors. And I'd like you to, well, first of all, does the policy reference the Connor factors that you just mentioned?
Yes.
If you could display 217, page 2. Okay. And we have 3 bullet points here under the Connor factors. And that is the officer is supposed to look at the totality of the circumstances, right?
Yes.
And the 3 bullets here that the officer is supposed to consider are what?
The officer should consider the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight.
And fair to say these these three different considerations are things that you can attribute to the subject, correct?
Yes.
That's the subject's conduct, not someone else's.
Yes.
And of course, it has to be judged by a reasonable police officer on the scene at the time, correct?
Yes.
Now, do you recall, and obviously you're here talking about what happened on May 25, 2020, involving George Floyd. Do you recall why the officers were responding to cup foods on that date? The original reason for the call?
The original reason for the call was a response regarding a counterfeit situation at the store at the intersection of 38th and Chicago.
And in terms of the deployment of your resources at the Minneapolis Police Department and as chief, how do you rate, I guess, the severity of that offense, the seriousness of that offense?
It would probably not rise to the level of, and particularly in light of last year, the level of violent crime that we've experienced in the city, but we would certainly respond to it, but it would not rise to the level in terms of severity of the crime here.
In looking at the particular type of crime, is that one for which a suspect is typically taken into a custodial arrest?
Typically not.
And why is that?
If it's not a violent felony, we also, in coordination with our jail system and our courts, there's been a shift over the years to make sure that the individuals who are going to jail are those who, from a public safety standpoint, need to be at least in that facility in the Hennepin County Jail. And if we can properly identify and it's not a violent situation, we can always charge via complaint and other things. And so that's one of the reasons why.
You use the phrase, I guess, violent felony. What's the more important part, whether it's violent or whether it's a felony?
Oh, violence.
Why is that?
Well, it can certainly endanger not only the officers but the community.
Where something that's merely labeled a felony may or may not require a full custodial arrest.
That is correct.
And are Minneapolis police officers trained in the use of force?
Yes.
In the pre-service, in the academy, and also in post-service at the in-service training?
Yes.
And are officers taught the standard that force must be reasonable at the time it is applied?
Yes.
The entire time it's applied?
Yes.
Are officers taught the need to assess and reassess and reevaluate situations in the field?
Yes, we are.
Are you familiar with Minneapolis Police Department's critical thinking model?
Yes.
How are you familiar with that?
It was something that I wanted to embark and make sure that it was part of our training curriculum that also includes the aspects of procedural justice. And procedural justice is really, it's actually research and evidence-based learning that has shown that if police departments treat people with respect, give them voice, establish neutral engagements, and build areas of trust, our communities are more likely to cooperate with us. We're likely to be seen more as legitimate. It is actually shown that our employees are come to work, their wellness is better, and so this is very important work. And so it's part of that procedural justice I just mentioned, is part of that critical thinking in our training.
At this time, I'd ask to display only to the witness exhibit for identification 276. Sir, do you recognize exhibit 276 as being MPD's critical decision-making model?
Yes.
Offer exhibit 276.
Any objection? No objection. 276 is received.
Permission to publish? So we heard about the model, now we get to actually see it. And if you could enlarge the graphic, please. Right, so this is what the model looks like. It's sort of a wheel, is that right?
Yes.
And the first stage of the critical thinking model, decision-making model, is information gathering.
Yes.
Explain that, please.
It's very vital. We rely upon trying to gather as much information as possible so that we can try our best to effectively go in, respond, and manage that situation. Trying to gather as much information at the onset is very important, but we also need to make sure that we're continuing to try to gather as much information as we're dealing with the scene or the call.
I see the arrow points in two directions, and one it points to the middle of the circle, voice, neutrality, respect, and trust, and the other arrow points to the threat or risk assessment. Let's talk about the middle of the circle first. Right? What is that middle circle supposed to be representing?
Well, that's the principles, really, of what continues to guide us. So, for example, information gathering, while we may associate it specifically with receiving a 911 call and the dispatcher giving us information, but information gathering could be that officers come across a call that they weren't dispatched to, and they need to talk to a community member. If they don't treat that community member with respect or give them voice, it's likely that they will receive less information that will be less helpful in them resolving that call. So that voice, neutrality, respect, and trust, that has to guide and be a part of all of that critical decision-making model.
So let's go to the next step. The officers gathered some initial information, and now the officer is in a position to need to think about it or assess it. Is that right?
Yes.
And so the next step is the threat or risk assessment. Is there a difference between a threat and a risk?
There can be in terms of what is being played out at the time, and you're constantly evaluating that, and of course the information that you're receiving, which may be fluid, is going to dictate that threat or risk. Yes.
And so then once the officer has made an assessment of a threat or a risk, the next step, authority to act. What does that mean?
That may mean the officer now, based upon that the information that they've received, evaluating that threat or risk, am I going to act? Is this going to be a physical arrest? Am I going to separate parties? Does this require a report? All of these things. So, but it's giving more information for the officer to guide he or she in terms of what is the next appropriate step they need to act and take.
And so if we were to, at least to this point in the model, put a scenario into action, information gathering, the officer perceives that someone is approaching them with a weapon, like a bat, right? And so then they would reflect on that and determine whether or not this is a risk. It's a bat, maybe the person is at a baseball game, or a threat. The bat is being brandished, correct?
Yes.
Then after that, under authority to act, if they've determined that this in fact is a risk and that they're being threatened, they would look at the authority back to the MPD policy and procedure manual. Is that right?
Yes.
Under what is the use of force policy, what tools are available to me to respond here?
Yes.
Okay. The next step then, after considering the authority to act, goals and actions. What is that?
The goals. The officer is making an assessment. So with the authority to act, will an arrest resolve this situation? Will separating the two parties be enough? Is taking a report, will that be enough of a goal or an action? It may mean a combination of things. It may mean that I'm going to have to, or the officers are going to have to make an arrest, but we may need additional resources here because the situation is still could have the potential to not be stabilized. And so all of that is part of that goals and action.
And then to review and reassess, assuming that means exactly what it says.
Exactly, yes. And information is going to flow, dynamics can change, and so it can be a constant just review and reassess the situation to make sure that we're trying to get to the best possible outcome in this peacefully and safely.
Because circumstances can change, the situation can change, correct?
Yes.
And force that might be appropriate at one moment might not be appropriate at a different moment, or more force might be needed at yet another point. Is that right?
Yes.
This particular critical thinking model, Exhibit 276, we see examples of this throughout training materials that are provided by the trainers at the facility. Is that right?
Yes.
And why is that?
It's to really embed that knowledge that, we don't want to fall susceptible to kind of check the box training. This training is important for all of our officers to have a knowledge and understanding of, and that our community members can expect this to be consistent as they have encounters or engagements with our officers.
All right. If we could take that down, please. And I want to shift a little bit to talk about, we've talked about use of force and the policy. Does Minneapolis Police Department train its officers in specific defensive tactics?
Yes.
And where does that training occur?
That training occurs at our Special Operations Center.
And does the department provide training for officers in handling uncooperative individuals?
Yes.
Does the department provide training for handcuffing reluctant suspects?
Yes.
And when you provide the training, you're assuming you're taking someone into custody. Do you also teach officers their responsibilities, their personal responsibility with respect to the person they've just taken into custody?
Yes, we do.
And what responsibility does an officer have to a person they've taken into custody or restrained?
So the American policing profession, which I believe is the best in the world, and I will tell you why, and it's really two reasons.
Rephrase your question.
Yes, Your Honor. Sir, you have a responsibility, I guess, and that's imparted throughout officers in various forms of training as to what, once someone is in their custody.
Oh, yes. We have a duty of care. And so when someone is in our custody, regardless if they're a suspect, we have an obligation to make sure that we provide for their care.
Does that include people to whom defensive tactics are being applied?
Yes.
Why is that?
They are still in our custody, and they have rights. And the humanity of this profession, we need to make sure that we're taking care of them.
So how often are officers required to participate in defensive tactics training?
It's usually a yearly annual training.
Do you know that, when we're talking about the training and policies in effect on May 25, 2020, were neck restraints and chokeholds taught and authorized by MPD policy at the time?
At that time, yes.
And they were taught pursuant to the defensive tactics training as well?
Yes.
At this time, I'd like to publish Exhibit 224. Exhibit 224 showing MPD policy 5-311, use of restraints, neck restraints and chokeholds. You see a chokehold is considered a deadly force option, is that right?
Yes.
Okay. If you could go to the next page, please. Neck restraint, if you could highlight that portion from that down to unconscious neck restraint. Okay. There are various types of neck restraints that were authorized at the time, is that right?
Yes.
And neck restraint was defined as compressing one or both sides of a person's neck with an arm or a leg, is that right?
Yes.
But without applying any direct pressure to the trachea, the airway that needs to be protected?
Yes.
Right. And there were two types of neck restraints that were authorized: conscious neck restraint and unconscious neck restraint. Yes. And the objective of the unconscious neck restraint, the second one, would be to have the person actually pass out.
That is correct.
And under certain circumstances in which the officer was in fear of grave bodily harm or death, that would be authorized. Is that right?
Yes.
And conscious neck restraints were more with the neck restraint with the intent to control, but not to render the subject unconscious. Is that right?
Yes.
By applying light to moderate pressure. Is that right?
That is correct, yes.
And if you could go to Roman 2 on the same policy, highlight that. Okay. Conscious neck restraint can be used for someone who is actively resisting, correct?
Yes.
And an unconscious neck restraint could be used for a person who is exhibiting active aggression or to save a person's life. Is that right?
Yes.
Okay. Or in a subject who is exhibiting active resistance if lesser attempts would have or would likely to be ineffective. Is that right?
Yes.
But neck restraints were not to be used against persons who were merely passively resisting, correct?
That is correct.
All right. Now I'd like to draw your attention to May 25, 2020. Can you tell the jury when you first learned of the incident involving the defendant, officers Tao, Lane, and King, and George Floyd?
On Monday evening, around 9 p.m., back on May 25th, 2020, I received a call. I was at my residence, and I received a call from one of my, I believe it was a deputy chief, who had informed me that Minneapolis police officers had responded to 38th in Chicago, and while attempting to take someone into custody, that, which I learned now to be Mr. Floyd, they believed that he would not make it or survive. And so he was being transported via ambulance to, at that time, Hennepin County Medical Center. And while at least the information I had that evening at 9 p.m., he at that time at least I was told was still alive, I decided to contact the Minnesota Bureau of Criminal Apprehension. And they are a state agency that conducts our critical incidents. I deemed that this would be a critical incident, and it has been our protocol to alert them, and they would conduct that investigation. So I made that call to the BCA to have them start to conduct this critical incident.
Did you then proceed to City Hall?
I should also say that right after that call, I notified Minneapolis Mayor Jacob Frey to say that this is a situation we have at least right now, and that I would brief him as I received more information. I then proceeded to leave my residence, and I went directly to my office in City Hall.
When you arrived at City Hall, do you recall seeing any video images or footage of this event?
The first time that I saw a video of the event was after I was notified that Mr. Floyd was now deceased. And so I had asked my deputy chief to pull up knowing the area really well and knowing that there's usually a camera, a city-owned camera at that location, I asked him to locate that video so that I could review it.
Okay. And that's what we would refer to as the milestone camera or milestone footage?
That is correct.
Okay. Did you watch the footage from the milestone camera that evening?
I did watch that.
Okay. Can you describe for the jury what you saw when you watched the footage?
When I first viewed this milestone video, what I was able to see, and I should just note that it was from a distance from where the officers were with Mr. Floyd, and so all I could really see were the back sides of the officers. There was also no audio to this milestone video, and so I viewed that video in its entirety, and quite frankly, there was really nothing in terms of the actions of at least, again, this non-audio video that really jumped out at me. After a few minutes, it seemed, a paramedics vehicle pulled up to the scene, and it was at that time, for the first time, that I saw a glimpse of Mr. Floyd when paramedics placed his body on the gurney and transported him away from the scene. But that was really my first observation of that incident from that night.
At some point, did you become aware of another video that had been taken by a bystander?
Yes, probably close to midnight, a community member had contacted me and said, Chief, almost verbatim, but said, Chief, have you seen the video of your officer choking and killing that man at 30th Chicago? And so once I heard that statement, I just knew it wasn't the same milestone camera video that I had saw. And eventually, within minutes after that, I saw for the first time what is now known as the bystander video.
Fair to say that this was a much closer video and it had audio?
Yes, this I was able to see the occurrence, see the officers involved. I was able to actually see Mr. Floyd. I was actually able to hear what was occurring, and I was also able to get a better understanding of the length of time, the duration of the call, the incident. Yes.
Now, prior to testifying today, have you now reviewed the bystander video, Facebook video in its entirety?
Yes, I have.
You've also reviewed and reviewed milestone footage?
Yes, I have.
And have you reviewed the body-worn camera footage worn by officers Tao, King, Lane, and the defendant?
Yes, I have.
Now, first, I want to show you what's been received as Exhibit 17. Do you recognize Exhibit 17 to be an image taken from the bystander video that you reviewed?
Yes, I do.
Now, sir, based upon your review of all of the information that you just mentioned, do you believe that the defendant followed Departmental Policy 5-304 regarding de-escalation?
I absolutely do not agree with that.
And how so?
That action is not de-escalation. And when we talk about the framework of our sanctity of life, and when we talk about the principles and values that we have, that action goes contrary to what we're taught.
As you reflect on Exhibit 17, I must ask you, is this a trained Minneapolis Police Department defensive tactics technique?
It is not.
Well, we read the departmental policy on neck restraints. Is this a neck restraint?
The conscious neck restraint by policy mentions light to moderate pressure. When I look at Exhibit 17, and when I look at the facial expression of Mr. Floyd, that does not appear in any way, shape, or form that is light to moderate pressure.
So is it your belief then that this particular form of restraint, if that's what we'll call it, in fact violates departmental policy.
I absolutely agree that violates our policy.
Are you aware now that the defendant maintained this position on George Floyd for 9 minutes and 29 seconds?
I am aware of that.
I believe you testified that force has to be reasonable when it's applied at the beginning and through the entire encounter. Is that right?
That is correct.
Is what you see in Exhibit 17, in your opinion, within Minneapolis Police Departmental Policy 5-300, authorizing the use of reasonable force?
It is not.
And why not?
That is, it has to be objectively reasonable. We have to take into account the circumstances, information, the threat to the officer, the threat to others, and the severity of that. So that is not part of our policy. That is not what we teach, and that should be condoned.
When do you believe, or do you have a belief as to when this restraint, the restraint on the ground that you viewed, should have stopped?
Once Mr. Floyd, and this is based on my viewing of the videos, once Mr. Floyd had stopped resisting, and certainly once he was in distress and trying to verbalize that, that should have stopped. There's an initial reasonableness in trying to just get him under control in the first few seconds, but once there was no longer any resistance, and clearly when Mr. Floyd was no longer responsive and even motionless, to continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy, is not part of our training, and it is certainly not part of our ethics or our values.
Sir, based on your review of the video and based on your own experience and training as an MPD officer, did you see signs during the encounter that Mr. Floyd was exhibiting indicia of being in medical distress?
Yes. Yes.
And you saw at one point, I think you just testified that Mr. Floyd was unresponsive.
That is correct.
And that officers, were you aware that officers couldn't find a pulse?
Could you repeat that, sir?
And were you aware that officers at the time of the restraint were unable to find a pulse?
Yes, I was aware of that.
And so stated.
I was aware that the officers were not able to find a pulse, yes.
Did you see the defendant or any of the officers attempt to provide first aid to Mr. Floyd?
I did not see any of the defendants try to attempt to provide first aid to Mr. Floyd.
The defendant did not try CPR. He did not start chest compressions.
Objection, argumentative, and sustain is leading. Rephrase.
Did you see them provide any medical attention?
I did not.
Then based on these observations, do you have an opinion as to whether the defendant violated MPD departmental policy 7-350 by failing to render aid to Mr. Floyd?
I agree that the defendant violated our policy in terms of rendering aid.
Thank you. I have no further questions at this time, Your Honor. If you could please take the video.
Mr. Nelson.
Good afternoon, Chief Arradondo.
Good afternoon, Counselor.
Thank you for being here this afternoon and this morning.
Thank you.
A few follow-up questions for you regarding this incident. Your determinations today are in reference to employment policies and Mr. Chauvin's actions violating the departmental employment policies.
That is correct.
Now, as the police chief, I assume that you're not out on the street day-to-day arresting people.
That is correct.
Can you just give me a general sense, when's the last time that you've actually, I don't mean to be dismissive, but actually arrested a suspect?
It's been many years, sir.
Yeah.
Yes.
Your role as the Minneapolis police chief is sort of grander in its scope, right? I mean,
It's large in context and the operations of the department, yes.
And part of that job is to be sort of aware of issues in policing, kind of policy changes, use of force changes. All of these things fall under the umbrella of your role as the chief. Agreed?
Yes.
And you're sort of the general in a sense, right? Formulating the plan for your police department.
And delegating some of those to our subject matter experts, yes.
Correct. When you talk about training of a police officer, you would also include the training that the Minneapolis Police Department goes through, but you may go to other trainings out of state, listen to speakers talking about issues that confront policing, right?
Yes.
As well as maybe a homicide detective will get permission to travel to an interviewing a suspect type of a training in some other state or location, right?
Yes.
And so there is a variability within the training depending upon your role as in the police department, right?
Yes.
So that you've got sort of your rank and file basic patrol officers, and they go through all of the trainings that you've described, the defensive tactics, medical assistance or basic medical training, crisis intervention, things that we've been talking about here today, right?
Yes.
And then the investigative type officers, they may go to they have to go through that training, but they may go through some additional training in terms of how to interview suspects or how to properly collect evidence, etc., unique to their role, right?
Yes.
And then you as the police chief or those who are in the more management or administrative side of the police department, you go to the kind of the big picture training sometimes.
That's correct.
All right. So I want to review with you a few of the policies that we've already talked about today. If we can take this down for the moment, Your Honor. First of all, I'd like to show you what has been introduced as Exhibit 216, which is the use of force policy for the City of Minneapolis Police Department.
Yes.
We've discussed this. And I know that kind of what we did a little earlier is we kind of jumped around from part to part, but I'd like to walk through some of these issues in a little bit more linear fashion, if we could. So you've described under policy 5-301.01 that the Fourth Amendment's reasonableness standard applies to the use of force in Minneapolis, of the Minneapolis Police Department. Agreed?
Yes.
And that goes on to say that MPD employees shall only use the amount of force that is objectively reasonable, and it continues in light of the facts and circumstances known to that employee at the time the force is used. Correct?
Yes.
So the reasonableness standard, or the objectively reasonable standard, applies to the facts and circumstances that are known by the officer at the time the force is being used. Correct?
Yes.
Now, 5-302 gives some definitions in terms of the use of force, and it differentiates between active aggression and active resistance. Can you describe the difference between active aggression and active resistance?
Active aggression, behavior initiated by the subject that may or may not be in response to police efforts to bring the person into custody or control. The act of aggression, when presenting behaviors that constitute an assault, or in the circumstances reasonably indicate that an assault or an injury to any person is likely to occur at any moment. That's for active aggression.
Yep, let me just stop you there. That's active aggression. So that's where a suspect is essentially fighting with a police officer or doing something that is aggressive, behaviorally speaking. Agreed?
Yes.
And that is aggressive in its nature.
Yes.
Now, can you read active resistance?
Active resistance is a response to police efforts to bring a person into custody or control for detainment or arrest. Subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control.
So essentially what we're talking about here is behavior that may or may not be physical in its nature that simply makes it harder for an officer to take a person into custody. Agreed?
Yes.
And sometimes that is maybe not trying to punch the officer, but pulling away or hiding his arms or doing something that just makes it more difficult physically, right?
Yes.
And sometimes it's, you're not going to take me alive, you dirty cop, like they're saying something to prevent the officer from arresting.
Yes.
Right? So they're using their words, they're using their behaviors. Is it common, based upon your experience, for people to enjoy being taken into custody? Do people like to be arrested?
Typically not.
Right. And in your experience, is it common practice for people whom are being arrested to say things in an effort to try to get the officer to not arrest them?
That certainly occurs, yes.
Right. My mom is homesick, I need to get home to my kids. There may be words that they use to try to convince an officer to not arrest them, right?
Yes.
Now, you would also agree that there is a difference between being arrested and being detained. Agreed?
There can be.
Right.
Yes.
So an officer in certain circumstances is permitted to expand the scope of the original intervention. Would you agree with that?
Objection made.
You can restate.
Let me try. When an officer approaches a situation, and let's assume it's a relatively minor offense, is it possible that that minor offense can grow in its scope of investigation?
Yes.
And it's actually quite common for that to happen, correct?
Yes.
An officer makes a traffic stop for speeding or something like that, smells drugs in the car, searches the car, finds a large amount of drugs, finds guns, etc., right?
Yes.
So what starts out as a relatively minor incident, a traffic ticket, can turn into a felony arrest, correct?
It could.
And that, again, happens quite regularly.
Yes.
So when an officer, well, let me back up a second. You would agree that being a police officer is a pretty dangerous profession.
There are inherent dangers with it.
I've never had to get in a fight with anybody in my life, in my job, right? But in your job, it's probably more probable that that will happen. Would you agree with that? Now, talking about the use of force, when an officer approaches a motor vehicle, is that considered to be one of the most dangerous initiations of contact between an officer and a citizen?
I don't have the exact statistics on it. It's certainly an encounter that officers are certainly more heightened. I know that domestic response calls can also have a sense of heightened awareness for officers, but it's certainly something, a traffic stop certainly raises an awareness for officers, yes, for their safety.
And that's because that's that suspect's sort of space, right? The officer doesn't know what's in the car or in the apartment during a domestic situation. You're walking into someone else's territory, so to speak, right?
Yes.
Right. And so there could be guns, there could be knives, there could be any number of instruments that could bring harm to a police officer, right?
There's that potential.
Now, obviously, there's tens of thousands of traffic stops, and there's not every traffic stop turns violent. I'm not suggesting that, but that does happen regularly. Agreed? That traffic stops turn violent.
Yes, they can.
So, when we're talking about the use of force policy under 5-301.01, the last sentence that wasn't read before is the force used shall be consistent with current MPD training. Agreed?
Yes.
Now there's a difference between a policy change and like a best practice change. Would you agree with that?
Can you clarify?
Sure. So there are certain times where the policy, it's with respect to the use of force, may specifically change to prohibit a particular style or use of force, right?
Yes.
So thinking about in the old days, officers used to wear like weighted gloves to make their punches more effective, right?
Yes.
The policy changed and prohibited that, correct?
Yes.
And then there's a difference between, say, the evolution of defensive tactics. Would you agree with that? I mean, the defensive tactics training you received in 1989 is much different than the defensive tactics training that's taught now, right?
Yes.
And I believe it was maybe 15 years ago that the Minneapolis Police Department started moving towards more body weight control, sort of this jujitsu training as opposed to physically striking people to gain compliance.
And are you referencing policy or training?
Training.
I believe so.
About 10, 15 years ago, agreed? Yes. And that was sort of highlighting the evolution, as you kind of described it in your direct examination, of policing since you've become a police officer. That's
yes.
One way it's evolved.
Yes.
And when something changes per policy, can't wear weighted gloves anymore, for example, that's it, no more. Agreed?
Yes, I agree, yes.
But if the policy, if training, for example, evolves into a best practice, it doesn't prevent an officer from learning a technique he learned earlier in his career. It just may not be the best practice anymore.
So I pause just to, when you say that they're learning something, but if it's not in alignment with our policy, then that would not be prohibited. If I'm hearing you correctly.
Let me try to explain. So if an officer was trained in a particular handcuffing technique, and then they go to their defensive tactics training and they say, this is a better way to handcuff a suspect, it's not a policy change, it's just a best practice change. And they can still use the old way they did it.
It would, Counselor, it would have to be something that the training staff would have to, not just an officer saying, I want to do it this way. And I mean, it's something that would have to be authorized through our training staff. Yes.
So we could talk about that kind of thing with the training, the use of force defensive tactics training, right? That would be the better place to talk, better people to talk to about that?
Yes, yes.
Okay. All right. Now, when we're talking about active aggression and active resistance, sometimes those two things are happening simultaneously. Agreed?
It can be, yes.
Go back to... So now we were talking then about, again, the Graham versus Connor case. and how that is incorporated into the Minneapolis Police Department policy. And I'm showing you Exhibit 217 now. It should be up in front of you. What we're basically talking about was a United States Supreme Court decision that outlined the objectively reasonable use of force standard, right?
Yes.
And Graham versus Connor is not limited to those three factors that you were read before, right? The Graham versus Connor analysis.
Yes, correct.
Those are three that are kind of listed, but ultimately it's not an all-inclusive list of considerations for the reasonableness of the use of force. Agreed?
That would be my understanding, yes.
And in fact, what the policy reads is that the reasonableness of a particular use of force must be judged from the perspective of the reasonable officer on the scene rather than with the 20/20 vision of hindsight, right?
Yes.
So we're looking at it in the instant and the moment based upon the objective standard, right?
Yes.
Now the policy also includes that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation, right?
Yes.
And that's because when officers go to a situation, kind of like what we talked about before, what can be initially very minor can grow into something major. Agreed?
Yes.
Now to show you Exhibit 219. You read a part of 5-304, which is threatening the use of force and de-escalation. And I want to talk to you a little bit about de-escalation. Have you heard the term, sometimes you have to escalate to de-escalate? You ever heard that phrase?
I have not heard that.
Okay. So in here you talk about, or the policy talks about, that officers shall consider verbally announcing their intent to use force, including displaying an authorized weapon as a threat of force, right? So sometimes an officer has to take out his gun, say, hey, I mean, that's a use of force in that instance, right?
Yes.
And if you don't listen to me, I'm going to use force. It's a pretty clear indication that force could be used when you have a gun pointing at you. Would you agree with that?
Yes.
But other things such as chemical irritants or tasers, it's not limited to just the firearm, right?
Yes.
And so sometimes what an officer has to do is command the presence, right? They have to take control of the situation.
Yes.
And sometimes that's not particularly attractive, is it?
Could you explain?
Sure. The use of force is not something that people like to watch generally, right?
Objection, speculation, and argument.
Sustained.
Would you agree that the use of force is not an attractive notion?
I would say that use of force is something that most officers would rather not use. Yes.
Right. And you described in your direct examination how the single greatest way that the Minneapolis Police Department could be judged is based upon how the public perceives its use of force.
Yes.
Right? So it has a tendency to garner a lot of attention.
It can.
So much so that citizens have become more prone to record observed interactions with police, right?
Yes.
Something that you didn't have to deal with back in 1989, right?
Yes.
So essentially what this policy 5-304 in terms of threatening the use of force, it's contained within this de-escalation concept, right? So sometimes you have to display a weapon to gain command so that you can de-escalate, right?
Yes.
Now, when we're talking about, is it fair to say that pretty much every single one of these use of force of policies contains some phrase, if reasonable or if practical? There's limitations on the use of force, right?
Yes, there are limitations, yes.
And it's situation by situation, right?
Yes.
And then again, if we go back and look at the language of the Graham versus Connor and the policy that's contained by Minneapolis Police Department, it's the use of force has no precise, objective, singular rule. It's different in every case.
Yes.
So for example, in the de-escalation policy 5-304B1, de-escalation is advisable when it is safe and feasible, correct?
Yes.
And sometimes de-escalation, again, includes the use of force, right? The use of force can be a de-escalation tactic.
Counselor, I was thinking of your example of displaying your weapon. And so I don't have a lot of knowledge in terms of physical force being used to actually de-escalate a situation. But the threatening use of force or threatening verbally, I'm more familiar with that.
Okay.
Yeah.
So again, if we were to talk to the use of force or defensive tactics,
Objection, argumentative.
Overruled.
they would be the best source of that.
Objection, argument.
Overruled.
Yes.
But the purpose of de-escalation, agreed, is to attempt to slow down or stabilize the situation so that more time, options, and resources become available to the officer.
Yes.
Basically, slow down, everybody kind of calm down, let's try to relax, right?
Yes.
But it's a lot more, the process of de-escalation is not just trying to talk somebody out of doing something. There are actions that are important, there may be reactions that are important, and the de-escalation policy includes some examples of those things, right?
Yes.
Such as placing barriers between an uncooperative subject and an officer.
Yes.
And sometimes those barriers are another officer, right?
Yes.
Containing a threat, right? I mean, that's one of the examples in policy.
Yes.
By containing a threat, that can include physically restraining someone so that they don't upset another person, right?
Yes.
Or cause another person to have a violent reaction towards them or officers, right?
Yes.
Moving from a position that exposes officers to potential threats to a safer position, right? So kind of retreating in certain circumstances.
Yes.
Reducing exposure to a potential threat using distance, cover, or concealment, right? So hiding, say, behind a squad car, right?
Yes.
Avoiding physical confrontation. That's probably a pretty big one, right?
Yes.
And using verbal techniques to calm an agitated subject or promote rational decision-making. That's kind of down towards the end.
Yes.
And lastly, calling additional resources. Right?
Yes.
And we talked about Exhibit 230. Showing you Exhibit 230, which is the emergency medical response. You'd agree that the policy requires Minneapolis police employees to request an emergency medical service as soon as practical, right?
Yes.
If a person comes into contact having an acute medical crisis, and any delay in treatment could potentially aggravate the severity of the medical crisis, right?
Yes.
So sometimes officers will call for EMS, not thinking it's a major issue. When suddenly it becomes apparent, they can step up or request a quicker response from EMS, right?
Yes.
And that is something that an officer can do to ensure the medical treatment of the suspect that they have or the person that they're in contact with, right?
Counselor, to ensure,
sorry, it's been a long week. To ensure the medical condition of the suspect, to help with that.
Yes.
Right. Get EMS there as quickly as is possible. Right?
Yes.
Now, we didn't talk about the maximal restraint technique. You're familiar with the policies surrounding that?
Yes.
I'm going to show to you what's been admitted as Exhibit 225. Can you describe what the maximal restraint technique is?
Yes, Counselor, the maximal restraint technique has often been referred to as the hobble. And that is it's a method of, if officers are dealing with typically a combative or aggressive person, in order to protect them or even property, it's placing, basically attaching a cord of the legs to the waist, so that the person, the individual, does not have free movement of their legs. So it's securing them, again, usually by their ankles. If you're prone, bringing that up to your waist and securing it. The maximal restraint technique, or the hobble, though, if it's used, a supervisor has to respond to the scene. You cannot transport anyone prone in that position due to the risks of the breathing. But that is Counselor, that would be my understanding of the MRT, or the maximal restraint technique.
So you talked a little bit in terms of the use of force, how officers are kind of reevaluating their use of force from time to time, right? They
Yes.
should be, at least, right? And so if officers decide to use the maximal restraint technique and then decide, hey, we know, and then later decide not to use it, right? That is kind of adjusting that use of force.
I would, Counselor, with some clarity, I don't know if that, what I mean by that is, if you were to have a person handcuffed and prone on their stomach on the ground and pavement, and you had two officers, let's say, securing their legs to the back of the waist, you in a way are still employing what that technique is about anyway. So there can be some variances to that.
Sure.
If that makes sense.
It does. So let's assume that you've got two officers pulling the legs forward, essentially employing that aversion, so to speak, of the maximal restraint. But then they release and they say, we're not gonna hobble this person. We're not gonna employ the MRT. You're going from a decision to employ that technique backwards down the continuum in terms of the use of force. Would you agree with that?
And Counselor, I just because these types of uses of force can be problematic in terms of there's a high risk to them. So meaning that if you're going to take that initiative to do that alternative version in the first place, you'd want to get a hold of a supervisor, because something could happen in terms of that person. And so
I'm not asking in terms of the policy. I'm asking in terms of sort of the use of force and the critical decision-making model, right? You described how the use of force, you have to go through this critical decision-making model. How much force am I going to use? And sometimes you have to back off the use of force. Agreed?
Yes.
And sometimes you have to go forward with the use of force, meaning you use even more force.
Yes.
Right? And it's this constant reevaluation Agreed?
Yes.
And so when you have officers who make a decision that the facts and circumstances would warrant using the hobble device, but then later decide not to employ that device, that is that critical decision-making model in action. Agreed?
Yes.
And it would be a reduction in the use of force. It may still require supervisors to be on scene, policy-wise, but it is a reduction in the use of force. Agreed?
And Counselor, are we talking specifically the events of May 25th?
I'm talking generally.
In general, yes.
But you would agree ultimately that all of the Minneapolis Police Department policies relevant to the use of force, emergency medical response, emergency medical treatment, all of these policies are, by their very language, are situationally dependent, right? They all say, if the circumstances allow, if time permits, if it's safe. They have a qualifier to them. Agree?
Yes, I would agree with that.
I'm going to show you Exhibit 231. Which is at the bottom of Exhibit 231 is the crisis intervention policy. And the second page includes the definition. Could you read the entire definition of what a crisis is?
Yes. An event or situation where an individual's safety and health are threatened by behavioral health challenges to include mental illness, developmental disabilities, substance use, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may, but not necessarily, result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to himself, herself, and or others.
All right. So generally speaking, again, not relevant to the May 25th of 2020 incident. We'll get there in a minute. But when we talk about a general police response, sometimes the police may respond to something and the person they're dealing with is not in a crisis. Agreed?
Yes.
But other people may be perceiving what is happening and it could become a crisis to that person.
Objection. If you could rephrase.
Sure. People who observe, would you say that people who observe police interactions with people, especially the more physical or use of force types, that could turn into a crisis for an observer?
Objection irrelevant.
Sustained is calling for speculation.
So in terms of the definition of crisis, a crisis may involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds that individual's current resources and coping mechanisms, right?
Yes.
That doesn't necessarily mean that you are the person with whom you are arresting or having contact with is going to be the person who will experience the crisis. Agreed?
Objection irrelevant.
Overruled.
And Counselor, just respectfully, so you're saying that the person who's witnessing a situation with the officers, that situation may cause them to be in crisis?
Correct.
Could potentially.
Right. And the crisis may, but not necessarily, result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to him, her, or others, right?
And Counselor, just this is the person who's watching this?
Right.
It could.
So people are watching what something that they appear to believe or they believe is wrong or contrary to police policy that may cause them to get upset, and that level of upsetment or that level of volatility may grow throughout the course of the interaction.
Objection, irrelevant, calls for speculation and beyond the scope.
Overruled. It's within the scope.
It could.
Because ultimately, part of the training that Minneapolis police officers have to go through is how to deal with crowds who observe police interactions, right?
Yes.
Crowds that may be upset with police interaction, right?
Yes.
I mean, there are classes through the training academy, there are classes through in-service specifically dealing with how to deal with crowd control, right?
Yes.
And all of this is to revert in part back to that de-escalation process as well, right?
Yes.
So part of it, as a crowd grows or becomes more upset, part of it is to try to de-escalate, which can involve trying to avoid a physical confrontation, right?
Yes, it could. Yes.
Trying to stay safe, concealed, and covered, right?
Yes.
Not yelling back at somebody, not engaging with them verbally, right?
Yes.
And sometimes when an officer tries to de-escalate a situation and someone is so upset, right? Sometimes they don't hear what the officer tells them. Would you agree with that?
Objection, speculation.
That calls for speculation. It is sustained.
Is it possible, generally speaking, that someone's own crisis may prevent them from hearing what an officer is telling them?
That could happen.
Hold on. The objection is sustained. The answer will be stricken.
So you testified that you've watched the body cameras, correct?
Yes.
Going to show you, I don't know. Mr. Slisher, this is exhibit 1008, which is a 10-second, approximately 5-second clip of Alexander King's body-worn camera. It's already and I gave you a copy of it.
Is this in evidence?
Not yet, no. I'm just telling you, first and foremost, that's what it is. I'm going to show you on your screen a short clip of a video to see if this would be contained in what you've watched. And I need to... You would agree that that appears to be taken from one of the officer's body cameras, May 25th, 2020, at approximately 20:25 and 33 seconds.
Yes.
Again, watching it without sound. Do you, at this point, did you see what appeared to be a reflection in the back of the squad car there?
Counselor, I did not.
Okay.
And it might just be because of the brevity of the video, but.
Yeah, it's unfortunate. If you look in the upper left-hand corner at the bumper of the squad video.
The cursor to circle it for him.
I'm sorry?
Use the cursor, the stylus to...
Oh, sure. That's right. Forgot all this fancy technology here. See the legs of someone reflecting?
Yes.
And so you would agree that this appears to be a short clip from one of the officer's body-worn cameras on May 25th of 2020?
Yes.
You've seen these before. You see what appears to be Mr. Floyd's arm there by the back of the squad car, right?
Yes.
So I would offer Exhibit 1008.
Any objection?
No objection.
1008 is received.
And if I may publish. Come over here.
Up on the sidewalk.
Yeah, we need you to keep some distance. Sorry, didn't mean to reply. You hear a voice say we've got an ambulance coming?
Yes.
Oops, sorry, if we could take that down. Now, policy 5-311. Let's talk a little bit about 5-311, which is the neck restraint policy. Get rid of this.
Council, will you stay there for a second?
Sure.
Welcome everyone here to News Now from Fox. We are listening to extensive cross-examination here of the Minneapolis Police Chief. At the center of today, they are talking about, okay, what is proper use of force? And we are getting all the details here. Oh, looks like we're going to have something.
Mid-afternoon break. We'll reconvene around 3:20. Thank you.
All right, so about a 20-minute break right there. We just heard from the judge here. But as I was saying, what we were talking about was use of force here and just how far it extends for police officers and when they have to use that use of force and when they have to almost bring it down a notch or accelerate it as well. Let's listen to some of the coverage here from Fox 9 Minneapolis.
Those witnesses today is Minneapolis Police Chief Medaria Arradondo. He spent a good number of time this morning talking about police department policy and what officers are trained on. And then some of the questioning, as you may have heard this afternoon, led directly into the incident where George Floyd died, talking about use of force and de-escalation policies. In fact, some of his quotes here today, he said, "I absolutely agree that this violates department policy. Once Mr. Floyd had stopped resisting and was in distress and started to verbalize that, this should have stopped." And that's directly from Police Chief Medaria Arradondo on the stand here this afternoon. I want to bring in one of our legal experts to talk a little bit more about this. Ryan Pasiga is a criminal defense attorney who is not tied to this case. Ryan, what did you pick up on here in court this afternoon?
Well, number one, the chief, he's a real professional witness, right? Very likable, very articulate, a powerful witness for the state to have. But, you know, as we predicted, right? So the prosecution is going to take them through all of the policies. And it makes me think of workplace issues, for example. Every workplace that we've ever been has these policies that look really nice on paper. And yes, they're written policies. Some are aspirational. Some are actual rules in the workplace. But how many times are we all sort of familiar with that divide between the people that are in upper level management, if you will, and the people who are in the trenches dealing with the customers every day or in the warehouse every day and the like, and that disagreement between, hey, you people in upper management think everything works like this, but if you were doing our job in the trenches or the police officer on the street, these ideas sound really nice, but they're not always practical. So we're getting a little bit of that feeling now in the cross-examination, I think, between, hey, all right, there's written policies, yes, but these are fluid situations and there are a lot of qualifiers, and it's easy for us to armchair quarterback and say, well, the policy says this, or there's this nice diagram that points to these things. When you're in the heat of the battle on the street and you're a police officer or you're an everyday blue-collar worker out there somewhere, sometimes you're saying, listen, you don't understand how these policies really affect us, and you're not feeling what I'm feeling. And that's the theme the defense is trying to get out there right now.
In fact, I thought one of the key exchanges here this afternoon within the past half hour was defense attorney Eric Nelson questioning the chief and saying, Chief, the use of force has no precise singular rule. It's different in every case, right? And the chief said yes.
That reminds me of that old United States Supreme Court case from the 60s, Justice Stewart, when he was trying to define obscenity or pornography, and he said, I don't know how to define it, but I know
I know it when I see it, right?
Yeah.
Very famous case.
Yeah.
Now, I'm trying to put myself in the seat of the jurors as they're listening to this. How much do you think that they're paying attention to this cross-examination, and how much about the credibility of the police chief? Because you've already established that he was a really good professional witness. What tends to override in the jury's minds and with this?
Well, I think they're gonna take his testimony in view for now, but then they're gonna revisit it in cross-examination and put it all into context. Yes, he's professional, he's courteous, he calls Mr. Nelson counsel. He doesn't necessarily argue with him, although he does qualify things from time to time. And what makes him really credible, I think, is that he makes concessions where we know he's got to make a concession. He won't fight it if there's no point in fighting it. That makes him more credible and, to a degree, more difficult for Mr. Nelson to handle.
All right. I see Paul Bloom is joining us now, and he's probably getting in his earpiece. Paul, can you hear us?
Yeah.
All right.
Yeah, Tim, how you doing? Yep.
Paul, quite an afternoon in court already, and one of the things that stood out to me was not only the chief talking about the policies and how he believes that Derek Chauvin violated some of the department policies, and not only training, but use of force and de-escalation and failure to render aid here, but also how he learned about the video that spread virally on social media and how he got that call at midnight from a member of the community saying, Chief, have you seen this yet?
Yeah, I thought that was interesting, Tim. You know, we sat down with Medaria Arradondo one-on-one in the immediate aftermath. I remember going through his thought process here. I don't remember hearing that anecdote from him at that point, but you are right. He initially gets the call from a deputy chief. He's at home. Told that, you know, there's this incident where, you know, a subject may not make it at the hospital. So he goes into the office. He immediately knows at 38th in Chicago outside Cup Foods, just from prior knowledge, that, quote, milestone camera, the city surveillance cameras that are across the city. He knows there's one on top of basically the Speedway signage right across from Cup Foods at 38th in Chicago. And he asks to see it. He acknowledges that he saw it in that moment. You know, he had maybe some concerns in that, you know, a subject wasn't well after the arrest, but certainly couldn't tell much from the high in the sky camera angle. But then, yeah, a couple hours later, he gets a call from the members of the community. Obviously, at this point, Darnella Frazier's Facebook video is circulating widely. And this resident told him, Chief, there's an issue. You got to take a look at this. And then you heard him basically respond to seeing it, the 10 minutes, the 9 minutes, 29 seconds we now know the prosecution is using in terms of the knee on George Floyd's neck, and he immediately goes into action. It is interesting, while some of the things he's talking about, obviously violations of department policy, you will note he did not call this situation murder, as he has done publicly outside of the courtroom. Obviously, the judge is limiting where Chief Medaria Arradondo can go with his opinions. Right now on the witness stand, he said, you know, blatant departmental violations, but doesn't say anything criminal. He also hasn't been allowed to say that he fired the officer, right, during his lengthy testimony so far on direct and now somewhat into cross-examination. So I know Judge Cahill has kind of limited where Medaria Arradondo can go. They built it up all kind of morning into the early afternoon, sort of explaining Rondo's position, the department's position on policies, and then finally getting to this kind of crescendo where Steve Schlischer got out of him that, yeah, basically he violated all sorts of departmental policy. But some interesting testimony. But again, what the jury is going to get is a little different. What we've consumed publicly since day one, I find that extremely interesting.
All right, Paul, thanks. I want to bring Ryan back into the discussion here for a moment, picking up on what Paul was just talking about. And that is Medaria Arradondo was very public in his characterization of this incident as murder. Do you expect the attorneys to bring that out here this afternoon?
Absolutely not. They won't be able to, and here's why. There are motions in limine. We heard them argued during jury selection, if you remember, each morning. And one of the issues that are always limited is the ultimate issue to be decided by the jury. For example, we have a motion in limine saying you can't refer to the person as a victim in the trial because that's the ultimate issue to be proven. If it's an assault case, for example, are they a victim or aren't they a victim? Is this a murder or isn't it a murder? That's for the jury to decide. So to have the chief reach a legal conclusion in this trial about the ultimate issue to be decided by the jury is improper. And that's why the judge will not let any witnesses go there on whether or not this is murder or even manslaughter or not. They cannot offer a legal opinion as to the ultimate issue to be decided by the jury.
You know, you're a seasoned veteran of the court yourself, and based upon what you've seen so far, what do you expect that we will hear yet this afternoon?
Well, I think Mr. Nelson is going to continue to try to cleaver off the chief and the aspirational or training modules in terms of that from the real world experiences and some of this perhaps speculation even about, well, you see Floyd's face, for example. Does that mean that Mr. Chauvin was kneeling hard on his neck, or does it mean that Floyd was uncomfortable from the breathing, or could it be some other causes as to why his face is like that, for example? In other words, you don't know for sure. So you've got this training. Reasonableness is a fluid thing. You're not even sensing necessarily what Chauvin may have been sensing. For example, for the sake of argument, right? Maybe Chauvin's telling his lawyer, hey, when I'm kneeling on his neck, it looks like I'm pressing hard, but I'm not. In fact, I'm varying my weight. Sometimes I'm pressing a little hard. Other times I'm barely pressing at all. Other times if I'm feeling his shoulder blades squirm, I'm worried he's going to get up again. So I press for another minute. We don't know these things. None of us do. And so Eric may be trying to next get the office or the chief to make some of these admissions or concessions that we necessarily do not know those things. So far, I think he's done a pretty good job of talking about the differences or the qualifiers that are in these different areas of training that we've been talking about now. And I would think he would keep going there if he wants to, and if he can.
I think one of the fascinating tactics by Mr. Nelson here this afternoon is getting back to that variance, or the variable rather, of de-escalation techniques and how it ramps up and then maybe you scale back a little bit. Precisely what you've just been talking about, and how feeding into that now is the reaction and the anxiety of the people on the sidewalk.
Yeah, there is that. And so that's very interesting as well. And look, no matter, to a degree, no matter how much Mr. Nelson does try to point out those differences or the things that we don't necessarily know that maybe only Chauvin knows because the other officers aren't going to be testifying in this trial. At the end of the day, we still have some pretty damning testimony from the chief, right? Saying, look, this is absolutely in violation of our policies and for a number of different ways. And the chief not only comes up as somebody who really knows this training well and has been around enough to know where this barometer or where you define beyond reasonable, but a guy that really cares about his community in the beginning of his testimony as well. And I think has his heart in the right place as a police officer. So a jury is really going to strongly consider what this chief is saying. That's a big hurdle for the defense to overcome.
What do you suspect was the most powerful statement from the chief that will stick in the minds of the jury?
Yeah, I wrote it down. I mean, it was basically, that action is not de-escalation. That was a big one when he was just flat out saying that this isn't resisting anymore. The guy's handcuffed. He's got a couple officers on top of him. Maybe at first it's okay to do this, but after we see that, and then maybe more testimony on redirect, maybe after we see him what looks like stop breathing and not resisting at all and continuing to do this, even light pressure at that point isn't okay. I mean, that's really heavy, difficult testimony for the defense.
And I also think the chief and this is for your analysis here, but I respect what he did off the top in trying to lay down some foundational universal truths of what he believes about the department. And one of those universal truths is that they respect the sanctity of life, and everything kind of seemed to flow from there.
Yeah, that's powerful as well. I mean, look, I'll tell you, to be fair, as a defense lawyer, there are times where I'm hearing the chief talk about these ideals with the police department, and we know, because we see a lot of cases, that those ideals aren't always lived up to, all right? And so those ideals can sound nice and aspirational and what we would want in any community for policing, but the reality is it doesn't happen all the time. So I think, Mr. Nelson's got to bring that out and say, yeah, it's very clear you care about your community and these are the things we want. But let's be fair. These things happen in a lot of different things. And Eric brought that up to a degree. Traffic stops can get dangerous. Officers can get in fights. These sorts of things can have to happen. Even hobbles once in a while have to happen. So as much as we want it to be more about community policing and more recognition and of the human element and this evolution of probably smarter policing now that we have, at the end of the day, at times it can be a very ugly job and a very dangerous job. And just like war is ugly, policing at times can get very ugly.
Ryan Pasiga, criminal defense attorney. Thanks for sharing your time with us here this afternoon to dive into some of the legal analysis of this so far. Deeply appreciate it.
You bet.
We want to remind our viewers that we are in the middle right now of a break inside the courthouse. They usually take about a couple of breaks in the afternoon. They typically last about 15 minutes, and we will rejoin that coverage here once they are back here in the newsroom. But I want to bring in our Hannah Flood here at the moment, because she's been watching all of this too and is dialed into some specific pieces of sound for us to listen to this afternoon. Some very powerful testimony here from Chief Arradondo, right, Hannah?
Yeah, absolutely. And I have to say, things started a little slow. And I think this is something that we're going to see with more of our expert witnesses during this testimony over this next week. The chief had to use, a lot of time you went through with the state talking about his credentials, his history with the department, different ways that they train officers, different policies. So kind of a slow start. But then in the afternoon, we did get into some really interesting sound of the chief kind of giving his opinion about what he was seeing. I do also want to note, as you know, because of COVID, there are a limited number of reporters who are allowed inside the courtroom at any given time. So we have pool reporters who are in there, and then they send us notes about things that they're observing. And I just found this note really interesting. So as they were coming back into the courtroom after the lunch break today, there's a note from a reporter saying that Nelson held open the door for Chief Arradondo. And Nelson says to Arradondo, "Hey, do you remember the Roosevelt fight song?" And it said Arradondo's face kind of lit up. He didn't know that Nelson also graduated from the same high school that he did. Nelson goes on to say that he was in the class of 92, and Nelson says, "Hey, my older brother actually went to school with you." So I think that that's kind of an interesting exchange, interesting things that we're not seeing being able to be in the courtroom because of COVID. But just kind of fascinating that they have this little exchange at the doorway, and then they go into the courtroom. Nelson takes the podium, Arradondo takes the witness stand, and they begin this line of questioning. So that's just a little note from inside the courtroom. But Tim, I do want to play some of that sound of Chief Arradondo answering questions kind of about his opinion of Derek Chauvin following the department's policies. So we have a little bit of that sound for you now. Again, this is Steve Slisher asking Chief Arradondo about MPD policies.
Based upon your review of all of the information that you just mentioned, do you believe that the defendant followed departmental policy 5-304 regarding de-escalation?
I absolutely do not agree with that.
And how so?
That action is not de-escalation. And when we talk about the framework of our sanctity of life, and when we talk about the principles and values that we have, that action goes contrary to what we're taught.
As you reflect on Exhibit 17, I must ask you, is this a trained Minneapolis Police Department defensive tactics technique?
It is not.
Well, we read the departmental policy on neck restraints. Is this a neck restraint?
The conscious neck restraint by policy mentions light to moderate pressure. When I look at Exhibit 17, and when I look at the facial expression of Mr. Floyd, that does not appear in any way, shape, or form that is light to moderate pressure.
So is it your belief then that this particular form of restraint, if that's what we'll call it, in fact violates departmental policy?
I absolutely agree that violates our policy.
Are you aware now that the defendant maintained this position on George Floyd for 9 minutes and 29 seconds?
I am aware of that.
I believe you testified that force has to be reasonable when it's applied at the beginning and through the entire encounter. Is that right?
That is correct.
Is what you see in Exhibit 17, in your opinion, within Minneapolis Police Departmental Policy 5-300, authorizing the use of reasonable force?
It is not.
And why not?
That is, it has to be objectively reasonable. We have to take into account the circumstances, information, the threat to the officer, the threat to others, and the severity of that. So that is not part of our policy. That is not what we teach, and that should be condoned.
All right, we want to let our viewers know that the juror has re-entered the court, and we are now joining back our continuing live coverage of the trial of Derek Chauvin.
5-311, correct?
Yes.
Exhibit 224. You have that in front of you there?
Yes.
So there are, is a difference, the policy draws a difference between a chokehold and a neck restraint, correct?
Yes.
A chokehold is actually from the front, obstructing or occluding the trachea and airway of the suspect, correct?
Yes.
And per Minneapolis policy, that's considered a lethal use of force or a deadly use of force, right?
Yes.
And that's because it has a high rate of death associated with it, right?
That is correct.
It's more dangerous to from the front.
Yes.
It also differentiates between a chokehold and a neck restraint. Agreed?
Yes.
And a neck restraint is specifically defined as compressing one or both sides of a person's neck with an arm or leg without applying direct pressure to the trachea or airway. Agreed?
Based upon the policy, I think it's important to note, Counselor, that the light to moderate pressure.
Right, understood. Light to moderate pressure.
Yes.
And I'm assuming that you don't have a degree in physics.
I do not, Counselor.
Okay. And in terms of the amount of pressure or force that was actually applied to Mr. Floyd, you would not be qualified to speak to that. Agreed?
Agreed.
But then it also differentiates between a conscious and an unconscious neck restraint, right?
Yes.
And a conscious neck restraint is where you have someone who is resisting you and you apply that neck restraint in an effort to simply gain control of that person, but they stay conscious, correct?
Yes.
And an unconscious neck restraint is where you actually render the subject unconscious, right?
Yes.
Both were permitted under Minneapolis police policy on May 25th of 2020. Agreed?
Yes.
And ultimately, you have, if I understand what you have, the opinion that you have formed the opinion that this was a neck restraint that was being employed.
Yes.
And you have also formed the opinion that this was an unconscious neck restraint. Is that correct? Oh, excuse me, a conscious neck restraint.
Yes.
Okay. You're familiar, you testified on direct examination that it is contrary to the training that you've received to place your neck or your knee on a subject's neck.
Counselor, if I can clarify, it is contrary to our training to indefinitely place your knee on a prone, handcuffed individual for an indefinite period of time.
So the issue that you take with it is the length of time?
Counselor, there's a couple of issues, and one of those, again, is, as you noted, receiving the information. Is the person a threat to the officers or others? What is the severity of the crime? Are you reevaluating and assessing the person's medical condition? So all of that critical thinking, that's really key for me in terms of why I vehemently disagree that that was the appropriate use of force for that situation on May 25th.
Now, when we talk about that critical decision-making model, that critical decision-making model doesn't only apply to the specific subject that you have under your control, correct?
And Counselor, so we're talking about, is this the bystanders?
Would you mind moving the microphone back just a little?
Your Honor, my apologies.
No problem.
I think we just got a loud voice.
Sorry about that.
That's all right. Well, I'm talking about bystanders. I'm talking about other officers. I'm talking about other things that come into play in terms of the officer's critical decision making.
And I apologize, Counselor, if you could just rephrase that question again.
When an officer is engaged in the use of force, and I'll just phrase it as a yes or no, their attention is not exclusively necessarily focused on the subject of whom they have in custody. Agreed or disagree?
The officer that is engaging in the use of force may be viewing other matters?
Correct.
That would be yes.
Right, and in fact, that's what the de-escalation model talks about, is looking at things from a tactical advantage or disadvantage. Agreed?
It's one of the portions of it.
Right. Specifically in the policy, de-escalation has to be applied, assuming that it's safe to do so, right?
Yes.
And all other tactical considerations. Agreed? That's what the policy says.
Yes.
And in terms of those decision-making, an officer, it's not a singular decision-making process that's happening in the course of an arrest. Agreed?
Yes.
So an officer has to be concerned about other things that are known to him at that time. Agreed?
Yes.
So some of those things would be, what just happened between me and this subject a few minutes ago, right?
Yes.
I just fought with this subject a few minutes ago. I'm talking generally here. I just fought with this person generally a few minutes ago. He now seems to be not resisting, but that doesn't mean he can't resist again, right?
Yes.
Even if he's handcuffed, right?
Yes.
And so even if he's handcuffed, someone can still, they're not threatless if they're handcuffed. Agreed?
And Counselor, this is just a general hypothetical.
Right.
Yes.
Right. Someone who is handcuffed can be equally as a threat to an officer as someone who's not handcuffed.
Yes.
They can kick, and they could bite, they can spit, they can do all sorts of things. Agreed?
Yes.
Now, in terms of the use, so I just want to make sure you form the opinion that this was an unconscious neck restraint, right?
Counselor?
On May 25th of 2020.
That it was a conscious neck restraint.
Conscious neck restraint.
Yes.
Okay. Now, again, in this whole de-escalation, officers have to take into consideration the safety of the crowd, right?
Yes.
They have to take into account the reactions of the crowd, whether they're angry or hostile or just simply watching, right?
Yes.
That's all a part of this critical decision-making model, right?
Yes.
They have to be aware of their surroundings, right? Generally speaking. Being on a busy street versus being in a park, right?
Yes.
Different decision go into that, right?
Yes.
Knowing that I have other officers that are in place and may be at risk as well, right?
Yes.
So there's lots of, the critical decision-making model is not singular in its application.
That's correct.
Lots of information coming in very rapidly, right?
Yes.
So I'm going to show you first, and I believe by stipulation, or at least without objection, I'm going to play a few minutes, or excuse me, a few seconds of Ms. Frazier's Facebook video. So at this time, I'd offer Exhibit 1018.
No objection.
Permission to publish.
1018 is received. You may publish.
I'm going to pause it here, sorry. This appears to be sort of that time, that picture that was shown to you earlier, Exhibit 19. This is that general time frame that picture appears to be taken from.
Counselor, yes. I'm sorry. Was that that's the question? I'm sorry.
Oh, yeah. This appears to be that image you were shown on direct examination, that static Exhibit 19, right?
Yes.
Shows Officer Chauvin, shows Officer Mr. Floyd, it shows Officer Tao.
Yes.
And it shows the perspective of the Miss Frazier's phone. Chief, are you familiar with the concept of camera perspective bias?
I am not, Counselor.
Okay. Now again, if I may take that down, a stipulation, I'm going to show that same time frame, Exhibit 1019, that same perspective from Mr. King's body camera. And I'd offer 1019. 1019.
Any objection?
No objection.
1019 is received.
Wish to publish, Your Honor. Agree it appears to be the same time frame?
Yes.
All right. Now lastly, Chief, I'm going to show you one last video. If we could take this down, Your Honor. I would offer Exhibit 1020, which is a side-by-side of the two.
Any objection?
No objection.
1020 is received.
And permission to publish. Pardon? Oh. I just started it over, if that's okay. You would agree, Chief, that from the perspective of Miss Frazier's camera, it appears that Officer Chauvin's knee is on the neck of Mr. Floyd.
Yes.
Sorry, I didn't mean to do that. Would you agree that from the perspective of Officer King's body camera, it appears that Officer Chauvin's knee was more on Mr. Floyd's shoulder blade?
Yes.
I have no further questions.
Mr. Slusher.
Thank you, Your Honor. Chief, let's start with what you just saw, and you testified that the particular moment in time that you were viewing Officer King or former Officer King's body-worn camera, it appeared at that moment in time that the knee of the defendant was more towards the shoulder blade. Is that right?
That is correct.
That was at a time where the ambulance had already arrived?
Yes.
Very shortly before they loaded Mr. Floyd onto the gurney?
That is correct.
And in your view of the body-worn camera footage and everything you reviewed prior to testifying today, did you see the defendant's knee anywhere but the neck of Mr. Floyd up until that time?
That is correct.
And so the knee of the defendant was on Mr. Floyd's neck up until the time you just pointed out?
Yes. When I viewed that video portion, that is the first time that I'd seen the knee of the defendant on the shoulder blade area.
And that was right before the paramedic came?
That is correct.
Now, looking at and talking about the neck restraint policy, if you show Exhibit 17, please. Oh. So, looking at Exhibit 17, was it your testimony that Exhibit 17 is not a trained MPD neck restraint?
Correct, that is my testimony.
And I'd like you to reflect on the exhibits that you were shown by defense counsel, exhibits 1008, 1019, and 1020, the 10-second clip. Okay. During that period of time, which is much later than the point in time we see here, did you see any indication that Mr. Floyd was actively resisting, as that term is defined in Minneapolis Police Department policy?
I did not observe Mr. Floyd to be actively resisting during that time.
Did you see, same question, same time period, any indication that Mr. Floyd was being actively aggressive during that 10-second clip that you were just shown?
No, I did not observe Mr. Floyd to be actively aggressive during that short video.
Could you even say that he was passively resisting at that time that you were shown those exhibits?
No. As a matter of fact, as I saw that video, I didn't even know if Mr. Floyd was alive at that time.
I want to revisit a little bit of the testimony on cross-examination about the use of the MRT or the hobble, right? And if I'm to understand your testimony, you indicated that A hobble is a strap that's used to connect a handcuffed person, their waist, the arms, and the legs to restrain them. Is that right?
Yes, that is correct.
And what I thought I heard you saying in response to questioning by counsel was that you can do an MRT effectively, right, without using a hobble when you're doing the same thing but with your hands.
Yes, that is correct.
And did I understand your testimony to essentially be that that's what these officers were doing, was essentially using the maximal restraint technique but not using the hobble?
That is correct.
And pursuant to departmental policy, the hobble is the only authorized way to employ the maximal restraint technique. Is that right?
That is correct.
Are you aware that the use of the actual hobble requires a supervisor to report to the scene and do a force report?
Yes, the supervisor must arrive at the scene and do a report.
But that would be avoided if the hobble itself wasn't used, or?
No, if you're still employing that sort of technique, again, with a prone individual handcuffed, and you're basically doing that maneuver, and because of the severity of risk to, and certainly that would have been to Mr. Floyd, you would have contacted a supervisor.
And aside from that, I mean, if you're using an MRT, you are supposed to adhere to departmental policy. Is that right?
That is correct.
And the Minneapolis departmental policy for the use of the MRT requires an officer to do what as soon as the MRT is applied?
Again, because of the severe nature of making sure that that individual can breathe, we have to get that individual into a side recovery position to make sure that their airway is not obstructed. And so that's paramount.
So, and that's required by policy, and the side recovery position is supposed to be instant. Is that right?
Immediate.
And you indicated that it has to do with breathing. You're familiar with the term positional asphyxia?
I am.
Is that one of the dangers of leaving somebody in a prone, handcuffed position for too long?
Yes, positional asphyxia. We again, as I mentioned, we cannot transport people in that position if they're prone, handcuffed, and there's pressure around their airways or on their back. The risk and potential for them and us killing them goes up substantially. So that side recovery position is very critically important.
I want to follow up on some of the questions about your own personal training and that of different officers in different roles within the Minneapolis Police Department. Different officers can attend other types of training, is that right?
Yes.
But everybody's required to do in-service training, is that true?
That is correct.
And regardless of where somebody trains, I mean, the rules are the rules, right?
Yes.
And the policy applies to all MPD officers.
Yes.
The question was posed regarding the critical decision-making model and the need to take in information. And that's true, correct?
Yes.
When we're looking at the proper and authorized use of force under departmental policy, is it fair to say that the amount of force an officer can use depends upon the conduct of the subject, the person upon whom the force is being used?
Yes, it's fair to say that.
So, for example, if you had me in, let's say, a dangerous hold, right, would you be able to continue to keep me in a dangerous hold based on something somebody else is doing?
I'm sorry, if you could explain that, I'm sorry.
So, for example, if you found the need to place me in some sort of a hold that's dangerous.
Yes.
But something that you see, say the judge is starting to pick something up to throw at me, would that justify you using more force on me?
No.
And in terms of de-escalating the crowd, you indicated that there's some potential need to de-escalate a crowd, a group of people. Is that right?
Yes.
Because a group of people can experience something that they find shocking or upsetting, and that can, place them in some kind of an emotional state. Is that right?
That's correct.
And you may need to turn your attention to and de-escalate the crowd.
Yes.
Would one way, if we can show Exhibit 17, would one way to de-escalate the crowd who's experiencing something shocking to stop doing the thing that's shocking them?
Absolutely.
I have nothing further.
Any recross?
Thank you. Very briefly, just one question. There are certain circumstances where an officer has to kind of freeze the situation, evaluate, hold the person until he or she can decide what's the safest way to move forward. Agreed?
Agreed.
Sometimes you just have to kind of hold the person, correct?
Yes.
And that's something that happens fairly frequently. Agreed?
Yes.
And so one other question with respect to the policy regarding the maximal restraint technique and putting a person in the recovery position or the side recovery position, you said it was immediate. Agreed?
As soon as you're able to do so, yes.
Right. And that's actually what the policy says, is as soon as you're able to do so, right?
Yes.
And there are certain circumstances under which you may be using force where the force has to be dealt with before you can turn your attention to rendering medical aid, right?
And Counselor, just so that, are we still talking about someone in the recovery position or the hobble?
Just generally.
Can you repeat that? I'm sorry.
Sure. There are certain circumstances where a use of force needs to be continued for some reason to deal with something else before you can deal or render medical aid. Let me give you an example. We're in a gun battle, right? You and I are shooting at each other. I'm the cop, you're the bad guy, and you hit my partner. I'm going to continue to use my force against you before I can go render medical aid.
Counselor, in that hypothetical, yes.
Thank you.
Briefly.
Sometimes it's necessary to freeze a scene and to hold an individual, correct?
Yes.
But you have to do so safely. You have to hold the person safely. Isn't that correct?
That is correct.
Nothing further.
All right, thank you, Chief. You're
Your Honor,
excused.
thank you so much.
Next witness. All right.
All right, so they are in a side panel right here as we continue on right here on News Now from Fox. Next witness will be coming up. We're going always gavel to gavel right here.
All right, next witness, please.
Thank you, Your Honor. The state calls Katie Blackwell.
You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
And if you don't mind taking off your mask, great. Let's begin by having you state your full name and spell each of your names.
Okay. Katie, Katie, Marie, Marie, Blackwell, Blackkwell.
Mr. Slusher.
Thank you, Your Honor. Good afternoon.
Good afternoon.
How are you employed?
Through the Minneapolis Police Department.
What is your current position?
My current position is the inspector of the 5th Precinct.
Right. How long have you been the inspector of the 5th Precinct?
Since January 31st this year.
What was your immediate rank and assignment prior to that?
The commander of the training division.
Now, I'd like you to tell the jury a little bit about yourself. First, could you tell us about your educational background in law enforcement?
Sure. So my 2-year associate's degree is in law enforcement through Minneapolis Community and Technical College. My 4-year bachelor degree is in police science through St. Mary's University. My master's degree is in public safety administration from St. Mary's University. I'm a graduate of the Northwestern Police Staff and Command, and I'm just about to complete a 2-year course in United States Army Sergeant Major's Academy, which is equivalent to a master's in leader.
So in addition to being a police officer, you're also in the Minnesota National Guard, is that right?
I am.
At what rank?
E9 Sergeant Major.
And just for the uninitiated, can you describe where that falls within the ranks of the enlisted?
That is the top enlisted rank that you can achieve.
How long have you been in the Minnesota National Guard?
Over 23 years.
Have you ever deployed?
I have.
Where?
To Bosnia on a peacekeeping mission, and then to Iraq for almost 2 years on a Operation Iraqi Freedom.
Thank you. Can you please tell the jury when you began your law enforcement career with the Minneapolis Police Department?
Sure. So in 1999, I worked with the 2nd Precinct Community Response Team in the neighborhood I grew up in, Northeast Minneapolis. And we basically worked on nuisance livability crimes, narcotics related, alcohol related. And then in 2000, I became a community service officer. I was assigned to the 4th Precinct in the SWAT team. In 2002, I became a police officer, and I worked the 1st Precincts, 2nd Precinct, and 3rd Precinct, mostly 911 response patrol. I did work for 1st Precinct and 3rd Precinct's community response team, which is, I did a lot of ICE work and narcotics-related investigations. And then I did a little time in Violent Offender Task Force, which is known as Safe Streets. That's high felony violent crimes that we worked. In 2012, I was promoted to sergeant, where I worked sex crimes investigations, and then 4th Precinct Patrol Supervisor, and then 1st Precinct Patrol Supervisor, mostly overseeing 911 response, and then our community response teams, and foot patrol. And then I went to the assault unit to do investigations, and then violent criminal investigation team, which was primarily investigating shootings, and then cold case homicide and homicide detective. I was then promoted in December 2019 to the rank of lieutenant. And I should say during that time, I led the SWAT crisis negotiator team for 5 out of the 7 years. When I became a lieutenant, I was assigned to the training division to create leadership and professional development programs for the department. And then I took on the field training officer program. I was promoted to commander of training in April 14th, 2019, where I oversaw the Police Athletic League, Police Explorers, Community Service Officers, the Academy, police academies, the in-service training, overseeing the subject matter experts, the medical support team, range patrol operations, the crisis intervention team, and the use of force team, as well as recruitment, hiring background, the 911 call center, court liaison, and adult and vulnerable homeless population.
Thank you. And as a person who was in command of the training center, are you familiar with the basic curriculum that was offered at that center during the time period you oversaw the operations?
I was.
And were you also familiar with the various staff and components who provided training at that center?
Yes.
Before we get into a more thorough description of the training center, I need to ask if you're familiar with an individual by the name of Derek Chauvin.
I am.
How are you familiar with that person?
We worked on the same shift. We were community service officers together.
Back prior to becoming a police officer?
Correct.
So you've known this person for approximately how long?
Almost 20 years.
Do you recognize Derek Chauvin in the courtroom today?
I do.
Would you please point to him and describe what he's wearing?
I was sitting over there in a navy blue suit.
May the record reflect the witness has identified the defendant.
It will.
So you and the defendant have worked for the Minneapolis Police Department contemporaneously for nearly 20 years?
Correct.
When you came into the police department, did you go through academy training?
I did.
Hey, describe that process.
It was a 16-week police academy that we went through. Everything from, we learned policy, procedure, investigations, defensive tactics, use of force. We did a lot of scenarios at the end that we had to pass. So it was just a wide curriculum of things, report writing, basically anything that pertained to the job.
Okay. And after completing the classroom and practical portion of the academy, when you took it, what was the next step?
Sorry?
What was the next step after completing the practical exercises at the academy and the classroom training?
Oh, so it's a field training program. It's approximately 5 to 6 months long that you would ride with a field training officer.
And then after you completed that, you were able to get your first assignment.
Correct.
Oh, I'd like you to please describe first generally the training center. Where is it located within Minneapolis?
Sure. So it's our training center is a former elementary school that's located on the north side of Minneapolis. And it's just several classrooms that we use for training, as well as auditorium and a gym if we have to do hands-on or practical exercises.
And it was supervised at the commander level, or is supervised at the commander level?
It is.
Can you then describe, currently, or at least at the time, say 2020, when you were overseeing it, how is it staffed, or the different positions at the training center?
So there's multiple units out of the Special Operations Center is the training facility. For training, we had full-time instructors, our use of force instructors, our patrol operations, our medical support team, our civilian support staff. We have 2 civilian support staff members. I don't know if you want me to go through the rank structure, but
I do. How many lieutenants were under you?
At the time, there was 3 lieutenants.
In what areas?
So one oversaw pre-service, so your academies, and then another one oversaw the use of force program and our range. And then the other one oversaw our leadership professional development programs and assessment center type of things. So they each had individual kind of specialty things that they oversaw.
And who was the lieutenant over the defensive tactics training?
At the time was Lieutenant John Mersil.
Sorry?
Lieutenant Johnny Mersil.
What happens during pre-service training now?
So pre-service is our police academies. We have 2 different types of police academies, a recruit and a cadet program. So they will, currently it's changed a little bit since last year, but the time I was a commander, it was 18 and 19 week police academy that they would go through, that they had to pass before they could enter into their field training officer program. So they endure a lot of use of force and defensive tactics. They train on investigations. They do scenarios, de-escalation, crisis intervention, medical, and heavy emphasis on the policy manual and patrol operations.
Okay. And the training that's provided, say, for example, with defensive tactics, is that different in pre-service than the training that's provided during in-service training?
It is not different. It's just longer. They get more of it in the academy.
If you, one moment, Your Honor, if I may.
Okay.
Thank you, Your Honor. Right, and so fair to say that the training that's offered up at the academy, it's just an extended version, a more thorough version of what's offered at in-service.
Correct.
In-service would focus more on classroom training, and there's a curriculum that's been developed by the defensive tactics instructors and teams, is that right?
Yes.
They typically show some kind of a PowerPoint presentation going over the rules and Minneapolis Police Departmental policy, is that right?
Correct.
For in-service. Whereas the academy, they're going to go through that same, some of the same concepts and materials, but in a more extended way.
Yes.
Correct? Now, you've also mentioned a field training program. In order to have the field training program work, you have field training officers, is that right?
Correct.
And sometimes, the field training officers need to be aware of what the people in pre-service are doing as far as what they're learning in defensive tactics, is that right?
Yes.
And so is it true that sometimes field training officers will receive instruction in defensive tactics, for example, just the same as someone in pre-service training?
Correct.
And what is the purpose of making sure that the field training officers are aware of what the training is in pre-service?
So there's consistency of how we grade and how we evaluate recruit officers on the street.
And was the defendant a field training officer?
He was.
Do you know how long he was a field training officer?
I do not know off the top of my head.
Did you select him as a field training officer?
I did.
Now, you've mentioned a variety of different courses that are taken and training that's provided at the Workforce Center. Is it important to keep records of that training?
It's very important.
And why is that?
Because Minnesota Post Board, which is our peace officer standards and training, require us to complete so much training each year. Part of that is the 48 hours of continuing education over the course of 3 years. And with that training has to be annual use of force, weapons qualifications, mental health crises, procedural justice. So a third of that training, 16 hours roughly out of that 48 hours, has to be in compliance with the Minnesota Post Board. And so keeping those records are critical to make sure we can, when we bring them to Post Board, they can do an audit on them.
And you rely on those records in order to, in fact, make these reportings to the Post Board so that you have qualified officers on your staff, is that right?
Correct.
They're kept in the ordinary course of your business, I guess, in the police department?
They are.
This time I'd like to show the witness only, Exhibit 203 for identification. All right, Inspector, can you take a look at Exhibit 203 and I'll ask you to rotate through some of the pages so the witness can examine. You familiar with these records?
I am.
How are you familiar with them?
So these are training records that we track in our workforce director system. We maintain these records. Each officer has to sign in at training, usually in the morning and the afternoon. And then our civilian coordinator will upload these into the officer's file so we can keep track of the training, or if somebody didn't make the training, who needs to make it up. And it's in-service training and any additional training that they had on duty.
And I'd like you to go to the back page to show the last page of the witness. Right, and you see that this particular workforce record goes back to 2003. Why is that?
That's when workforce director started, I believe.
Prior to that, there was some different system?
Just paper system.
And how long are those records retained?
So in workforce director or in our...
How long does MPD retain the training records pre-workforce director?
So the city retains records for 7 years. So once we have them, we'll keep this in our workforce director. Some training syllabuses and itineraries are put on an M drive. Paper copies are generally archived at some point. They're brought down to a central location within the city.
But for 7 years?
Correct.
Okay. So these are the records that we have available for this particular individual, going back to 2003. Is that
Yes.
right? Okay. Is Exhibit 203 the defendant's training records? Exhibit 203, is this the
Yes.
the training records of the defendant?
Yes, it is.
I'll offer Exhibit 203.
203 is received.
Permission to publish. And so I'd like to just, if you could scroll up and highlight this first record entry here. You can see these records are organized in a way that just generally labels the course, and it gives various dates, and then there's a start date and an end date for the participant. Is that right?
Correct.
And then a total number of continuing education credits that are logged. Is that right?
Yes.
Okay. Now I want to back up through these records. If you could bring it out again. If you could slide down, please. All right, so just for example, we can take a look at what's labeled here in the 2019 annual training, that section there. All right, and so you see with these records, it's listed as a 2019 annual in-service training, and it refers to a phase 3. Right. What is the annual in-service training?
So our annual in-service training usually consists of 3 phases of training. The first phase will have 2 days of in-service training for officers, so approximately 14 to 16 hours from January to roughly April. And then phase 2 will roll into our shotgun qualifications or medical training, depending on the curriculum that year, what's in that. And that's usually kind of the beginning of the summer months and the end of the summer months. And then phase 3 is our fall in-service training. And the same thing, it's usually 2 days of different curriculum that we're mandated to do, or that maybe the chief wants us to do, or that we're trying to do professional development courses.
And so regardless of the specific trainer, if an individual from MPD is taking phase 3 2019 annual in-service training, should they be learning the same thing on that particular day as anyone else in MPD taking phase 3 training?
Yes, they should.
If you could zoom out again, go down to 2018 FTO, next page. Oops. Okay, here you see what's marked as a 2018 FTO training program. FTO is Field Training Officer, correct?
Yes.
And so is this a train the trainer program?
Yes, from the FTO coordinator, and myself was the FTO lieutenant at the time, put on that training where we brought in a variety of different instructors to teach at that class.
And what is taught at FTO training?
So that was a almost 40-hour course, and it was a primary emphasis on leadership, the critical decision-making model, effective it's a recruit observation, performance evaluation report, really. So the FTOs are taught the FTO manual, and then they're giving tips on train the adult learner. And we do some scenarios in there where they debrief using the critical decision-making model. They had defensive tactics. They had a component of human resources that came in to explain what the dues and other jobs are as a field training officer. It's basically, we were trying to make sure that they understood what the recruits were being taught, because they're going to evaluate them out there, and they're the closest thing to a supervisor that young recruit officer has.
And if I understood your prior testimony, defensive tactics and use of force is something that's trained every year during the regular in-service, is that right?
Correct.
So, for example, in 2018, the defendant would have been instructed in defensive tactics and proper use of force at least twice, right? Once during this 2018 FTO training program and once during the regular in-service.
Correct.
And if we can, I'd like to at this time, just to the witness, display Exhibit 275. At Exhibit 275, does that appear to be a handwritten records, like a sign-in roster for a particular course?
It is.
The particular course includes patrol ops, and then there's a parenthesis, as taught in the academy, and defensive tactics as taught in the academy. Is that right?
Correct.
And the second name on this list, does that appear to be the name of the defendant?
It is.
Right, and so does Exhibit 275 indicate that the defendant did receive on November 30, 2018, a block of defensive tactics training as taught in the academy?
Yes.
Offer Exhibit 275.
No objection. 275 is received.
Permission to publish? And if you could highlight this portion. And you can see the number of training hours here was 8, is that right?
Correct.
And so that would have been divided between patrol ops and defensive tactics as taught in the academy.
Yes.
And again, the purpose is so that a person can be an effective field training officer and know what the trainees or the cadets and recruits are being taught in pre-service. Is that right?
Yes.
We could go back then to 203. She'll go to the second page, page 2 of 7, and where it says 2018, this one. If you could highlight that, please. Oh. It's up for me. Is it just quicker?
You want to publish?
Oh, I did. I'm sorry. Permission to publish. You highlight that section, please. And just to define some terms here, you see it says 2018 shotgun and CIT training. Is that right?
Yes.
And it's a 7-hour block.
Yes.
Correct. And CIT, what does that stand for?
That is crisis intervention training, so de-escalation and mental health awareness.
You also see there's a training indicated for procedural justice and Narcan training in 2018, correct?
Yes.
And on the crisis intervention training, this one is a fairly short crisis intervention training block, is that right?
Correct. They switched days, so one group would go to qualify with shotguns and the other group would in CIT, and they'd flip-flop after lunch.
But the original crisis intervention training block or model that's taught to MPD officers, it's much longer than 7 hours or even splitting 7 hours. Is that right?
Yes, it's 40 hours, and this is just a refresher.
Okay. And so then if you could move to the next page, please. And highlight that portion. The one above it too, where it starts at CIT 2016. All right. And so here you see on the defendant's training records, it indicates multiple 8-hour blocks of instruction occurring in November of 2016. Is that right?
Yes.
And is that show where the defendant attended paid crisis intervention training in 2016, the approximate 40-hour course?
It does.
In addition to, if you can take that down, please. In addition to the defensive tactics and use of force training, does in-service training require regular medical or kind of combat lifesaver training?
Yes, we generally do a medical component.
Can you just please describe what that training entails?
Sure. So our medical support team consists of a full-time trainer, and they have part-time trainers that are certified EMTs or paramedics. They're also police officers. So they will perform, they'll conduct CPR training, Narcan, tourniquet, chest seals, just life-saving measures, they cover positional asphyxia. Sometimes they cover excited delirium, opioids, things that relate to our job when we respond to a call, so they can better assess the situation when they get there and be able to render first aid.
Now, you mentioned the term positional asphyxia. You're familiar with what that is?
Yes.
What is your understanding of positional asphyxia?
So positional asphyxia is if you're in a position where you're not able to adequately breathe. Something is interfering with your airway.
And if an individual is in a prone handcuffed position, for example, face down, that could inhibit their ability to breathe.
Yes.
And cause positional asphyxia.
Yes.
And what are officers trained to do or supposed to do to prevent positional asphyxia?
They're supposed to put them on the side recovery position, which is they're going from prone and just putting them on their side or upright position.
How soon are they supposed to do that prior to or after getting the person under control in the prone position?
As soon as possible.
How long have you known about the potential dangers of positional asphyxia?
We were taught positional asphyxia all the way back to my academy.
At the Minneapolis Police Department?
Yes.
The dangers of positional asphyxia have been known throughout the department, at least as long as you've been employed there?
Correct.
And your employment overlaps, with the defendants, is that correct?
Yes.
As part of the medical training, do you, in addition to the actual how-to of providing emergency medical care, are officers taught their obligations to provide and render emergency assistance when the circumstances arise?
Yes, it's in policy as well as training.
You're familiar with the Minneapolis critical decision-making model?
I am.
And that model, you've seen the circle, we've all seen the circle now a few times, that model is infused throughout different portions of the training materials at MPD, is that right?
It is.
Why is that?
We wanted to ensure the officers, a lot of experienced officers understand that critical decision-making model. The more experience you have, the more you can walk through it. But we found it critical that recruits learn it early on. It was helping them connect the dots better with information they were receiving on the scene and working through that wheel, constantly reassessing, and then using the pillars of procedural justice in the middle. And so we wanted it consistent with our field training officer program to debrief them, the recruits, and then in our in-service so that officers out there could constantly reassess situations when they're on a scene.
You said that the critical decision-making model was used to reassess people who are going through the FTO process?
Yes, in the field training officer program, we had scenarios where we had the field training officer debrief. At the time, we used community service officers as role players, so we had them debrief using that after a scenario.
So going through the steps of taking in information, assessing risk, assessing threats, reassessing, evaluating goals, and then relating that to the pillars of procedural justice. That's something that any field training officer would be required to do with the people that they're evaluating, correct?
Correct.
In your defensive tactics training, you are not only showing or having officers learn, sort of the nuts and bolts of defensive tactics, but also the rules of engagement. Is that right?
Correct.
And those are contained in the Minneapolis Police Departmental policies. Is that right?
Yes.
And the rules are the rules. They apply to everyone. They apply to you.
Yes.
They apply to recruits. They apply to cadets. They apply to people on field training and experienced officers as well. Is that right?
Correct.
All right. I'd like to show you what's been received as Exhibit 17. To ask you, officer, as you look at Exhibit 17, is this a trained technique that's by the Minneapolis Police Department when you were overseeing the training unit?
It is not.
And why not?
Well, use of force according to policy has to be, consistent with MPD training. And what we train are neck restraints, the conscious and unconscious neck restraint. So per policy, a neck restraint is compressing one or both sides of the neck using an arm or leg. But what we train is using one arm or two arm to do a neck restraint.
And how does this differ?
I don't know what kind of improvised position that is. So that's not what we train.
All right. You can take that down. Thank you. I have no further questions.
You may.
And just want to say thanks again for being here with us on News Now from Fox. Currently, we do have Minneapolis Police Department Inspector Kate Blackwell testifying here in the Derek Chauvin trial as we enter the second week. And just a reminder, sidebars are private conversations. That's why there's no audio. It will resume as soon as they do return to questioning. And there you can see returning to the courtroom are the attorneys from both sides. And again, audio going to be resuming now that the private sidebar is done.
Good afternoon.
Good afternoon, sir.
Just want a few follow-up questions. In terms of any in-service, you see, when we look at the exhibit, you see 2020 defensive tactics in service, and it's worth 8 hours of time. Agreed?
Correct.
Now, in that course of that 8 hours, officers may go through multiple trainings during that 8 hour time, right?
Correct. They rotate through things.
I'm sorry?
They can rotate through different.
Right. So within that 8 hour time frame, they may get a class or an hour-long class on, say, the human factors of force, or they may get an hour-long course on handcuffing techniques. It varies within each of those 8 hour time frames, right?
Correct.
Now, have you maintained a list that shows 2020, these are the classes that occurred during those 8 hours?
We have.
Okay. And have you provided that list to, in response to the search warrant that was executed at the police department?
Yes.
Okay. Now, in terms of the defensive training tactics or any of these continuing education classes, there are other officers that actually train these classes, and multiple officers may appear during that 8 hour time, multiple trainers, right?
Yes, we have part-time trainers.
So there would be maybe one person will teach the human factors of force, someone else may train on crisis intervention, and there'll be multiple instructors, right?
Correct.
But a lot of the instructors will use materials from past instructors, or they'll take combinations of things and they'll just represent it in a slightly different format, right?
At times, yes.
Right. And I just, for the record, I want to ask you, you were served, or the Minneapolis Police Department was served with a search warrant requesting all of the training materials for the four involved officers in this case, right?
Correct.
And so this would be materials that were from the police academy, some materials that were from in service, just a variety of different records, right?
Correct.
Some 30,000 pages, perhaps?
Thousands, yeah.
Okay. I have no further questions.
Any redirect?
No, Your Honor.
Right. Thank you, Inspector. You are excused.
Members of the jury, we're going to take our break for the day. We have a hearing we have to do at 8:30, but I'm still hoping that we can get started by 9:15. So same arrangement as today. Thank you. Just a reminder, don't talk to anybody about the case. Don't read it in the media. Appreciate your patience. Thank you.
All right, guys, just want to say thanks again for being here with us on News Now from Fox as we continue to keep you up to date on the trial of Derek Chauvin. Now, don't forget, we have you covered every single day, gavel to gavel, as we are live in the courtroom in Minneapolis. I do want to, though, continue your coverage here on Fox 9.
Good afternoon. Welcome to Fox 9 special coverage, gavel to gavel coverage of the trial of Derek Chauvin in the death of George Floyd. Just give you a quick update on what happened today. There was testimony this morning, and this is week 2, by the way, of this trial. This morning, some expert testimony continued. A Hennepin County Medical Center doctor who was there when George Floyd was brought in, he testified to what he found with George Floyd's condition when he was brought in. But most of the testimony today really centered around Minneapolis Police Chief Arradondo, and it was some very, very interesting expert testimony based on his oversight of the entire police department. It included, for the most part, an explanation of how officers are trained, what they're trained to do in situations in the field, and something called de-escalation. And there was a lot talked about with several witnesses, expert witnesses today, with de-escalation. Let's bring in our Hannah Flood, who has watched this with us all day long. She continues to watch it, as we did today as well. Hannah, I was struck by how much they asked Chief Arradondo about the specifics and the nuances of police training and the aspect of de-escalation, which much will be talked about in this case. Bring us up to speed.
Yeah, I thought so too, Randy. And this is something I was talking to a defense lawyer yesterday that she said we should kind of expect when we're bringing in some of these now expert witnesses, right? They're going to take a lot of time to, you know, in Chief Arradondo's case, establish his credentials. They talked a lot about his work history, when he joined the force, when he climbed the ranks, how he climbed the ranks, what each officer in different ranks, what their responsibilities are, what their positions are. And then we got into a lot of policy, talking about you have a policy about this. They even was a point where Steve Slisher for the state brought up a policy about police officers knowing police department policies. So kind of slow there, a lot of kind of paperwork and definitions and even some diagrams, some training diagrams brought in to kind of just help the jury lay the foundation of here's who Chief Arradondo is, in case you don't know him, here's what his credentials are, and then basically this is what officers are taught, this is what their training looks like, how often their training comes up, how different ranking members of the police department have different responsibilities and oversight. So that went on for quite a while with Chief Arradondo. And then we got into a point where it kind of took a turn, and Steve Slisher says, okay, so based on everything we're talking about, now we know these policies about use of force. Now we're up to date on these policies about de-escalation. How do you think that relates to what you saw in the videos with Derek Chauvin? And here is what the chief had to say about that.
Sir, based upon your review of all of the information that you just mentioned, do you believe that the defendant followed departmental policy 5-304 regarding de-escalation?
I absolutely do not agree with that.
And how so?
That action is not de-escalation. And when we talk about the framework of our sanctity of life, and when we talk about the principles and values that we have, that action goes contrary to what we're taught.
So there you heard the chief kind of give his opinion in a way of what he saw and how that relates to policies. I want to be really clear that the chief is very limited of what he can say. And in fact, this morning during some motions, there was really detailed discussion about how far the chief can go when talking about his opinion, talking about things that he saw. Basically, Judge Cahill has ruled no one can just get up there and start spewing off their opinion of this is what I would do. It's more of like, here's what our policies are, and here's how that relates to the action that we saw. So we actually have a soundbite from Judge Cahill talking about the limits that officers will have when giving testimony on the stand.
My analysis of this is, we have said Mr. Floyd's state of mind is not relevant. It's the defendant's state of mind, his knowledge and his intent. And part of his knowledge is based on training he's received. So a summary of the crisis intervention training he has received is appropriate. We're not getting into, I suppressed the psychiatrist's testimony about what was Mr. Floyd's, was that truly anxiety or whatever. I'm not gonna let a trainer say, look at the video and give those kind of answers. But evidence regarding what Mr. Chauvin knew, what he had been trained on, which goes to intent and knowledge on the May 25th, 2020, are all relevant and would be allowed.
So there you can hear Judge Cahill kind of laying out the rules again of what officers will be able to talk about. So you heard in that soundbite with Chief Arradondo saying, based on our policies, based on our de-escalation training, I thought that this was appropriate or not appropriate. So just kind of interesting as you're watching this to know that witnesses on the stand, they're not always able to say exactly what they're thinking or exactly what they would say in a normal conversation, but are kind of confined to some of these rules. So then, of course, it's cross-examination time. It's time for the defense to be able to come up and ask some questions to Chief Arradondo. And kind of a lot of the same when Eric Nelson was questioning the chief. He was kind of getting to the point of these policies look great on paper, but police officers have a complicated job and they're not always able to exactly execute policy exactly as it looks on paper. Of course, there's a lot of gray areas for police officers in that they end up in dangerous situations and can sometimes bend policy or policies change based on a level of threat. So after going through all of that, Eric Nelson then brought up a side-by-side video, and it was Officer King's body camera side-by-side with that bystander video. And what he did there is he was asking Chief Arradondo to watch about 10 seconds of that video just before George Floyd was put on a gurney and taken away by paramedics. So he showed about 10 seconds of this video and then asked Chief Arradondo about what he saw.
Would you agree that from the perspective of Officer King's body camera, it appears that Officer Chauvin's knee was more on Mr. Floyd's shoulder blade?
Yes.
There was kind of a mic drop moment. After that, Eric Nelson stepped down and sent questioning back over to the state, who can then redirect and ask more questions. And basically in that portion, Steve Slisher, the attorney for the state, got up there and was talking to Chief Arradondo, and they basically went over, the chief said, for that 10 seconds, it appeared that Derek Chauvin's knee was on that shoulder blade. He said that was not necessarily the case the entire 9.5 minutes of that encounter, but he did say in that last 10 seconds or so, it looked like the knee was closer to the shoulder blade. But then the chief goes on to say, even at that time, he wasn't even sure if George Floyd was alive. Remember, when paramedics first came over and checked for a pulse, they couldn't find one. It wasn't until a few moments later that Derek Chauvin actually got up and George Floyd was put on the gurney, kind of suggesting there that even in that case, the use of force might not have been appropriate. The threat might not have risen to the level where Derek Chauvin would even need to have his knee on the back of George Floyd's shoulder or anywhere.
And Hannah, to your point there on cross with Eric Nelson, he was really hitting on the nuances of what an officer can and cannot do in any individual circumstance in the field. In other words, he asked, as you heard, he asked the chief, are there variances in applying MPD policy in the field when, life kicks in, for example? And they asked very specifically about those nuances. At one point, he said, is reasonable force should be from the perspective of the officer, at which Chief Arradondo said yes, because they spent all that time, as you point out, talking about what reasonable force is and what de-escalation is. And then he said things on the scene can change. Agree. Those were Eric Nelson's words, and Arradondo said yes. So to your point, what he was trying to establish there after a lengthy testimony from the prosecution standpoint about policy and was policy followed, and Chief Arradondo, as we heard, said no in many cases. In fact, there was a couple points there. At one time he said, is this form of restraint a violation of department policy? Of course, we're talking about the knee on the neck and the shot, and he showed Arradondo the very iconic image of George Floyd with Derek Chauvin's knee, and he said it is not. And then he said, is the form of restraint a violation of department policy? He said it is. And then he said, is this a trained use of force on the MPD? And Arradondo said, it is absolutely not. It is not what we teach and cannot be condoned. And to that point, I want you to elaborate on this. At one point, Hannah, the police chief was asked about the public's image of the MPD and the use of force. And the question was, how are you viewed when you use force in the field? And Chief Arradondo said, we deploy it with diligence. And these were his words. He said, of all the things that we do, it is my belief the one thing we are well judged on is our use of force. We want our officers and members of the public to go home each and every night. That was a very powerful statement, and it was one that, as chief, with his purview of the whole department, it sort of summarized where this testimony went today from the chief.
Yeah, I thought that was interesting too, Randy. He said, something like, they were talking about all of the calls that they get called out to, tens of thousands, maybe even hundreds of thousands of calls. And he said, when you're in a situation, when you're facing the public and interacting with the public, a lot of times people, when they're dealing with MPD, it might be the only time they have ever dealt with or will deal with MPD. And he says, you can't explain to that person, well, on my last 99 calls, everything went really great. For a person in this situation, that instance that they're dealing with is the most important. Basically kind of saying that these policies, their values, these are everyday, every situation things that they take very seriously. And, to your point of them breaking down all of these different policies, Randy, there was even a point where Steve Slisher asked, what about the medical condition? Did you think that George Floyd was in medical distress? The chief said yes. And they said, basically the question was, were the officers supposed to render medical help? And Arradondo said yes, even that went against their policies. So they went over several policies in the beginning. That was kind of the drier, slower part of the testimony today. And then in the end, took all of those policies and kind of went through and let the chief explain where he thought those violations were happening.
And I want you to hang on for just a minute. I want to, for our viewers, briefly summarize as quickly as I can, and then I want to go to Paul Bloom, who clearly is covering this from the perspective of in the court. But essentially, there was an awful lot of time today spent on policy, police policy, MPD training. And whether or not the defendant violated that training, whether or not that defendant violated his obligation to the public, and in this case, his obligation to George Floyd. And then on cross from the defense, there was a lot of time, not as much, but quite a bit of time on the nuances of those policies. And essentially, can an officer in the field, under the circumstances that he is seeing right now, adjust that policy? And so there was testimony, expert testimony on both sides of that coin. Paul Bloom, as I said, has been watching this from the courthouse area and the media area where we can watch it very closely. He joins us now. Paul, if you could, in the limited amount of time we have, because your perspective is so unique on this, give us a sense for what you viewed as the most dramatic sort of testimony of the day from Arradondo from the prosecution standpoint, and then on the flip side, sort of the retort from the defense in cross.
Well, I certainly think you and Hannah are hitting on the key points. The one thing I would just stress here is this emphasis. And, clearly Chief Madera Arradondo thinks big picture. He's a thoughtful leader, first black police chief in the city of Minneapolis. And his respect and reliance on the sanctity of life and the violation that he saw in that scene at 38th in Chicago. He could not talk about kind of his deep down beliefs, his knee-jerk decision to fire those officers. Chief Madera Arradondo publicly called what happened at 38th in Chicago murder. If you listened and didn't know that Chief Arradondo had previously said that, you would have really no idea if you had just watched our court hearing, the proceedings today, because he's just not allowed to give a legal opinion on the matter. And of course, some people would argue, certainly the defense would, that the firings so quickly were more political. And his return to the city's motto, the police department's motto, to protect with courage, to serve with compassion. And he just felt deep down inside, and you could see it in his heart, that Derek Chauvin just did not live up to that oath. He just did not. And, he went down as he could, use of force, duty to provide medical care, a de-escalation, failure. Now, those aren't criminal offenses. Those are department violations. But I think you saw a chief speaking from the heart there. Obviously, this jury is going to recognize the face, the position of Madera Arradondo in this community. So I think his words matter. And to that point Hannah made about the 10-second video clip, yeah, it showed some sort of, what would you call it, bystander, what do you call it, kind of camera perspective. situation, biasy really, and that there were 10 seconds where it appeared Derek Chauvin's knee wasn't quite on the neck, it was on the shoulder blade, but I certainly thought as soon as the state got back in there, Steve Schlisser clarifying that throughout the 9 minutes and 29 seconds that the knee was on the neck and not just on the shoulder blade, I thought the state sort of stemmed that argument from the defense. But again, powerful testimony. It was drawn out. How much the jury takes away, question mark. But again, I think that we can't understate the value of seeing the police chief there just feet away from his former employee, describing how he felt Derek Chauvin violated the oath and the sanctity of serving on the Minneapolis Police Department.
Hey, Paul, I know she pulled your IFB out, but I want to make sure you can hear me before I ask another question. Is the answer to that yes? You can hear me?
Yes,
okay.
yeah, I just had some audio distraction
Hey,
in my
I want to
ear.
ask you, we've seen so much video, and we've seen it for months now. Clearly, Chief Arradondo has viewed every piece of video there is for his testimony today as well. But there was one point today where he was asked about the video and his initial response to the video, and this was on the night of the incident, fairly early on, by the way, in that night. He said, I viewed the city camera, which he knew would be somewhere in close proximity to 38th and Chicago. I viewed that camera from what is a distance, and he could only see the back of those officers. And at that point, nothing really jumped out at him, he said. Later that night, he was asked to view a bystander video, which is the famous video that we all know and have seen so many times now. And he said, and please elaborate on this, he said, that struck me as different. Explain.
Yeah, I thought that was very interesting, putting the jury and the court in that moment after the news of what happened 38th in Chicago was sort of developing. He takes an initial call he thought was from the deputy chief. He's at home. It's Memorial Day, the nighttime. There's word that a subject taken into custody may not make it, may not survive at the hospital. So the chief's on notice. He goes into City Hall to view, as you mentioned, the milestone camera. The chief, knowing the city as well as he does, knows that there's that aerial camera kind of above the Speedway gas station that the prosecution has used to sort of look down on the scene throughout. He described, everybody looking really small. I mean, he saw the squad car shake and some activity with Floyd, and certainly would have seen the 10 to 12 minutes the whole process would have taken outside of Squad 320. But then around midnight, he takes a call. He just described it as a member of the community, a resident, who said, you got to see this other video that's circulating. And by now, the public had circulated and seen it. I remember as this story was developing, it's Darnella Fraser's Facebook video. And what was so powerful about that is, remember, now we've seen every angle, left, right, before, after. But that video really, when you put it in the context of, you see just George Floyd's head, neck, shoulder area, and you just see Officer Chauvin kneeling on him at the time. You hear, that's the original, George Floyd crying out for help, crying out for his mother. He can't breathe. His stomach hurts. And there's no other video available other than that aerial at that point for the bird's eye view for Chief Arradondo to consider. But in that, I mean, you think about when the first time you saw, or we all saw that video. It is powerful. It is anguish. It is visceral. It hurts. And Chief Arradondo put himself in that moment, and it would just be hours later till his decision to fire all 4 officers on the scene in that moment. But yeah, as soon as his attention was drawn to that, he knew this was something different that he was dealing with.
Absolutely. That was his testimony, no doubt about it. Paul, thank you. I know you're sticking around for our later newscast, so thank you for your perspective. We want to go now to our legal expert. One of our several legal experts, Christa Groshek, is standing by via Zoom for us. She's watched the testimony of today as well. Again, it was expert testimony today and not so much the eyewitness on the scene testimony that we've seen the first week in this week too. Do we have Christa on the phone yet or on Zoom yet? There you are. Christa, is it safe to say that most of what happened today and most of the testimony today was to establish whether or not Derek Chauvin violated MPD policy by his actions that day, and then on cross, whether or not there are nuances on how an officer can impart his actions per policy, and can he vary from those in an incident like that?
I think that's exactly what we saw unfold. What the state is trying to do, as you know, is indicate that what Derek Chauvin did was absolutely against policy, training, and protocol, and no amount of improvisation can excuse what he chose to do at the time. The reason why this is important to the defense is they want to show that Chauvin's intent was simply to carry out the duties of his job, and he was acting in accordance with his training. So this testimony, or this piece to the puzzle, is important for that purpose. But as you know, some of the witnesses now are going to start talking about causation, and that really truly is the centerpiece of the trial.
And also, Christa, do you think, and again, this is your sort of evaluation of what unfolded today, we saw an awful lot from the prosecution on establishing, as you point out, whether policy was followed or not, MPD policy, or even policies that an officer might have been trained on outside the purview of the Minneapolis Police Department. But also on cross, Eric Nelson tried. Did he succeed in giving any type of leeway to that policy for Derek Chauvin because of the circumstances of that given moment on that given day?
What I've seen from what happened in the courtroom today, and unfortunately, I've been having to catch up vis-a-vis the news because I was involved in my own court hearings, but what I've seen is that Nelson attempted to say, look, there is this policy that allows for use of restraint on the neck. The question is when you can use it, how long you can use it, and then there's these competing sort of broader policies about de-escalating people and making sure when there's no resistance that we move into a different action and we start dealing with a person in a different way, consistent with maybe how their behavior is after they've escalated and come down. So for sure, there is policy in print on point that says that this controversial neck restraint can be used. The question is when, and the reason why digging into that minutia is important for the defense is it goes again to their desire to show that Mr. Chauvin was just trying to do his job under a difficult set of circumstances.
And it seems to the casual viewer, and I'm speaking for our viewers now who watch this, may watch it on and off all day, that part of this establishment from the prosecution is whether there was enough time during those, what we now know as 9 minutes, for Officer Derek Chauvin to make different decisions. Was there time for him to release his hold on Mr. Floyd? Was there time for an officer to administer some sort of medical care within the bounds of their training before EMTs arrived there? And if so, what might that have been based on the training that officers go through? Is that a fair assessment of what we saw?
Absolutely, I think it is. And to be blunt, you know, that's clearly the biggest hurdle for the defense, is that in some other cases that have come before Mr. Chauvin's, we've got very short or very limited encounters where split-second decisions have been made. In this case, there's a longer period of time. What we also saw Mr. Nelson doing in defense of Mr. Chauvin is he was again bringing back that crowd element, that the crowd was, you know, engaged and, you know, concerned. You know, Mr. Nelson has articulated that they appeared angry and that caused the officers to be distracted from the work that they had to do. And maybe, in fact, they could have pivoted to some different tactics, but had difficulty doing so with the crowd that they were surrounded by.
Well, Christa,
All right, guys. I just want to say thanks again for being here with us on News Now from Fox. Christy Larson here at the desk with you. And we want to continue talking about the latest on day number 6. We're now entering the second week of the Derek Chauvin trial. And I am joined live with our own legal expert. We have Ben Taylor here joining us. And Ben, let's just kind of jump into your thoughts on today. You know, last week we had a lot of witnesses who were on stand, you know, giving us a little bit of their own feedback on what they saw. But now here today, it seems like we had a lot more experts and, of course, people wearing uniforms taking the stand here today.
Yes, you had a lot of expert witnesses talking about police use of force, police tactics, and the prosecutor, what they want to do is try to explain to the jury that these are what Minneapolis Police Department officers are trained to do, and this is what Derek Chauvin did not do. So that's why you see the prosecutor asking all these witnesses to testify in regards to training and experience. You see Eric Nelson, the defense attorney, cross-examining, and one key point today was the fact that he showed a picture of Derek Chauvin's knee on the shoulder and not on the neck. So what he's trying to establish there, the defense, is that maybe the knee didn't really kill him, and going back to the drugs. So when you see the defense, when he does his case, you're gonna see Eric Nelson talk about drugs when he has a time. Everybody has to remember, no matter what the video says, Derek Chauvin is still innocent until proven otherwise or proven guilty. And that's what the prosecutor is trying to do with all these witnesses. But as we all remain throughout this trial, he's still innocent until proven towards the end of the trial if he is found guilty or not guilty.
Right, and that's, a point that we've emphasized before. So let's kind of talk about that, because obviously with the Minneapolis police sitting there on the stand, he has to really take his own personal opinions and everything else that's still going on in Minneapolis, put that aside and really just answer directly and honestly these questions that he's being asked. He can't be putting his own opinion into this.
Yes, so before the trial, you see the attorneys argue about what evidence goes into courtroom and what evidence does not. And the judge there is a referee. And the judge was telling the witnesses they can't testify to the ultimate opinion. Only an expert witness like a doctor can testify to whether or not the knee to the neck killed George Floyd or was it drugs. So that's why you're going to see more doctors in the future testify to that. But as far as the police chief was able to testify to police tactics, what they know, but you want to still have a fair trial. No matter what people believe, no matter what people have seen on TV, ultimately our Constitution protects the rights of the accused, no matter what opinion a person has. So that's why you have the judge limiting certain testimony, because the police chief is a very powerful person. The jurors know the police chief. They live in the city of Minneapolis. They see the police chief on TV. So that's a very powerful witness there that you want to make sure that the chief testifies to the facts of the case, but doesn't give an ultimate opinion in regards to how George Floyd died that day.
Right. And, one of the things that will really be interesting is once the defense team really starts to bring in their own witnesses. So let's talk about that. Who do you expect to see called to the stand once that time finally comes? Because this could be another couple of weeks as far as how long this trial goes.
Yes, if I'm Eric Nelson, defense attorney, I'm calling in my own police tactics and police use of force expert. I'm calling in an expert who can testify to maybe what Derek Chauvin did was within policy, or you don't understand how it is on the streets. That's what he was trying to do today, is that even though you have all these tactics and everything, if in some circumstances you have to use your judgment, and this was his judgment to do this, then maybe what he did was correct. That's what kind of person you would want to do, is calling your own use of force expert. And the main key witness you're going to want to call in is a doctor who can testify whether or not the amount of drugs in George Floyd's system caused the death of George Floyd. So that's what you're going to see in the future when the defense attorney gets a chance to call his witnesses. Right now, the state is the state's case. So the state always has the burden of proof. That's why they go first. Under our law, it's beyond a reasonable doubt. So they have to prove beyond a reasonable doubt that George Floyd was killed by Derek Chauvin. The defense attorney, you might see him asking a few questions, might not see him asking a lot of questions. However, what the defense attorney is trying to do is prove doubt. He has an uphill battle because it's been on national news. People have seen this video. He has an uphill battle with the defense attorney, but what he's trying to do with his questioning is to prove some doubt in the minds of the jurors so that at the end of the day, they might have a chance to vote not guilty.
And I like that you pointed that out too, that, they're going to have their own experts come in, because it really did seem like today they emphasized a lot on what are the policies in place, what commitment do they make when they take that oath of, I'm going to put on a uniform every day and go out there to protect and serve and, provide people with the kind of care that they would want us to have also with those people in blue out there on the streets.
Yes, so that's what people are seeing right now. The prosecutor, they're having their chance to testify and bring their witnesses, but the defense attorney will have their chance to put on their witnesses the next coming weeks, and you'll see it back and forth. And eventually the jury will get the decision and to decide, go back in the jury room and talk about all this evidence, rehash it. And the jurors are tired. I mean, doing trials like this, doing all-day trials, doing it 5 days a week, the jurors are tired and have a lot of evidence to go over, to take notes over. But we always have to remember, no matter how people feel about Derek Chauvin, no matter how people view the video, of course, is a powerful video. People see it, but as I explained earlier too, is that these cases take over a year. That's why it takes over a year to get to trial, because you have so much evidence. And ultimately, Derek Chauvin is innocent until proven otherwise, based upon all this evidence that we're hearing throughout these weeks.
Yeah, and it will be interesting, as we said, as this trial continues on into these next few weeks, who else is going to take that stand, if they're going to also testify if he, broke those policies and really, took that oath and didn't obey it.
Yes, the prosecutor is going to hammer in every day with different police officers, because the police officers you see, they're coming in there wearing their badges, wearing their uniforms, and those are powerful witnesses because they're in uniform, they're authority figures, and jurors tend to want to believe authority figures. So the prosecutor is going to hammer in that Derek Chauvin killed George Floyd because of the knee to his neck, and that he didn't use the proper procedure, and he didn't follow policy. He didn't follow the rules of the police department. And that's what you're going to see from the defense and from the prosecutor, but the defense is going to try to poke holes in there and say, you heard last week, you tried to say that the crowd was unruly. You tried to say that Derek Chauvin was under a lot of stress, a lot of pressure, and he had to do what he had to do. It's like I said before, it's a strong uphill battle. As a defense attorney, you dance with the girl who brought you to the dance, and this is what facts that he has, and he has to go in there with these facts, even though the facts are strong against him, but he has to fight his case and see what happens at the end of the day.
Yeah, and of course, we're going to continue to have people covered, continue to have those conversations with you. So thank you for helping kind of break down today's trial with us, Ben Taylor.
No, thank you for having me.
And don't forget, we always do have you covered here on News Now from Fox, gavel to gavel. And while we were in the trial a little bit earlier here today, we did also get an update from security and law enforcement in Minneapolis. Now, again, there's been a lot of concern as to what kind of people are going to step out and protest and as activists in the city of Minneapolis as this trial continues on. And as we just mentioned, it could take a few weeks in the city of Minneapolis. So let's go listen into the latest security update with Minneapolis officials.
I'm John Harrington. I'm the commissioner of the Minnesota Department of Public Safety. As you probably all know, Chief Arradondo is still testifying at court, and so I'm going to sort of MC or at least kick off this press briefing on OSN today. First of all, I want to note that over the weekend we have seen no arrests made around the free speech area. We have seen protests, including a rather robust rally over at 38th in Chicago, but no arrests, no fires, and no damage to property has been noted over the course of this weekend. And while we are continuing to track rallies and protests, nothing that we are seeing indicates that there is an imminent threat to the court proceedings or to either of the Twin Cities. Having said that, you well have noticed, especially on the St. Paul side of the equation, that a new fence has gone up around the Minnesota State Capitol, and that there is fencing now around the St. Paul Police Headquarters and also their East and West districts. Those fencing operations have been done much as we did in Minneapolis, both out of an abundance of caution, but also as a recognition that with the fencing securing these properties, it requires less police personnel to be on guard and to be on duty, allowing more officers to be available, to be responsive to the needs of the community, to answer 911 calls, and also to be there to facilitate the First Amendment rights that are the #1 mission of Operation Safety Net. I will also note, before I turn this over to Assistant Chief Halverson, that we are seeing healing circles. I've heard a lot from community Last weekend with Passover and Easter, I heard a lot from the religious community in particular about the trauma that seeing and hearing about the death of George Floyd has caused for the community. And I wanted to note that all over the Twin Cities area, there are healing circles and opportunities for that. There's one tonight, for example, from, I believe, 6 p.m. to 8 p.m. over at the Arradondo Library in St. Paul. But we can get you more information about that if folks are interested. But we do want folks to be taking care of themselves. We know that the images that you see and the testimony about how George Floyd died is disturbing and is re-traumatizing many people, and so the healing circles that have been sponsored by the cities, communities, and religious organizations, I think, are really very important steps in making sure that the community is both not just safe, which is Operation Safety Net's purpose, but also well. And with that, I'll turn it over to Assistant Chief Halverson of the Minneapolis Police Department.
Thank you, Commissioner Harrington. I appreciate that. Good afternoon, and thank you for being here. I'm happy to report that at this time, we do not have any arrests, as Commissioner Harrington said, or substantial damage to property to report in regards to protests to this trial. As we move forward into this week, we will continue the same cadence with staffing. We continue to monitor all areas of the city and continue to be responsive to the needs of all communities. We'll be using our staff along with our OSN partners to ensure that the mission is met. We have done extensive outreach with the business community throughout the city and largely downtown to ensure that their needs are met. We value and appreciate their continued support and partnership as we move through this time. Additionally, we continue to work with our professional sports teams to ensure they are able to hold their games in a safe manner. At this time, I will call up Chief Deputy Tracy Martin of the Hennepin County Sheriff's Office.
Thank you, Chief Halverson. So the first week of testimony in the trial went as we anticipated. We heard emotional testimony in the courtroom. We saw some increased demonstrations out on the plaza, and our deputies were prepared and professional. As Sheriff Hutchinson has said each week, we continue to ask for the public's help to keep the process inside and outside of the courtroom running smoothly. We're asking that everyone remains patient and peaceful. Please keep in mind that the number of positive cases of COVID are on the uptick. We're asking people to please remember to wear a mask and social distance. The trial is on schedule, and if we want justice to be served in a timely manner, we need to keep it that way. We're asking everyone each week to let our deputies do their job so the court can do theirs. Thank you. I'm going to call on Colonel Langer from the State Patrol. Thank you.
Thank you, Chief Martin. Just a few things today to update people from the perspective of the State Patrol and the operational side of things with Unified Command. Number one is I'll continue to be repetitively optimistic or optimistically repetitive that we're thankful for all of the peaceful protests, the demonstrations that have occurred thus far. We'd like to see it continue exactly the way it has been happening. Secondly, there's been a variety of planning endeavors that continue to happen each day and each week. Some of these include tabletop exercises between the State Patrol, the Department of Natural Resources, the St. Paul Police Department, the Ramsey County Sheriff's Office, the Hennepin County Sheriff's Office, the Minnesota National Guard, and many other entities coming together and drilling, contemplating, planning for various events, everything from an active shooter situation to a severe weather event during a large demonstration. We believe that those are really important pieces of the planning process to make us better prepared in the event that any of those things happen, and we hope that they don't. Last but not least, one of the questions that we get once in a while is when will we start seeing additional state troopers in and around the city of Minneapolis or St. Paul or around the Capitol? And the answer to that question is even though we're ready and we're poised across the state of Minnesota, you'll see additional troopers when we believe it to be necessary. and not before that point. And I think I'll turn it back over to the commissioner who will answer or lead us through answering any questions that anyone might have.
Thank you, Colonel. And yes, we're going to be open to questions, whether we have answers for them or not. But at this time, we'll open to questions. Stephen? So the question is did the fence that's going up around the Capitol replace, or was it in addition to? And it is a replacement fence. It has got the exact same footprint as the previous fence did. That fence was put up rather hastily in May of last year, and we recognized that structurally we could do a better job, as that fence has. It's now almost a year old, and we wanted to make sure that we had a safe and secure fencing area. So it is not any larger than the original fence area, though. So the question is this fence more likely to be permanent? And the answer is no. I will tell you, and I heard the Colonel say the same thing as we have testified before the Lieutenant Governor's Committee on Capitol Security, that we think the fence is ugly. We frankly like the environment of having a non-fenced people's house. But in the wake of threats to burn it down or to tear it up or to do other damage at the Minnesota State Capitol, we put the fence up. We continue to work with the Department of Admin, assessing threats on a monthly basis. And once we no longer have any threats, we will then make that recommendation, and we hope to see the fence come down as soon as possible. Going once, going twice.
Thank you very much, everybody.
Thanks much.
Hello, everybody. Happy Monday. We have been following the Derek Chauvin trial the second week so far all of this week, and we'll continue to do that every single day, showing you from the very beginning to the end with expert analysis, legal analysis, and live reporting out in the field. We'll be talking to Paul Bloom, Fox 9's Paul Bloom, in just about 15 minutes or so, asking him what his biggest takeaways are, but also talking about some of those other topics we haven't hit yet, like this. This is a tweet that he posted showing some video of buildings that are boarding up around the county in advance of possible unrest in the downtown area. He said, quote, "My understanding is we are still likely talking about 2 more weeks of witness testimony before closings and deliberations." He is the reporter who is down on the ground covering all of this, so it'll be interesting. I'll be asking